Court of Survey.
ಹಲೋ. ಹಾ ಗೌಡ. ಅದ್ರಲ್ಲಿ ರಿಟರ್ನ್ ಅಡ್ಮಿಟ್ ಕಳ್ಸಿದ್ರಿ 326 ಅಲ್ಲಿ ಒಂದು ಸೈಟೇಷನ್ ರೆಫರ್ ಮಾಡಿದೀನಿ. ಆ ಸೈಟೇಷನ್ ಆಮೇಲೆ ಕೊಡ್ಕೊಂಡು ರೆಫರ್ ಮಾಡಿದೀನಿ ಕರ್ನಾಟಕದ್ದು.
Court of Survey.
PDF ಅಲ್ಲಿ ಕಳ್ಸಕ್ ಆಗಲ್ಲ ಹೆಂಗ್ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಹೇಳಿ ಸರ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಒಂದ್ ಬೇಕಾದ್ರೆ ILR 2000 ಕರ್ನಾಟಕ. ಹಲೋ
ಸರ್ ನಿಮ್ ಕೊಲಿಗೆ ಯಾರು ಇರಲ್ಲ ಸರ್ ಇಲ್ಲಿ?
ಇಲ್ಲ, ನಾನು ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಅನಾನುಕೂಲತೆ ಇದೆ, ಹಿಂಗಾಗಿ
ಹೇಳಿ ಹೇಳಿ.
ILR 2007 ಕರ್ನಾಟಕ.
ಹಾ,
ಶಾಂತವೀರಪ್ಪ ವರ್ಸಸ್ KN ಜನಾರ್ದನಾಚಾರಿ.
ಇದು ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
ಪೇಜ್ ನಂಬರ್ 1127.
ಓಕೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 13.
30.
ಓಕೆ ಓಕೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. 16 2016 connected 21 45. 160. 322. 55. ಮಾಡಿದೆ ಇದೆ ದೂರ ಇಟ್ಕೊಂಡು ಇದು ಹೋಯ್ತು ಹುಡುಕ್ತಾ ಇದ್ದೀವಿ ಇದು ಒಂದಿನ 40. Two. 806. 72. 701. Class 3. 34. 15. What is happened?
One of the respondents name is
Monday.
Application has been allowed
Hmm.
and the paint has been rejected. Was in possession of the property till date of possession of the
Fresh matter.
fresh matter.
Fresh matter, give that memory.
Possession of the property.
Want to withdraw that and next week.
Page wise adjournment, list number 1, page number 1, serial number 1 to 7.
Yes.
Mahendra Gowda CR for appellant.
Request of counsel for the appellant. 2 weeks time is granted to complete it. Yes.
Page number 2,
6. So the request of counsel for the appellant. 2 weeks time is granted to complete. 1 week. Yes.
page number 2, serial number 8 to 17.
13.
Venugopala for appellant.
The request of counsel for the appellant. Weeks time is granted to complete. Serial number
16.
16.
Refer 2 weeks accommodation.
The request of counsel for the appellant.
ನಾನು
2
apply
weeks
ಮಾಡ್ಬಿಟ್ಟು-
time is granted to complete.
Shobha Shivramesh.
17, you are appearing for appellant. The request of counsel for the appellant. Weeks time is granted to complete. 8.
Page number
11.
Serial number 11. Yes.
Ramadan.
2 weeks time is granted to complete.
Page number 3, serial number 18 to 21. 18 Mohammed Usman Said.
Yes, weeks time at the request. Yes.
Page number 4, serial number 22 to 24. Page number 5, serial number 25 to 28. 28A Madhusudan Rao for appellant, Vivekananda TP.
Only week's time may be granted, ma'am. To
At
taking
the
steps,
request
like
of appellant, week's time is granted to do the needful.
paperwork 3 weeks time.
ಎಲ್ಲಿದೆ?
The paper, non-file item.
Yes, 3 weeks to file paper book. Week's time is to pay the process.
Page number 6.
It's at the request. 9th time. Why? ಏನ್ ಸಬ್ಮಿಷನ್ ಇದೆ 9 then no. Yes. At the request, finally, week's time is granted to comply of subject.
Page number 8, serial number 34 to 37. Page number 9, serial number 38 to 42. Page number 10, serial number 43 to 49. Page number 11, serial number 50 to 57.
Serial number 53, my lord. Kindly have day after tomorrow, my lord.
We are not respondent, my lord. Fourth time, my lord.
Yeah,
And
thank you.
again, last Monday also it time.
Only for, I'm ready, my lord, but only I have to secure some judgments. Pressure of work, I couldn't lay my hands. ನಾನು ಜಾಸ್ತಿ ಕೆಲಸ ಇಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
Yes, I know, because for, before me also he has asked for me.
This is the fourth time.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
See,
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ರೆಡಿ ಮಾಡಿ ಬಟ್
lawyers has to argue the case and leave it to that.
only I have to secure some judgments, my lord. Because of pressure of work, I couldn't lay my hands.
They have to
Day after tomorrow.
request of counsel for the appellant. It is this matter day after tomorrow.
Interim.
Granted earlier is extended till next date appeal.
Serial number 57, madam. I seek a week's account. I appear for respondent, madam.
Federal Vacancy, Kensapur.
Yes, at the request of counsel for the respondent, leave this matter next week.
Much obliged.
56, Rashita DJ for appellant, LS Venkata Krishna.
Request of counsel for the appellant, leave this matter up to 2 weeks. Yes.
50,000. Page number 12, serial number 58 to 62.
58. Yes.
58, B.B. Shivakumar for appellant, A. Madhusudan Rao.
Yes. Yes, at the request of counsel for the appellant, leave this matter next week. 57. What do you want? For a second time, somebody has mentioned and taken time. Next week means 22nd or 23rd. 23rd. 22nd. Yes.
My lord, serial number 60, my lord.
Serial number
From appellant side.
Shiva Prakash for appellant, Usman P.
The request of counsel for the, you are for the appellant. Request of appellant, leave this matter next week.
Page number 13, serial number 63 to 68. Page number 14, serial number 69 and 70. Page number 14.
69, yes.
69, Sridhar BK for appellant, connected with Ramesh Chandra.
Lord,
69, huh? Yes, Mr. Who is appearing for 69? Yes, there is an objection. He is the opposite side. Yes. He has an objection. Yes, you have no objection. Yes, Mr. Yes, learned counsel at the request of learned counsel for the appellant. Is this matter 2 weeks and 27? 27. Yes.
How let's ready for appellant, Raghu Prasad PS.
No matter is the hearing length. When do you want? The request of counsel for the appellant. Is this matter of 2 weeks. Date 28. 6.
Peter Ramarao, DC for appellant, MD Raghunath.
Request of counsel for the respondent. Please next 1 week. Yes, leave this matter next week. 9 I will call out. Wait, yes.
PM Venkata Reddy. Serial number 20, TM Venkata Reddy for appellant, connected matter.
This for orders, let us see, yes, in the matter is released. Wait.
Sir, serial number 1, Harish N for appellant.
230, pass out 230,
Serial number 2, Channapasappa, SN for appellant.
same 230. pass
Serial
out.
number 3, K. Mohan Kumar, RP Sadashivappa.
Yes, pass over 1 round.
Number 4, TM
Pass over.
non-compliance of participation, first time matter, CH Dwarakanath for appellant.
Yes, Dwaraknath. Pass over.
Serial number 6 adjourned, serial number 7 adjourned. The business, serial number 8, Nataraj PS.
Objection. This is the certified copy of TP. An application for.
Yes, sir.
Notice for the party.
That certified copies of the photocopy of the FDP produced. Yes.
Along with memo.
Yes.
Produce the online copy. Kindly give.
What is this matter?
That was a respondent. Is the. With daughter of. Apparent number 3 to.
No, you are the plaintiff or defendant. Defendant.
The defendant number 1 to 3.
Hmm.
We are the brother and sister.
Hmm.
But after the declaring of the two, defendant number 2 died.
Hmm.
Like Sue,
Hmm.
she has not paid the second wife and children as party fees.
For the respondent defendant number 2.
Died.
Hmm.
Defendant number 2 party is
Hmm.
Sue decree.
Hmm.
But half share ಮಾಡಿದ್ದಾರೆ. Third share
ಅಷ್ಟೇ ಬರೋದು ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 2 ಗೆ ಬರೋದು ಅದರಲ್ಲಿ ಅವ್ರ ಸೆಕೆಂಡ್ ವೈಫ್ ಥರ್ಡ್ ವೈಫ್ ಏನಿದ್ರು ದೇ ಹ್ಯಾವ್ ಟು ಡಿವೈಡ್ ಚಿಲ್ಡ್ರನ್ ವಿಲ್ ಗೆಟ್ ಇನ್ ದ ಶೇರ್ ಆಫ್ ದೇರ್ ಫಾದರ್ ದೇ ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಈಕ್ವಲ್ ಶೇರ್ ವಿತ್ ದಟ್ ದೇರ್ ಅಂಕಲ್ ಇಸ್ ಇಟ್ ನಾಟ್ ಸಿ ವೇರ್ ಇಸ್ ದಟ್ genealogical tree you see that 31 ಅಲ್ಲ 32 ಅಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ ಟೈಪ್ ಮಾಡಿ ಹಾಕಿದಿರಿ yes who is the plaintiff ಮಂಜಮ್ಮ ಎಲ್ಲಿದ್ದಾರೆ ಮಂಜಮ್ಮ ತಿಮ್ಮಕ್ಕನ ಮಗಳು ಜಯಲಕ್ಷ್ಮಮ್ಮ ಹ ನೀವ್ಯಾರ ಮಕ್ಕಳು ಈ ತಿಮ್ಮಕ್ಕ ಮಂಜಮ್ಮ ಮಂಜಮ್ಮ ಹಾಕಿರೋದು ತಿಮ್ಮಕ್ಕನ ಮಗಳು ಮಂಜಮ್ಮ ಮಂಜಮ್ಮ ಯಾರ ಮೇಲೆ ಹಾಕಿದಾಳೆ ತಿಮ್ಮಕ್ಕ ತಿಮ್ಮಕ್ಕ ಯಾರು ಅವಳ ತಾಯಿ ಮಂಜಮ್ಮ ವೈಫ್ ಆಫ್ ಲೇಟ್ ಚೆನ್ನಲಿಂಗಪ್ಪ ಅಲ್ರಿ ಇದರಲ್ಲಿ ಪ್ಲೈಂಟಿಫ್ ಯಾರ್ರಿ ಇದರಲ್ಲಿ ಗೋವಿಂದಪ್ಪನಿಗೆ ತಿಮ್ಮಕ್ಕ ಮತ್ತೆ ಜಯಲಕ್ಷ್ಮಮ್ಮ ಇಬ್ರು ಹೆಂಡತಿಯರು
ಗೋವಿಂದಪ್ಪ ಮತ್ತೆ ದೊಡ್ಡ ಗೋವಿಂದಪ್ಪ ಮಗ 3 ಜನ ಮಕ್ಕಳು ತಿಮ್ಮಕ್ಕ ಗೋವಿಂದಪ್ಪ
ಜಯಮ್ಮ
ಗೋವಿಂದಪ್ಪನ ಮಗ ಗೋವಿಂದಪ್ಪನ ಇಬ್ರು ಮದುವೆ ತಿಮ್ಮಕ್ಕ ತಿಮ್ಮಕ್ಕನ ಮಗಳು ಮಂಜಮ್ಮ ರೈಟ್ ಇನ್ ದಿಸ್ ಗೋವಿಂದಪ್ಪ ಒಂದು ಫ್ಯಾಮಿಲಿ ಅನ್ಸಿಸ್ಟರ್ ಡಿವೈಡ್ ಆಗಿಲ್ಲ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ
ಅಲ್ಲಿ ತಿಮ್ಮಕ್ಕ ಗೋವಿಂದಪ್ಪ ಜಯಮ್ಮಗೆ ಡಿವೈಡ್ ಆಗ್ಬೇಕು ನೀವು ಯಾರು ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಪಾರ್ಟಿ ಯಾರ್ಯಾರು ಇದಾರಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್? ತಿಮ್ಮಕ್ಕ, ಮಂಜಮ್ಮ, ತಿಮ್ಮಕ್ಕನ್ ಪಾರ್ಟಿ ಮಾಡಿದಾರೆ. ಯಾರು ತಿಮ್ಮಕ್ಕ ಅಂದ್ರೆ? ಗೋವಿಂದಪ್ಪ ಸಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಬ್ರನ್ನ ಗೋವಿಂದಪ್ಪನ್ ಮಾಡಿದ್ದಾರೆ. ಗೋವಿಂದಪ್ಪ ಇಸ್ ಆಲ್ಸೋ ಪಾರ್ಟಿ. ಅಲ್ಲಿಗೆ ಶಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎನ್ ಸೂಟ್ ಅಂದ್ರೆ ಇನ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದಟ್ ಗೋವಿಂದಪ್ಪ, ಮಂಜಮ್ಮ. ಗೋವಿಂದಪ್ಪನ ಒಬ್ಳು ಮಗಳು ತಿಮ್ಮಕ್ಕನ ಮೇಲೆ, ಗೋವಿಂದಪ್ಪ ವಾಸ್ ಅಲೈವ್. ಮಗಳು ಕೇಸ್ ಹಾಕಿರೋದು ತಂದೆ ಮೇಲೆ, ತಂದೆ ಸಿಸ್ಟರ್ಸ್ ಮೇಲೆ ಹಾಕಿದ್ದಾಳೆ. ಈಗೇನಾಗಿದೆ? ಹೌದು, ಒನ್ ಥರ್ಡ್ ಶೇರ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ನಿಮಗೆಲ್ಲ ಡಿವೈಡ್ ಆಗ್ಬೇಕು. ಅದರಲ್ಲಿ ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಎನ್ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಮಾಂಗ್ ದಟ್. She is entitled half share on behalf of his Govindappa. Govindappa share ಕೊಟ್ಟಿಲ್ವಾ? Plaintiff is entitled for an half share out of her father's 1/3. Father share and half share, correct ಮತ್ತೆ? ಈಗ ಏನ್ ಗೊತ್ತೇನಾ? I will tell you. See, ಆಸ್ತಿನ ತಿಮ್ಮಕ್ಕ, ಗೋವಿಂದಪ್ಪ, ಜಯಮ್ಮ 1/3 ಮಾಡಿದ್ದಾರೆ. ಗೋವಿಂದಪ್ಪಗೆ 1/3 ಬಂದಿದೆ. ಗೋವಿಂದಪ್ಪನ 1/3 ಅಲ್ಲಿ ಹಾಫ್ ತಿಮ್ಮಕ್ಕಗೆ, ಹಾಫ್ ಜಯಲಕ್ಷ್ಮನ್. ಅಂದ್ರೆ ತಿಮ್ಮಕ್ಕನ ಎಲ್ಲ ಆರ್ಸಿಗೆ ಬರುತ್ತೆ ಅದ್ರಲ್ಲಿ. ಅದರಲ್ಲಿ ಮಂಜಮ್ಮ ಮಕ್ಕಳು ಎಷ್ಟಿದ್ರು ಜಯಲಕ್ಷ್ಮಿಗೆ ಒಂದೇ ಪಾಲ್ ಬರೋದ್ರಿ. ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಇಂದ ಹಾಫ್ ಶೇರ್ ಒಂದೇ. ಅದರಲ್ಲಿ ಅವ್ರು ದೇ ಹ್ಯಾವ್ ಟು ಡಿವೈಡ್. ವಾಟ್ ದಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ಡಿಡ್ ಇಸ್ ಕರೆಕ್ಟ್, ನಥಿಂಗ್ ರಾಂಗ್ ಇನ್ ದಟ್ ಮಿಸ್ಟರ್. ಈ ಗೋವಿಂದಪ್ಪನ ಶೇರ್ ಅಲ್ಲಿ ಅವ್ರಿಬ್ರು ಹೆಂಡತಿಗೆ ಒಂದೊಂದು ಭಾಗ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಅವ್ರ ಮಕ್ಕಳು ಅದ್ರಲ್ಲಿ ಭಾಗ ಮಾಡ್ಕೊಬೇಕು. ಮಕ್ಕಳಿಗೆ ಈಕ್ವಲ್ ಶೇರ್ ಬರಲ್ಲ ಇಲ್ಲಿ. ವೇರ್ ಇಸ್ ದಟ್ ಸ್ಟ್ಯಾಂಡ್ ಟೇಕನ್ ಬೈ ಯು? ಎಲ್ಲಿದೆ?
As her share, she undertakes not supplying any right over the ancestral and joint family property. And now she is breaking up the.
ಈ ಪ್ರಾಪರ್ಟಿ ಸೇರ್ಸಿಲ್ವಾ ಇದ್ರಲ್ಲಿ? 156/2. But where is that your contention that earlier partition? Nothing is there in that. Plaintiff has proved that 156 left to the share of the plaintiff of her share. Defendant has proved whether prove that property is ancestral property. Issue number 2 ಮಾಡಿದಾರಲ್ಲ, ನೆಗೆಟಿವ್ ಮಾಡಿದ್ದಾರೆ. You have failed to prove. ಏನ್ ಡಿಲೇ ಇದೆಯಾ? Just notice. Submission of learned counsel for the appellant is accepted. Issue notice on IA 1 of 2020. Yes.
Objection, correct time matter, serial number 9, M. Ganesh for appellant.
The request 2 weeks time is granted to comply of subjection.
Number 10, Naveen J. M. for appellant.
So,
Number 11, Arjun. Objection, fourth time matter, serial number 12, Sumati S. for appellant.
also
Number 13, Arjun. Objection, fifth time matter, serial number 14, Kumara L. for appellant. 15, Sampath Anand Shetty for appellant.
Subsection number 2.
Is that office objection?
If I counterclaim challenged or not, it is challenged.
Use of the trial court to we filed to verify the value of the counterclaim for that verification of the jurisdiction of that. You are the plaintiff or a defendant. Plaintiff. Who has they have claimed the counterclaiming, what is the documents you have produced? What is the value of
Decree.
the trial court? Where is that judgment and degree?
It is in a memo filed on 27 July.
Suit filed by the plaintiff were made agreed with cost. The register sale deed dated and trusted executed by the first defendant in favor of the second defendant is declared as other defendants are permanently restrained from interfering with the plaintiff's peaceful possession and enjoyment of suit scheduled property, restrains them from alienating the suit scheduled property. Counterclaim by the defendant was claiming to deliver the vacant position item on the suit scheduled property is hereby partly agreed. What is the value of that suit item 1 and 2? Because that you have to be produced. Now you are challenging that counterclaim which has been allowed. There. Subject matter of that appeal is valid 1,000. In court, clear purpose of jurisdiction. You see in that page 31. Page 31. What is that valuation you have stated? ₹1,000. Now you are saying that it is division bench. How? Where is that memo? Where is the memo? Yes. What you want to make out in this, madam? Yeah, on what basis you are saying division bench? The plaintiff valued the suit 35,41,000 and the court fee of 16 paid KFC so and so. Suit coming for so and so. Then why do you mention here 1,000? When there is in a 35,000, you have to amend that valuation. Yes.
It's a typographical.
OS disposal date differ with that.
33.
That you have to make a correction in that. In that judgment and degree. Where is that?
ಅದು 62nd ಮ್ಯಾಮ್ ಇದನ್ನ ಬಂದಿಲ್ಲ.
Page number 33. 17 February 20. Page number 38 is 16 to 20.
Anyhow, that is that we can be overruled, but it has to go before the division bench.
And
You make it that clarification, then they will post before the division bench. First week's time is granted. Comply after.
17 adjourned. Serial number 18 adjourned. Serial number 19 Deepak D for appellant. Serial number 19 Deepak.
Yes, password.
Order serial number 20 Venkata Reddy for appellant. Connected matter. Saravana S.
Yes, madam. Admitted on so and so furnishing issue notice to the R4 6 third time postal Chara as such. Most the person insufficient non-filing up. Yes, you have to take the process, madam. What do you want? Yes, at the request, week's time is granted to pay the process to issue notice to R4 and R6. and 2 weeks time is granted to file a paper book. What is that in your case, non-compliance, Mr. What is- When that notice has been served to you? Yes. IA for continuation of delay barala, proof before trial court to be filed to verify that exact value of the appeal for purpose of jurisdiction. ಅದನ್ನ ಬರ್ದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ ನಿಮ್ದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ. Deficit court fee has to be made good. What is that valuation in this appeal ಕೊಟ್ರಿ ಅದು?
Withdraw my IA 1/23.
2020. Wait. 1,000 rupees. 200 rupees. What is the court fee you have paid? Yes, that is the genealogical tree to be filed. IA to be not pressed since that appeal is not dismissed. Then IA full passage to be filed, that a proof before the trial court to be filed to verify that exact value. Make it in that amendment in that appeal memo. Yes. Each time is granted to comply that officer. This is the one you have to do it.
For opponent, then Chennaraya Reddy.
250. IA 1/23 for impleading. You have filed. You are the appellant. No, parties is not necessary. You are not pressing that IA. Learned counsel for the appellant has filed a memo. Copy paper. Filed a memo stating that IA 1 of 2023 may be dismissed as not trust. Memo is taken on record. IA 1 of 2023 is dismissed as not trust. Then what is that furnishing? Non-compliance of that office objection raised on the wakalat filed by Sri Girish Kumar. What is that office objection on wakalat? Why? Very good. Respondent number? T1. What is that name? Kumari H. Priya. What is their age now? 13 ಹಾಕಿದಾರಲ್ಲ. So 13 years when it is filed in 1998. It is your appeal, mister. Do you mean that party's age will not increase? When the suit is filed, she was aged about 13 years. In that appeal also, you have made it 13 years. Therefore, office objection has raised that she is a minor. You amend in your appeal memo, mister. Then who is that? Yema. What is her age at the time of filing? 13 years. Only two. Yes. Learned counsel for the respondent submits that. Other classification to degree. One D na. How that office has accepted this, mister? How you are given a number like this? 1D, 1P, 1D. ಯಾವುದು ಸರ್ವೆ ನಂಬರ್ಗಳು ಕೋಡಿ ಕೊಟ್ಟಂಗೆ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ. 1D, P1, D1. Respondent Priya, Kumari H. Priya and Kumari H. Yema, other major. Learner counsel for the appellant is permitted to amend the cast title. Wakalat filed by the respondent on behalf of Kumari H. Priya and H. Yema is accepted. Correct matter age our now ask him what is our age and return it. What are that other this thing? Paper book, yes, 2 weeks time is granted to file a paper book. Or recording marks correct. Yes, Mr. Reddy.
Senior.
Serial number L. Venkat Reddy.
D1A. Shanara Reddy ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಯಾರ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ?
D1A.
D1A. Venkat Reddy. Yeah, serial number ಇದಲ್ಲ 21 ಅಲ್ಲ? Yes, office is directed to delete the name of Chandra Reddy and show the name of Shankar Reddy for respondent number R1A na R1A in the cast title. 2 weeks time is granted. 1 week's time is granted to pay the process. Issue notice to unserved respondent. Yes. Mani, correction madi.
Number 52, NK Kantaraju, Sridhar MC Sridhar Road Expense.
Yes, Mr.
They have filed an application on 11/10/2023.
Hmm.
For that, it is moved to the saving.
Hmm.
Challenge it was resolved.
Hmm.
Safety of the execution and movement. The property was marketed in 2089. Till it was 2021, property was marketed. There was absolutely no occasion for my husband and saving. But we have excluded, but not withstanding certain documents were not there before the court.
What is the suit for? You are the plaintiff or a defendant? Defendant. Suit is decreed. Yes. Why you are not obtained that interim order in 2018?
Application on 11/10/2023. So they have filed an application. That's page 102. Page 102.
Yes.
This application was filed on 11/10/2023.
102 ಎಲ್ಲಿ ಇದೆ?
Last application.
ಇದೆ. Application. What is this?
For the court bill. Now this application, once I have to file objection to it, I have not yet filed objection. Once of 6/12/2023, once I file this application, it's day of the execution.
Now, what is the stage of execution? Now that
Execute the sale deed.
yes. Now that what is the stage? Now notice has been issued. That's all.
These are available. These are like that. Now, when must the objection filed on the-
Now, what is the next date of?
Now, immediately application filed by the court. The direct one is the pass on the days.
Now, what is the next date fixed in that execution petition? Yes. Yes. Now the thing is, if that degree is executed, then appeal become infructuous. Fix. What is the next date? That's what I am asking. 32. 3. We'll have it on 27th or 28th. Finally, you get ready. If you are Sunday. In the March it is there. 3 is in March. Yeah, that's what that. Otherwise, see, now it is state, then he cannot be executed his degree. He cannot enjoy the fruit of that degree. Yes. Yes. 26th or 27th? 27th. 26th. Yes. Leave this matter. Now the service is complete. Who is second respondent? He is the contesting. No, as a contesting. Why, how that? No, that. No, who has executed an agreement? You. Sanjeev Appa. Sanjeev Appa. Huh? Sanjeev Appa is no more. No, that is true. That will be, you are the son, you are succeeding that, you have to be. Now that, Sanjeev Appa, now that all the defendants has filed an appeal, plaintiff is the only a contesting respondent. Then he is accepted the degree. He is not necessary part. He has accepted. He has not challenged the degree which is passed against him. Has sold it. To whom? No, he is not this thing. Since he has not challenged service in respect of which respondent. Yes. Auto will be dispensed. Yes. Service of notice to respondent number 2 is dispensed for this matter on 26th. Yes. On that day we will hear. Yes. No, yes, I have not granted interim order. If he is not ready on that day, then there is no interim order. Yes.
Previous matter 21 how Umute alone, sir. GA Anthony Crossing.
It is not necessary, Mr. See, he is one of your brother. Degree is against him. He has not challenged. He has accepted the degree. What is his contention as a respondent? He should have filed an appeal along with you.
I cannot say.
Yes. At present, service of notice. Respondent number 2. Then you take notice. Then will not grant any interim order. If you want that, yes, awaiting service of notice to order. Yes. Post after service of notice to order. Yes.
Previous matter.
Yes. No. This is not the way of you making this, Mr. He is your brother. He is not challenging that degree. You want that to be service has to be completed. You take hands much. Yes. Yes, on 26th. Yes, 26th. Yes. Yes. List this matter on 26th.
Number 23, Veerabhadraya for opponent, Talada Riots.
Yes.
23,
Furnishing of PF issue notice to respondent number 2, 3, and 4. So,
54, Chandrasekhar Achar, SK Achar for opponent.
yes, SK Achar.
55, Prashant Chandra Edson, Ananda Tirtha D for opponent.
My lord, I appear for the appellant, my lord. I appear for the appellant in serial number 25, my lord.
Yes.
My lord, I have filed a memo on 15/6/2021 to hold the notice to that we do not press the relief against respondents 4 to 9 in this appeal, my lord,
Deleted.
as they were deleted in the suit also. Hence, my lord, we pray for
Delete that.
deletion of respondents 4 to 9.
Filed by that advocate for the appellant. to be taken, claimed R2 and R3. R2, R3 unclaimed.
My lord, so far as R2 and R3, it's unclaimed, my lord. Service may kindly be held sufficient, my lord. Respondent number 1 is served and is represented through a counsel.
Wait.
Please, my lord.
R2, yes, Raju, unclaimed.
Yes.
R3, A. Ananda Naidu, unclaimed.
Yes. Is issued to that respondent number 2 and 3. Written with postal shara. Unclaimed. In service of notice to. Point number 2 and 3 is held sufficient. The net counsel for the appellant has filed a memo. Deletion of respondent number 4 to 9. Memo is taken on record. Respondent number 4 to 9 is deleted. The net counsel for the appellant is directed to amend the cast title.
Obliged, my lord.
Basavaraju P. C. Komal Kumar for appellant, Somanant H.S.
Yes.
Exponent, he is a developer. He had constructed several apartments and sold away several properties. Respective person. But I am taking these steps today itself, my lord, to issue notice to the AB. Today itself I will take steps.
Yes.
My lord, the intelligence, my lord, small intelligence, my lord, the FPP has been filed before the trial court. Trying of the final dictate, at least, my lord.
You are the defendant.
Please.
Suit for
Partition and separate.
What is the degree passed by the trial court?
The degree, my lord, the plaintiff is entitled to 1 4 share.
What is your defense?
My lord, the defense was kindly come to page number 38 for it. So it is in a family tree.
Yes.
It will suffice, my lord, the internal person, my lord, the MR Venkatachalapati. So he is the person who acquired the property by virtue of partition between the brothers on 11/3/1998.
Who?
11/3.
Venkatachalapati. Yes.
Venkatachalapati acquired the right over the property and the partition on 11/3/1988.
Yes.
He got 3 daughters, Kumari, Usha, Srimati Jayanti.
Yes.
The Jayanti, the woman, died on 29/12/1987. Much prior to entering into the partition. In view of the same, the plaintiff, the mother of the plaintiff, may not acquire the right over the property since succession had not been.
See, she has a share in her father's property.
Please.
If she died, the LRs will entitle.
My lord, here in this case, my lord, she died on 29/12/1987.
No, if it is an ancestral property, even though there was no partition among his fathers and his brothers, she will entitle. Who said it is not entitled?
My lord, the property acquired by her father subsequent to her death.
No, not acquired by first time. It is an ancestral property. By partition, it has come to him. See, in the 1998, first time they have taken a partition. See, if it is an ancestral property, by birth, Jayanti itself has a right.
He acquired by her
By birth.
estate interest has been paid in, my lord, that's true. Well, my submission, my lord, the partition under the partition, Venkatachalapati.
No, that is true.
Brothers, my lord, the property acquired by him is the self-acquired property on 6/11/1990. Sorry, 11/3/1988. Where this Venkatachalapati acquired the right over the property, my lord, among the brothers. The property allotted to Venkatachalapati became a self-acquired property. So except the brothers have entered into the partition. The share allotted to Venkatachalapati to be treated as a self-acquired property.
No, earlier is it not a joint family property?
Earlier it was a joint family.
No, tell me. See, it is not that Venkatachalapati's self-acquired property. It is his ancestral property. See, the moment that Jayanti born, she has a right over the property.
There must be a 4 generations to be established. Well, there was no such 4 generations have been established. My responsibility, if the 3 brothers have been entered into the partition, well, the property allotted to one of the brothers, it will be treated as a self-acquired property during his lifetime. Well, after his death only the succession will be over.
No,
His
if it
children
is-
will be entitled.
No, if it is ancestral property, great grandson will, by born itself, they will get any rights.
8 and 9 of the Injunction Act, my lord. The succession will be opened only after the death of the father.
No, if it is grandson is concerned, if it is more than 3 generations old, then the moment they are born, they will enter into that.
Here also grandson, my lord.
No, whether this property originally acquired by Venkatachalapati's father is he self-acquired or it is ancestral for him?
My lord, it is a name, my lord.
See-
Property of Venkatachalapati's father. It's not an asset of property of Venkatachalapati.
That is what that case. You have to say that if it is in the hands of that Venkatachalapati, it is only from his father. It is not in a joint family property. That is it that case?
My lord, this is the defense has been set up in the written statement.
Yes.
Here, appellant number 1 and 2 have not filed the written statement. Only appellant number 3 contested this.
Then what is the finding of the trial court?
What will be the conflict situation is, my lord? The respondent number, my lord, 2A, B is there. They have, my lord, they constructed the apartment in the year 2010. They have sold away the entire flats. My lord, FDP, my lord, now the commissioner has been appointed. Lord, there will be, my lord, several flat owners. They have appointed.
You are appearing for a dependent number?
My lord, the dependent number, my lord, 1 to 3.
You are appearing for dependent number 1 to 3.
They are the appellants hearing.
Who has sold that property?
My lord, all these persons, my lord,
Who?
all these persons have not sold the property, have entrusted for the joint development agreement. While joint development agreement also proceeding with that. But as on the date of filing the suit, my lord, there was already construction of the over. Now, my lord, if the further proceedings, my lord, only by responsibility, proceedings will be going on, my lord, by appointing the commissioner and collecting, my lord, the report, everything. While only drawing up the final decree, my lord, I am requesting.
No, that is true. But you also not alienate that property.
Please,
You cannot, builders cannot go and create a third party interest.
Builder, my lord, have been arraigned as a respondent for 2A. Insofar as the appellant are concerned, my lord, I may.
No, both
This one,
appellant and the respondent has directed not to create third party interest.
Insofar as respondent number 2A, my lord,
The court is directing.
please, my lordship may get.
Yes, serial number
I cannot give an undertaking. 26.
26. Who is appearing for that? What has happened? Notice is not served to that respondent.
Number 2A, my lord, I am today itself I am taking steps ready, my lord, I already paid the process also.
Finishing up, we have issued notice to that respondent number 2A. Who is 2A?
3 and 2A, my lord, both are the, my lord, the developer.
Hmm.
The Vaishnavi property is represented by them, my lord, they are the partners.
Yes.
That's what I am taking the steps.
Senate counsel for the appellant press weeks time to file. To press 2 days time to get the process issue notice to respondent number R2A and R2B. No, there is a delay of filing that appeal is.
137 days.
Then you take a hand summons to that respondent. Who is appearing for R1?
The R1, my lord, is.
Where is he?
The
Somanath H. Who is that counsel?
FDP, my lord, 15/2019 is filed.
Who has filed that Somanath claim?
The
Where is-
respondent number 1 has filed the.
What is the next date in that FDP?
15/3.
16/3. In the meantime, you take an hand summons, we'll fix the date.
The respondent number 2A, my lord, today itself, I am telling, all the process has been paid, my lord, I have filed it in the counter.
No, if that notice is served, I could have allowed that application for condonation of delay. That's what. You take hand summons, we'll have it next week. Then we'll condone the delay and grant an interim order. Yes.
Lord, today I'll take steps also.
In addition, you take hand summons.
In addition to that. my
Because
lord,
it is your party, he will take hand summons. You have sold them.
Please.
Yes. We learned counsel for the appellant submits that during the course of the day, you pay the process to issue notice to respondent number 2A and 2B. In addition, appellant is permitted to take out hand summons to R2A and R2B. Yes. Post immediately after service.
It takes notice to the advocate to represent before the trial court on behalf of the 2A.
ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Unless sir, delay cannot be condoned. Yes. You take hand summons and move that matter. What is that non-filing of acknowledgement having deposited 50%? Where is the documents to show that? No, what is that? You are not representing, you have to get an instruction from your client, madam. We are not asking, you have to go and get it. What is the degree? Dependent is directed to pay the sum of rupees 2,60,000. What is that order passed by this court? They aspirate for is subject to the condition depositing 50% of the compensation amount. Yes, if you are not deposited, then there is no interim order. Request, read this matter next week. Yes.
Number 29, PM Venkata Reddy for opponent, matter, Naveen Reddy, MOV.
Yes, Reddy, what is this? Non-filing of paper book. Yes, madam, what is this? Then we'll dismiss it. Why the paper book is not filed, madam? It is all 2020-21 matter. Filing of the print list for the preparation. Yav documents bekanta one list kododu ashte ನೀವು office will prepare. Then you have to pay that fee. That you are not doing. Yes. Another counsel for the appellant prays finally week's time to furnish the print list for preparation of paper book. Yes. 32 is connected. Yes, what is this? You have to compare that. Why it is connected? Then why it is posted separately? There is no order for connect. Yes. 32 Ali. Week's time is granted to do the needful. Leaves this matter along with that RFA 556 of 2021. Yes. Adralla 32 ಅಲ್ಲಿ entry ಮಾಡು granted earlier is extended next date appear. Yes. Entry matter again. 27 entry matter will not extended, madam, unless you show that 50% has been paid. Therefore, I have not extended. You show me that you have deposited, then only entry matter will be extended. Yes. There is no limitation, limited entry matter, madam. It is an absolute entry matter.
30, Prasanna, we are for opponent, Krishnamurthy, the answer that.
Yes, Prasanna.
For respondent.
Yes.
both we have filed some documents notes along with memo notes. Matter was argued on the other day.
Why it is urgent on that day?
Only, my lord, my learned friend has not time to ask the reminding the matter.
Yes.
Provide dependent.
In view of that subsequently.
Please.
Yes, Mr. Krishnamurthy, what is your instruction?
Your lordship wanted to know whether for the purpose of facilitating the defendant to lead evidence in the matter, whether it could be remanded.
Yes.
Your lordship also said that all actions taken pursuant to the interim order granted by this honorable court will be continued till the disposal of the suit.
Yes.
And of course,
That is subject to the.
I leave it to the honorable court, but the thing is, before that, it is my attempt to show, kindly see the order sheet and some provisions and one judgment of this honorable court. Tamdu Yarmur judgment is the order 41, rule 27. Of course, this IA cannot be considered at all because totally irrelevant document. They say that Societies Registration Act some other Samudaya Bhavana Samiti has been registered ಅನ್ನೋದಕ್ಕೆ ಈಗ ಮೊನ್ನೆ certified copy ಕೊಟ್ಟಿದ್ದಾರೆ.
No, this application is filed first time before this court.
ಹೌದು.
I think judgment you want to cite, it is filed before the trial court without passing any order on IA. Final degree has been passed. Therefore, we have remanded. Is it that judgment?
ಇಲ್ಲ ಅದಲ್ಲ ಇದರಲ್ಲಿ ಈಗ there is no question of considering this IA under order 41 rule 27. Of course, consider ಮಾಡೋದಿದ್ರು because kindly see the factual aspect. Kindly see the order sheet.
Yes.
If he really deserves a concession from this honorable court, then I would say that this honorable court can proceed as the order. Kindly see the order sheet 1319 dinda 1319.
Order sheet of what?
Order sheet of the trial court proceedings. Records ಬಂದಿವೆ. ಅದರ ಒಂದು ತೋರಿಸ್ತೇನೆ. If he deserves with partition.
ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು.
We will get that 2:30. Records is here only. Office 2:30.
Please. 2:30 I love that.
Yes,
Please.
yes.
31, 32 ordinance, number 33, Mr. Sanjeev Gowda, Mahantesha BK.
Non-compliance of office objection, 8th time, accepting of acknowledgement having paid the cost of 600 to the legal service authority. Yes, have you completed the top objection? What are the top?
Sir, application to bring LRs in respect of dependent number 2 to be filed. ಇಲ್ಲ 3 4 present age to be stated. The value of appeal plaintiff share to be stated. Genealogical tree to be stated.
Where you have complied? Valuation, what is that value?
Post agent mention is plaintiff share.
That what is the root for? Root for injunction ಆದ್ರೆ plaintiff share ಹೆಂಗ್ ಬರುತ್ತೆ ರೀ? ಪೇಪರ್ ನೋಡೋದಿಲ್ಲ ಅಂತ್ರಿ ಒಬ್ರು. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ತಗೊಂಡೋಗ್ಬಿಟ್ಟು ನೀವು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅಂತಿರಲ್ಲ. 1/15 share of that future property. Share ಅಂದ್ರೆ ಎಷ್ಟಾಗ್ತದೆ? What is the value? Value of the share of the respondent PNDP is 8 lakhs ಅಂತ ಹೇಳ್ತೀರಾ. 8 lakhs, that is 4 lakhs only. And accordingly, defendant want to have valid pursuit. Individual share is 1/15th. ಎಲ್ಲ ಹಾಕಿದ್ದೀರಿ. Not complied, madam. You comply the top subjection first. Yes. At the request, in this matter,
I
appeal for the appellant, your lordships.
yes, Mr.
Your lordships, while filing at the trial court, the advocate has filed only jurisdiction as 20 lakhs. He has not mentioned the shares also. So however, the property is worth more than, plaintiff share is also worth more than 15 lakhs as on the date of filing of the suit and as well as today also.
No, see, plaintiff share is 1/3 share.
1/3 they have mentioned, but only jurisdiction he has mentioned as 20 lakhs. But it is worth more than 15 lakhs as on the date of filing. His share itself is more than 15 lakhs, your lordships.
Where is the document to show that it is 15 lakhs?
No, 15 lakh his share comes, it is because 2006 notification all in and around Dodballapura is 60 lakhs. Government notifications are there.
You produce the court. I have to go and see that government notification, or you have to produce before the court to see that value.
Yes, I'll produce it. I'll
That is
produce
what
it.
that office asked. Show that value to find out that share of the plaintiff.
Much or less.
Yes. Request. 2 weeks.
35, Ravindra Prasad B for appellant, Sampath A.
Retirement. When they collected the file, my lord, it's acknowledgement, I may permitted to retire.
Non-compliance of the office objection for 7th time.
Right, the office objection. Said that certified copy of the valuation.
Non-filing of
Court of
CC
34
for the purpose of
34.
jurisdiction of Karnataka. H. One, yes.
I could copy of before that 51. That is my copy of.
What is that value?
They have said that
The share of the plaintiff is more than 10 lakhs. Market value of that properties is rupees 1 lakh.
therefore, usually your lordship has been permitted to 1 lakh share that you mentioned your lordship. That has been amended here. Now the office objection is saying that the CC copy of the valuation slip has not been produced. I have produced already.
Where is that order regarding that office objection is overruled?
Initially, the office objection was that 6th item. Valuation paragraph appeared to be stated correctly.
Judicial report. The appellant have to produce the guideline value for the purpose of registering the state government action 2026 for hearing. No, there is an order from the judicial register. You have to produce that. No such, it can be held that 1 lakh only 26, hence that appellant has to produce the guideline value. Guideline value you have to produce to find out whether it is 1 lakh or not.
In the trial court, your lordship, there was no
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜುಡಿಸಿಕ್ಷನ್ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಸುಮ್ಮನೆ ಬಾಯಿಗೆ ಬಂದಂಗೆ ಬರೀತಾರೆ, ಕೋರ್ಟ್ ನಲ್ಲಿ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. ಇಲ್ಲಿ ಕ್ವಶನ್ ಆಫ್ ಜುಡಿಸಿಕ್ಷನ್ ವಿಲ್ ಕಮ್. He find out that whether it is appeal is maintainable before the High Court or a district court. If it is in the Bangalore, then it is in a division bench or single judge. Here jurisdiction has to be find out. ಅಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜಿಗೆ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ, ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಹಾಕ್ಬೋದು. ನೀವು ಬಾಯಿಗೆ ಬಂದು ಬರೀತೀರಾ, ಆಫೀಸಲ್ಲೂ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಲ್ಲ. Now that they want that guidelines value to find out whether it is 1 lakh is correct or not. If you produce the guidelines value as 2016, that is what that register judicial order. Yes. Awesome.
I been permitted to read.
You have filed them.
No, please, along with the acknowledgement, I filed it.
They have taken that copy.
Please, my lord, they have taken the copy with the affixing signature.
Yes. Only one respondent.
Please.
To 2023. After that, they have not engaged any
They
counsel.
are not engaged.
This will permit you when they're passing an order in this objection.
Your lordship, we have forwarded through RPID, your lordship, to the curator. Since he has refused to accept your lordship on the ground that.
Now he is retiring. He has given.
I have submitted curator that.
Yes. Now you show that guidelines value. Then.
36 Madhusudan Rao, Division Bench.
Yes. Office note says. No, amendment is not yet come forth. Notification is not yet issued. So what is that value now? Yes. Office note says appeal is valued more than 15 lakhs. Hence post this matter before the division bench having in a close. Yes.
Number 37, Mohan Kumar M for appellant.
For what? Yeah, week's time is granted to do the needful.
38, Narayan PM for appellant.
Press 1 week time. Steps.
On furnishing of or acknowledgement, week's time is granted to do the needful.
Number 39. Arjani Desai for appellant. K. Bhaskar.
Yes.
My lord, we will comply with the order.
Yes, week's time is granted. How much time?
Please, my lord.
Yes, week's time is granted to do the needful.
40, Union KGS for appellant.
Yes. What is the suit for ejectment?
For ejectment, it was decreed against me.
Yes.
And there was a, kindly see page 43, an order for mean profit of 25,000 from the date of termination of lease. And we were to hand over possession within 2 months.
Yes.
Honor will see that at page number 40, the 40, the operative portion of the order within 2 months from the date of the judgment. Judgment is dated.
Yes. 6/4/23.
6th April 2023. We handed over possession on 5th June as per the order of the decree of the court. That the honor will see.
It is further read that plaintiff are entitled to recovery of the mean profit 25,000.
Yes.
Plus per month
Per
from
month.
the dependent from the date of termination of tenancy, that is 20th February
Yes. Till date of handover.
till date of handover.
Yeah.
When
We'll
you
also see page 61. We handed over on 5th June 2023.
June 2023.
Yes.
That how many months there?
That's about 40 months. Calculation, memo of calculation is filed separately.
Where is that?
calculation, page 2. Who has the memo of calculation?
Page number
2 of the memo of calculation, separately.
yes 2025.
On the 9th February.
Yes.
Page 2 on that.
Yes.
Lord will see for 40 months into 25,000,
Yes.
that is 10 lakhs as per the decree.
Yes.
I've taken till handover of possession
Yes.
as per the decree.
Yes.
The court office is refusing to recognize that letter of handing over of possession, and they are calculating mean profits to the filing of the decree. The execution is filed not for recovery of possession,
Only mean profit
only
here.
mean profit, and then it's not undisputed.
No, that will kept open other side.
Absolutely,
It says that yes, handed over.
absolutely. Now the problem is, my lord, if that is kept open, I'm okay, my lord. There is a, when we handed over, kindly see page 61, the appeal memo.
Yes.
When we handed over the premises,
Yes.
we also marked a copy to both lawyers.
Yes.
And the understanding was, because we didn't appeal, we gave over the possession. The understanding was with any arrears will be adjusted against the security deposit. So with that understanding, the keys were handed over. After 10 months, an execution, after taking possession, an execution is filed for the mean profits.
For remaining period also.
Yes, for remaining period, and also not deducting the security deposit.
That you established before the court saying that you have already handed over.
Yes, that, and the security deposit was not minus. Kindly see the judgment. There was a rejection of certain arrears of rental. Kindly come to page 40, the second paragraph.
40.
Recovery of arrears of rent of rupees 1,26,000, page 40 of the appeal memo.
Yes. Four zero is valuation slip. You are
Memorandum of appeal.
memorandum of appeal. No, that no. Now you are referring to that order portions of that.
Yes, order.
Yes, that is page 35.
Yes, my lord. Order.
Yes.
Suit of the plaintiff is decreed in part. My lord has that.
Yes.
And then you have the prayer of ejectment of defendant is
Yes.
granted.
Yes.
Then the next, the prayer for recovery of arrears of rent of rupees 1,26,000 is refused. Now in the execution, he includes this 1,26,000. He also does not minus the security deposit. He gets an attachment warrant, which my lord will find at page number, pages are correct, 57 or 54. The type copy is at page number 60.
Yeah. What is that? 4/1/2024 they have issued.
Execution, yes. And yes. Now they are coming to the business premises to take over my furniture, computers, etc.
Respect of office objection. The net counsel for the appellant submits that appellant has handed over the possession of the two premises. The plaintiff on
5th June 2023.
5th June
2023.
2023. Accordingly, court fee has been paid. Since office has calculated that court fee till date of filing that appeal, that office objection in respect of non-payment of deposit court fee is kept open. Issue notice to. Adonde office objection only that was.
That's all.
There is no delay.
There is a delay because we were under the impression the matter was settled.
There is a delay of 200. The IA 1 of 2024 is filed for condonation of delay. Since that there is an order for warrant. What is that order now? Execution petition?
Attachment warrant.
Yes. Now that in the execution petition, attachment warrant has been issued. Under other circumstances, in view of the peculiar facts and circumstances of the case, pending consideration of IA 1 of 2024 for condonation of delay, stay of further proceedings in execution number
25486.
25486
of
of
2023.
pending in the file of 13th ACJ and SG portal 22 Mehal unit Bangalore is stayed till next date of hearing.
Matter, serial number 41, Saravana as per appellant, concerned matter, B.S. Satyanand.
Yes, Sarvan. Yes, he was. Yes, what is this matter, Mr.?
That serious, there is serious dispute with the identity of the properties.
He has to file a declaration suit. Yes, why it is posted today?
Application.
Yes, at the request of parties, leave this matter of 2 weeks.
For appellant.
Delay, my lord, notice.
Yes, issue notice.
Number 43, government advocate for appellant, Chandan.
Kindly pass on the matter. Sorry, I was not present on the last page.
Yeah.
Kindly pass on the minutes in a postal file.
So,
Request, like,
wait, council is there, yes.
request. I have already prepared the paper book and I have given it to the other side. Which copy is also ready and pass it on. But you can kindly hear me at 2:30 because the suit is of the year 97.
No, hearing it cannot be possible now.
I'll put records and also before. I'll put
This
records.
week and next week.
On a day-to-day
Regarding
basis,
the-
If both are agreed, I will fix on 26th or
But
27th.
regarding the interim application, it might be heard.
Yes, we'll see that interim application, yes.
Allah. Take it up, short point.
I'll
assist the court.
No, 26th or 27th, if both are agreed, I will fix. Otherwise, there is no time for.
The interim application.
Yes, he was
Wait, our
asking for
objection.
interim application. Let us see. We'll argue on that application. Yes. Yes, password. Password. Yes, password.
Number 45, Ajay.
Excellent, my lord. May I pray for 2 days time, Lord?
Yes.
Suit for partition. What instructions on last time I got it, they are on a verge of settlement also. I'll just seek proper instructions and I come back. Monday it may be taken.
Yes, madam.
My lord, I need to file impleading application
Hmm.
because the appellant here in item number 5 and 6 of the suit schedule, they alienated it in 2010 in my favor.
Yes.
In 2016, the suit for partition is filed excluding without making me a party. And I learned about this appeal just yesterday. Therefore, I need 2 weeks time
Yes.
to file necessary application to come on
This
record.
matter next week, please. Yes. You do whatever you want.
I appear for the appellant, my lord.
Yes.
This is an appeal by a defendant
Yes.
in a suit for mandatory injunction.
Yes.
Plaintiff was a tenant under my vendor and he continued to be a tenant under me, my lord.
Yes.
The property is a shop on the ground floor on Residency Road, my lord. Since 30 years they are there. Even today they are paying rents of 5,000 rupees. This is the background, my lord. He files a case, if my lord observes, on date of institution of the suit, my lord, is 25/2/2019. Saying that the water connection has been disconnected. On 8/4, which is the date of appearance, I appear and I file a detailed memo. That memo I have reproduced at page 6 of my petition, my lord. Memo nan sorry. The defendant begs to submit as under. The plaintiff has filed
Where is that memo you are reading?
page number 6 of my petition ಅಲ್ಲಿ reproduce ಮಾಡಿದ್ದೀನಿ. As annexure ಹಾಕಿಲ್ಲ, but I reproduce ಮಾಡಿ. Page number 6 also. On the date of my appearance itself, I filed this.
Yes.
The plaintiff has filed the above suit against the defendant for the judgment and decree for mandatory injunction to direct the defendant to restore the water supply to the scheduled premises. But during the replacement of some of the damaged water connection pipes with new pipes, the water supply to the scheduled premises was disconnected, and immediately after replacement with the new pipes, the water connection was automatically restored to the scheduled premises on 28/2/2019 itself, and the plaintiff has been using the said water supply to the scheduled premises. In the meanwhile, by misconception, the plaintiff has filed the instant suit in a hurried manner without waiting till completion of the replacement work of the said damaged water supply pipes. The photographs along with cash bills showing the restoration of water supply in the scheduled premises are enclosed herewith for kind perusal of this honorable court. Wherefore, since the prayer of the plaintiff in the above suit is already complied with by restoration of water supply to the scheduled premises, the defendant most respectfully prays that this honorable court be pleased to dispose the above suit as infructuous in order to save valuable time of the courts. Nange our hakid suit 25th, 28th kene restore ಆಗ್ಬಿಟ್ಟಿತ್ತು. ನನ್ನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಮನ್ಸು ಬಂದಿಲ್ಲ, ಏನು ಬಂದಿಲ್ಲ. First day I go and I appear and I tell the court like this has happened, water damage ಆಗಿತ್ತು, photographs ಕೊಟ್ಟು. Basis on this memo, my lord, the trial court has passed off a judgment under Order 12 Rule 6, given a decree. In the decree, it is told that if at any time water is disconnected, you can directly file execution case. This is not a case of interference, my lord, because execution can be done through multiple ways. Hence, I have filed this. It may be admitted, my lord.
No, that you yourself has admitted that you have restored that. Then what else remains now? Now, court is also decreed that to restore it.
The liberty
No,
is
not
given
re-
only if there is any disconnection. So now there is no disconnection.
My
So
lord.
what is the apprehension to them to now challenge this liberty part of the?
Where is that liberty?
Please, my lord, page number 13.
Plaintiff is the liberty to seek for a restoration of the water pipe by fixing in execution. If the
Execution.
defendant has not restored the water supply to the suit property, plaintiff has liberty to seek for, yes, whenever you going to disconnect, they have liberty.
Yes,
Sorry,
Lordship,
none-
kindly.
ನಾನು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದಿದ್ರೆ they have a cause of action, they can file a suit. ಆ ಕೇಸಲ್ಲಿ it was due to clear damage. ನಾನು ಅದಕ್ಕೆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಹಾಕ್ತೆ, ಬಿಲ್ಸ್ ಹಾಕ್ತೆ. Even before summons ಬರೋ ಮುಂಚೆನೆ ನಾನು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೆ. In all honesty, I went to the court, filed a memo saying that the suit is infructuous. It was not an admission of saying that I have interfered with.
No, ultimately, what will be the result?
The result
Is that to restore the water supply.
I have already restored till today also, not once I have disconnected, even they are aware.
Now they are also not complaining that you are disconnected.
But it acts as a weapon in their hand at any point in time.
If any point in time, if you want to go to disconnect, see, you can't use that. If there is no rent is paid, it is not the remedy for disconnecting
No,
the
I have never
or threatening the tenant by disconnecting that water.
No, my lord, that is not at all the case.
Then why do you worry?
My lord, it's a decree against me, my lord.
Yes, if
How-
any time if you disconnect, they will go and execute that.
My lord, decree comes into picture, my lord. My point is, I'm going on a very logical view of it. For Order 12 Rule 6 to apply, there has to be an unequivocal admission. My memo is to dismiss the suit as infructuous. It is not to decree the suit as complied.
What is decreed only on the basis of your memo?
Memo, only on the basis of my memo. Page number 12 only, order dated, memo dated 8/4/29.
That has put forth the reason for replacement of the damaged pipe with a new pipe. Therefore, no, they have, what you have stated, same thing.
Please, my
See,
lord.
it is not that you have intentionally disconnected. You have explained the reason for replacement of the damages. Therefore, degree has been passed. That's all.
But
See,
this,
degree is that in future you should not disconnect.
my lord, that in future is a very contingent thing, my lord. That which has not at all happened, for which they already have a decree, my lord. They can always file another suit. No court will ever prevent them. But this
No.
point,
Here,
point
what
number
is
2.
that? See, you have filed in a memo has given that undertaking that it has been restored. Suppose your submission is false, if it is not restored, you won't execute. That's all. It is not future.
You see paragraph.
Liberty is that, see, you have given assurance before the court that court has not come to the place and see that. Therefore, they are given, if it is not restored as per that memo he has filed, you execute it. That's all. That is what that meaning.
My lord, then this honorable court may give a clear
That
clarification.
is what the clear clarification.
Let there be an admission from them today that
No, you see, nobody can be admitted. That is the degree. If the dependent has not restored as per your memo, the water supply to the suit property, the plaintiff is at liberty to restore. They need not again come to the court saying that, no, he has filed in a false memo, he has not restored, again given a degree. Therefore, court said that if it is not complied, you go and execute it.
My lord, this falls in a gray area, my lord. I'm being.
No, it is not
Then it-
false in here. It is very clear for me.
If today, my point is only, say by chance today again, water supply is disconnected. If today, then this order will be used by them to directly file an execution, which cannot be permitted.
No, see, it is only in respect of earlier that you have to explain when they have executed. This is saying that in pursuant.
That is why that clarification
That is
comes.
not that. No.
Because an executing court, my lord, if they file an execution.
See, when you have filed a memo on 22/7/2019, you have restored. No, that memo which you have filed, you have restored. If any disconnection later part, then this degree is not applicable. They have other remedy.
My lord, that clarification may be.
That I can't clarify all these things. I can't give everything that you have to be explained before the court.
Practical difficulties.
See, court is not for that parties who has not understand that what is that meaning of the degree.
Gray area.
Not gray area. It is correct. That's what I interpreted. You have to be. If you should not have filed this appeal. If they have filed any execution petition subsequently that disconnection, you have to go before the court and convince this is this. If court is not convinced, then you have to come before the court. You can't expect that court will not consider this. Therefore, now I have to clarify. We are not for that purpose to.
Today, let at least an admission be given by them that we so far have never disconnected, and then this becomes inapplicable.
No, I will record your statement. I will record this statement that see, in pursuant to that, he has filed a memo stating that it has not disconnected. Only for this repairs purpose, it has disconnected. Trial court is also recorded that and disposed of.
That may be recorded that this pertains only and only to that memo and not to any further.
Kindly page 12 of the petition. The
Yes.
order copy.
Yes.
Paragraph 2. After they filing the memo, we have also filed a memo 22/7/2019. We've attached the photographs also stating that the water connection was not connected. Thereby, the court went ahead and they gave us the liberty. So they.
After filing the said memo on 22/7/2023, petitioner has filed a memo, another memo with photographs showing that disconnected water pipe. Yes, Mr. See your conduct.
Water textures.
My lord, today we are here. All I am saying is today they cannot directly fight. And these were old photographs. That is why there was an argument in the court that day that the photographs produced by them are the old photographs.
You could have filed an objection for that memo saying that it is old photograph.
My lord, it was taken off, my lord, and the court ought not to have order 12 rule 6 invoke Madi that position. It could have gone to trial. My only point is nan hakiro memo to dismiss it at infructuous now, to use it, though there were contentions, to pass a decree. If it would have gone to trial, my lord, I totally concede. But to use a memo, to pass a decree against me, where the memo was only to dismiss it as infructuous, cannot today again be used by them.
No, what is the contents of
matter is, my lord, the truth of the matter is, that it may appear as if I am at the defaulting side, my lord, but there is a case that for 30 years, though they have been evicted, 400 square feet of area on Residency Main Road today, they have been occupying for the last 30 years and still paying only 5,000 rupee rent. That's separate proceedings, but the Supreme Court is pending it for the eviction purpose. But now to use all of this, namge renovation madak bitta illa. That building 30 ವರ್ಷ ಹಳೆದು. ನಾವು renovation ಮಾಡಬೇಕು, fresh pipes ಹಾಕಬೇಕಂದ್ರೇನು ಪ್ರತಿಯೊಂದಕ್ಕೂ ಇದಕ್ಕೆ ಹೋಗ್ತಿದ್ರು. Today, if we want to do anything, this acts as a sword over our head. The only clarification, that is why, let it go to trial, my lord. If my lord deems fit, let the case go to trial. But to pass a decree on a memo for, that is why, it's my apprehension.
Yes.
My earlier vendor had also disconnected. In 2019, they had disconnected both water supply.
Yes.
Thereby, we had filed an injunction request direct release of the electricity, for which there was an order passed and also there was an execution instituted. And for that also they disconnected the water supply on 19. Based on that, we requested them, we gave them the order copy that there is already an execution order. Thereby, you should not disconnect the water and electricity supply as the person is pending before the Honorable Supreme Court. We get told I am not a party in the earlier proceeding, so it is not applicable. Thereby, we filed another injunction suit asking this court to direct them to restore the water.
Yes.
I run a beauty parlor there. electricity and water supply are the most important things to me.
Yes, we can find out that the frustration of the landlord by disconnecting that water connection.
My lord, this submission that in 2019 vendor had disconnected cannot be true because I have purchased it in 2012 itself. There is no purpose. I do not understand this particular submission that in 2019 that there was a decree. There is no such decree.
Yes.
But most importantly, in terms of procedure of law, my lord, a memo for disposal of suit as infructuous is used to pass a decree against me. It is not an unequivocal admission that yes, I agree.
Where is that memo?
That memo, exact verbatim, I have reproduced. Page 6. Verbatim. It is a part of the trial court records, but verbatim I have produced.
Yes, later they have filed a photograph showing that it is not.
Then it ought to have gone for a trial.
Have you filed objection to that memo?
It was on
Then
this.
why, if there you are not disputed, then court has taken that as pass in a degree.
My lord.
Now that you can't.
May I please? On a memo by itself, there cannot be orders. That is the law. There has to either be an application. On a memo by itself, there cannot be orders. This is memo to say that the suit is infructuous. It is purely, I understand, a point of law. But where someone goes to the court and says that dismiss the suit for infructuous, second part accept madala.
No. It is for the court whether it is dismissed. But we have admitted that you are disconnected. When that party has admitted, they need not go for a trial.
My lord.
What is the issue has to be framed when you are admitted that yes, I have disconnected?
Well, I have not disconnected. It is for replacement of damaged pipes.
Court is also not have taken that action against you that you are disconnected. Now water connection has been restored. Since they have filed a memo that still it is not restored, court said that if it is not restored, you this thing, because you have not disputed that no, I will not restore and all. You are admitted. Therefore, court has decreed that nothing wrong in that.
My lord, in view of that, I concede to this court and I only say, by passing the order in this, let there just be an observation. My lord may kindly record that that order pertains only to that memo, not for any future.
Future you want to discuss?
I do not want to, my lord. I do not wish to. I will not.
Yes.
That is not at all my intention. The last 3 years, they are still there.
Yes.
Fortunately, I have been able to renovate the building.
Yes.
And I am earning my rents. This
No, all that liberty cannot be, Mr.
But a decree against me, my lord, on a memo that was meant to for dismissal ge nan hakiro memo na nan against decree ಆಗ್ಬಿಟ್ರೆ, that is the point where I am.
This degree is, where is your plaint?
I have not produced it along with the nan bari judgment hakide because RFA.
Where is the plaint? What they said when it is disconnected and all. This degree for restoration only in respect of that pleading in the plaint. It cannot be saying that till there this thing. Where is the plaint? This is the plaint. Or with objection to what?
That they cannot be entertained, Lordship, because the liberty has been given to me. I have clearly stated facts, Lordship. Earlier, how and when they had disconnected the electricity and water supply.
No, what is this you are producing? This is filing an objection now to that this appeal or this appeal. You serve a copy to him.
Yes. Just now.
Yes, next week. Go to that next submission. Yes. Yes, you file it in that office. Yes. Learned counsel for the appellant place 2 weeks time.
Our respondent objection ಆಗ್ತಾರ.
No, they are giving that objection. You want to go through or you want to argue here only? Yes. The net counsel for the appellant place 2 weeks time to learned counsel for the respondent has filed an objection. Learned counsel for the appellant place 2 weeks time to. Serial number is 46. Filed an objection. 46. One of e case yakri 2020 in the pending ಇದೆ. What is there in that matter for? I thought that it is recent matter.
I came to the court immediately.
Yes, I thought that 2024 matter. Yes, filed an objection to IA 1 of 2019. Learned counsel for the appellant prays 2 weeks time to use this matter after 2 weeks.
Much obliged.
47. Again,
What's your date?
Bharat, yes.
My lord, advocate is not very well. Next week,
At the request of counsel for the appellant, use this matter next week.
48. Abhinav Ramanand here for appellant.
I am for the respondent number 18 in this case, my lord.
Yes, what is this, Mr.?
My lord, the suit pertaining to series case, all are suits for bearing injunction. 40 suits came to be dismissed by the trial court for want of title. There is a serious dispute title regarding the title and possession and also identification of the property in question. But somehow connected matter admit ಆಗಿದೆ some stay ಇಲ್ಲ ಯಾವ್ದಾದ್ರು.
Yes. Then we'll admit this also.
Please.
There is other side. And appear for the appellant list next week.
Achha.
Manjunatha essay for appellant. Dheeraj Hegde.
For specific performance. Yes. It is great. Specifically denied the execution of sale agreement by contending that sale is related to money. But another connected matter respect of another portion between same parties. This honorable court coordinate bench of this honorable court has granted stay in RFA number 803 of 2022.
Why 2 appeals?
2 appeals, there are 2 different agreements and 2 different portions.
In respect of same party.
Same parties. As far as legal judgment is concerned, Mila,
Yes. Yes, Mr. We'll admit it. Connected matter is yes. Out. A bit. Yeah. Segment and degree. It 8 October 2019. Passed by Senior Civil Judge JMFC Pavgada in OS number 1 7 of 2017. The next date of hearing. 6 weeks time is granted to file a paperwork.
Another portion for appellant, government advocate.
Yes. Password. Yes, password. Yes, Mr. Password. Yes.
51. Ranjana Muli for appellant.
Yes. Request with this matter next week.
52. Chandrasekhar Reddy for appellant. Prakash Ahmed.
2 weeks time, my lord. Yes. Taken by the
Rejectment. The suit is degraded. Yes, Mr. Then. Yes, next week. Verify if you are vacated that premises, then nothing will. Yes. Use this matter next Wednesday.
53 absent. Serial number 54, Pallava for appellant, Ramesh HN.
The trial court followed on the, even without there being a finding as regards interference.
If what?
Permanent injunction.
You are the plaintiff.
Because the defendant.
Yes.
Defendant, my lord, the plaintiff filed a suit against me, I'm the adjacent owner, site number 5.
Yes.
Site number 4. Filed the suit, my lord, on the ground that he is the owner in possession of the property, suit scheduled property, and there is interference from my side. But I do not deny the title. I say I have no interference. I only take up the stand that, my lord, 20 feet of land, my lord, in his property has gone to formation of road. So therefore, he is taking advantage of that fact. He's trying to encroach upon my property, and there's no interference from my side. But the trial court holds that, my lord, decrease the suit. There being no specific finding on the interference aspect of the matter. Trial court, my lord, relies on the endorsements, police endorsement, that is after the suit was filed. He produces 2 endorsement, police complaint endorsements, which complaints were filed after the suit was filed. The trial court relies on such endorsements and decrease the suit. There being no specific finding on interference, whether there was really any interference. Title was not denied, possession was not denied.
Yes.
Only question is as regards whether there was any interference from my side.
Yes.
The trial court, my lord, holds in para number 19 of the impugned judgment. Examination of BW1 is admitted that the parking of JCB is forthcoming in Exhibit P6. Further admitted that the property where the JCB was stationed belongs to the plaintiff. Further admitted that he being a Jeep from the defendant. Motion number 920 of 23 against the plaintiff. P67 is certified copy of the plaintiff. But where both the plaintiff and defendant clear that the property claimed to the plaintiff and defendant are adjacent to each other, but these are having separate numbers and identification. Voluminous documents produced by the plaintiff shows that the property so purchased by her is measuring 30 to 40. That apart, nothing is placed by the defendant to show that the property acquired by the plaintiff is enclosed by the GBFT for widening them. This being the state of affairs, the law laid out the aforesaid cited issues are aptly applicable to the case on endorsement. This endorsement was filed after the suit was filed by the plaintiff. The endorsement issued by the police probabilizes that the defendant, without having any manner of right title or
issue notice.
Notice is already issued. He's on caveat.
Serial number ಎಷ್ಟು ಇದೆ? 54. Yes. Any interim order granted earlier?
Interim order ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ. caveat ಹಾಕೊಂಡಿದ್ದು ಈಗ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ.
Yes. Is the only respondent. Caveator is directed to appear for respondent. Parties are directed to maintain status quo in state of hearing. Yes.
55, Gautam Sridhar for appellant.
This matter would have to be tagged with RFA 1714 of 2014. The same common.
Well, this is main appeal is there. This is a
This is a cross objection. Main appeal is in RFA 1714, 2014.
2014.
It was earlier an order of delinking. I'm not sure why that order.
No, that appeal is dismissed.
No, my lords. Then subsequently it was restored, my lords, because the paper book is also filed in that matter.
Nodi ಅದು stage ನೋಡಿ. Also will verify. What
Well, my lords, I just verified, my lords. I verified now.
It is pending.
It's pending. my
Order
lords.
is recalled.
The order is recalled. I verified it now. I'm sure.
Yes. Then my office is dealing the order.
Because probably at that point of time, my lords, it was dismissed for non-prosecution.
When it is recalled.
Lords, the order recalling it was. Recalling it was 19/1/23.
19/1/23. Yes, before that it has dealing. Learned counsel for the appellant submits that this class objection may be called along with that so on.
Formal notice may have to be.
No, other, who is that part advocate? He may directed to take notice. Advocate is notice. Will director to take notice and tag with the tag with yes. Director notice. Kumar and who are that? The first is the defendant. There, Savitrama has filed the suit.
Savitrama represented through. I just ascertain that.
No, we'll see who is that counsel. Will. For whom? Savitrama. Who is appearing for Shashi Kumar? No, then we'll issue notice. Yes. Issue notice. Leave this matter along with the sounds.
Great.
Number 1, Harish N for appellant.
Yes, Harish. Also.
2, number of present.
Also.
Number 3, K. Mohan Kumar.
We put it. Maybe Harish. Spite of granting opportunity for 8 times to comply office objection. Office objections are not complied with. 13/2/2024, when the matter is called, none appear for the appellant. In morning session, even afternoon session, there is no representation. Learned counsel for the respondent is present. Directed to release this matter on 14/2/2024 at the top of the list under the caption for dismissal. Even today, when the matter is called in the morning session, none appear for the appellant. Counsel for the respondent is present. Afternoon session, when called second time, none appear for the appellant. It appears that appellant is not interested in prosecuting this appeal against dismissal.
Number 4, Injunction for appellant.
Also.
Number 5, CH10.
Yes, Taraknath. Also.
Number 10, Naveen J.M. for appellant. Number 12, Sumati X for appellant.
Also.
Number 14, Kumar I.S. for appellant. Number 19, Deepak B for appellant. Number 19, Deepak.
Also.
Number 23, Veerabhadraya for appellant. Number 23.
Also, sir. None appear for the appellant. Week's time is granted to do the needful.
Number 24, K. Chandrasekhar for appellant.
Appear for the appellant. Week's time is granted to do the needful.
Number 30, Prasanna VR for appellant.
230 day. 230.
Number 35, Ravindra Prasad Singh for appellant. Sampath A.
On complaints of the office objection, 7th time verification specified when none appear for the appellant. Each time is granted to do the needful. Jurisdiction of Ida, our password, yes, password.
Number 43, government advocate for appellant, Chandan.
Yes. But some other matters is there.
But any other day, but first he's arguing in quota number 1. He will come, 4 to the date. Another 10 minutes, 15 minutes.
Yes.
Then
Yes, Monday. Monday or Tuesday.
Sir, kindly wait.
I have passed over twice. Either I have to wait for him or he has to come.
I'm sorry, Lord, I'm not saying that.
Once I have given a passover.
I understand.
Is it not?
I understand. One request.
Any other date, if you are convenient, you ask that. Any date if you want. Monday, Tuesday. Tomorrow, day after tomorrow, don't want. May not be sick day after tomorrow also. Monday?
Day is fine.
Monday? Yes, leave this matter on Monday.
Yeah.
Interim order granted earlier is extended till next date of it. It's understanding that on only application for vacating.
Yes.
Not on main, yes.
Yes, please.
Then 600. In fact, recovery suit.
Yes.
Decree only on the ground that the 130 proceeding where it has been convicted.
Yes.
Same time, Your Lordship, the trial court has failed to consider that conviction order was set aside and is acquitted the criminal appeal. And absolutely there is no agreement, Your Lordship. As and the court gives a finding that there is no written agreement and he has not produced any document
Yes.
to show that he has done the work of data entry for a period of April 2011 to August 2011. Only relying on the
Yes, you take notice, there is a delay.
Lordship, only one submission, execution petition has been filed and warrant has been issued to the.
You take hand summons, there are 624 days delay.
No, only one submission, Your Lordship. I may be subject to the condition that I would deposit some amount.
No, that you-
7,36,000.
What is that reason for delay in filing that appeal?
I produced the medical, there was a pandemic, COVID pandemic, and I was suffering from
When-
lung infection. That is along with the application, delay application. I produced a whole document, Your Lordship, for reason.
Yes.
And he's with the follow-up treatment.
Hmm.
And he is suffering with bronchitis and lung infection.
Hmm.
Not in a position to move around also, Your Lordship,
Yes.
because of the infection.
Hmm.
And moreover, Your Lordship, the decree was passed on 6/3/2021.
Hmm.
And there was a COVID pandemic. It was there, Your Lordship. So that is up to 22 March and that was up to June, it was extended.
Hmm.
With and only reason is that on the medical ground, Your Lordship, I couldn't find the appeal.
Yes. What is there in the 23 and 24?
That is with the follow-up treatment, Your Lordship. It's a 4/4/20. I have produced the page number 63, Your Lordship. 3923,
Hmm.
4/4/23.
Yes.
And even, Your Lordship, the January also, he still is under treatment, Your Lordship.
Yes. That is all that lung infections and all.
Yes.
It will not come in that way to file. It will be there for entire this thing. They can't file an appeal at all.
No,
That is
no,
not. See,
Only
whether if he is admitted to that hospital or if it is unable to walk,
I
then
don't-
it's
Your Lordship,
that
I
is nothing is there. Take an X-ray.
Your Lordship,
Anyhow, you take that hand summons to that party.
that's
Because
only
2 years after appeal is filed,
only one submission is that, Your Lordship. With the
what is that amount, digrital amount?
30,660.
You deposit entire amount.
Lordship, entire amount it was 50% also because he's under treatment, he's under medication only, he's spending so much and he's not in a position to move around also. That is the only.
7,32,000. You deposit if there is any delay. If there is no delay, I could have said 50%. If there is a delay, 2 years.
But only
delay.
my humble submission is that because they have issued a warrant, Your Lordship. That is the only reason. I mean,
That's why you come now. All this problem you have suffered has gone only after warrant has been issued.
I have given history of medical.
I have seen that. What is there? X-ray, taking any X-ray and all.
Not X-ray, Your Lordship. That is.
This is not the reason. If you want, I will pass an order on IA itself.
No, I
You deposit entire amount. If there is a delay,
Patient.
when is that execution petition?
29, 29th of last, it was posted, Your Lordship, January 29.
Next date,
Next date, Your Lordship, I'm not.
we'll get that next date, we'll verify.
The warrant is.
Pass out.
Warrant is there, Your Lordship, so only for that.
No, execution of the warrant that they have given a date.
That is what, Your Lordship, that is the reason
Very
I, 29/1, that is, Lordship, I would place it on record.
What is the next date is fixed for hearing, madam? Execution.
29th was the dated, further date I just.
29/1 is that warrant has been issued.
Yes.
After that, what is the date? Also, we verify.
That Your Lordship.
2:30.
For appellant, government advocate.
Yes.
The students were admitted to the.
50. Yes. What is this, Mr.?
It is a suit for recovery fraud of the plaintiff. Certain students were admitted to the appellate institution for the education in the institution of the appellant, my lord. The fourth respondent had undertaken to pay the requisite fee that would be chargeable in respect of all the students. Not initially only 25% of the fees was paid. However, remaining 1,36,320 rupees was the balance from the fourth respondent, my lord. My lord, the fourth respondent paid to make out
On which course? Fine arts.
Fine arts.
Fine arts. That student fees will be bear by the government.
That is what the communication made by the fourth.
Then why you have approached that civil court?
Not despite repeated request, my lord, the fourth.
You have a remedy under 226.
Please, my lord.
It's an easy. Why that going to that civil court? To seeking an mandamus or non-payment of this thing. If there is a government order, that has to be placed and file in a writ and seeking for a direction. What is the document to show that it is a duty of the government to pay that? No, you may request, but where is the obligation on the state?
My lord, who requested to admit the students, my lord.
Is there any government order?
My lord, it is a fourth respondent is the.
Or any request madly, unless there is a government order, it is a public money, they can't give it.
Recommendation, the admissions were given to the students.
Or if there is no such this thing, government order, why do you want to, who is responsible? Go and recover from fourth respondent. If he has assured. You go and recover from fourth respondent if he has assured. Why you have made that state government 1 to 3?
It is on the.
What is that fourth respondent has stated?
That based on the order of the government, may not, he had made a recommendation for.
Where is the government order? Put ಈಗ ಯಾರು ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಯಾಕೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ? ನಿಮ್ಮ ಲಾಯರ್ ಇರಲ್ವಾ? ಎಲ್ಲ ಕೋರ್ಟೇ ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಬೇಕು ಸರ್ಕಾರದವರಿಗೆ. Yes, nobody is represented, Mr. You have an I think ನಿಮ್ಮ ಇವ್ರು ಇರ್ತಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಯಾರು Government advocate, yes.
In fact, part payment was made on the approval of the government itself.
Where is that? ಇಪ್ಪತ್ತೊಂದನೇ ಸಾಲ ಮೊದಲ ವರ್ಷದ ಬಿಎಪಿ ಪದವಿಗೆ ಸಹ
Even the checks issued may not, checks issued by the
ಪಡೆಯಲು ತಾವು ಅಲಂಕರಿಸಿದ ಬೋಧಿಸಿ ನೀಡುತ್ತ ಅನೇಕ ಬಾರಿ ಒಂದು ಅಂಕೆಗಿಂತ ಸಂಖ್ಯೆ ಸೀಮಿತ ಸಂಖ್ಯೆ ತಪ್ಪುವಂತ ನಮ್ಮ ಸಪ್ಲಿಕೆ ಬಾಕಿ ಉಳಿದಿರೋ ಹಣವನ್ನು ಸಾಧನೆ ನೀಡಿದಂತೆ ಇತಿಹಾಸ. ಇದು ನೀವು ಬರ್ದಿರೋದು ಲೆಟರ್ ಅಲ್ಲ, ಅವರು ಅಕಾಡೆಮಿಯವ್ರು ಬರ್ದಿರೋದು. Where is that government order?
not the payment was received but from the
What is
government.
the finding of the trial court? Whether that plaintiff proves that Prabhu Lalita Academy was existence. Seven. Yes, Mr. Read, para 27.
Expanding the areas of admission be approved.
Except this, no other document produced and finished show that he has given an admission to the student for the purpose of BFA as per that plaintiff government. The plaintiff should prove that request of the fourth respondent he has admitted for a course graduation academic year. Out of the set, students were disqualified. Ultimately, 117 admissions. The plaintiff did not produce any admission receipt or the admission register extract about student is academic. Produce any document to show that student has paid the 25% of the admission. ಏನು ಇಲ್ಲ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಡ್ಮಿಷನ್ ಆಗಿರೋದನ್ನಕ್ಕೆ ದಾಖಲಾತಿ ಇಲ್ಲ. This is all, it appears to be false claim.
No, my lord, admissions have been made based on.
You are not produced any document. The 243 students of the course 2011, out of set 14 students were disqualified. 177 students got admission for the academic year 2011. Plaintiff didn't produce any admission receipt or the admission register. Admission ಆಗಿರೋದಕ್ಕೆ ದಾಖಲಾತಿ ಇಲ್ಲಲ್ರಿ. Thing is there, Mr.
Same thing is there, page number 31. The plaintiff failed to prove that the both defendant paid only 25% of the fee, remaining 75% of the fee towards the academic year 2011. Further, the plaintiff failed to prove that he has sent the answer sheets to defendant for defendant.
Not, it has been issued by the Karnataka.
ಅಲ್ಲ ಯಾವ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ is there any rules that you government will pay that this thing ಏನಿದೆ? That is the main basic. If there is an obligation of the government, then whether you are admitted the students and all, we can verify. Yes. When do you want? Next week? Yes, at the request. It is matter next week.
Matter. Chair number 56, 57, 58, adjourned. Chair number 59. Prasanna VR for apparent. Girisha V. Chair number 59.
Yes, Prasanna. Yes. What time? It has been ಇದು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
ಇದಕ್ಕೆ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಮಾತಾಡಿದ್ವಿ. ಇನ್ನೊಂದು MFA ಇದೆ. ಮತ್ತೆ ವೈಫ್ ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಮೇಲೆ ಹಾಕಿರೋದು ಆಫ್ ಶೇರ್ ಬೇಕು ಅಂತ ಸೆಟಲ್ಮೆಂಟ್ ಇದಾಗ್ತಾ ಇದೆ. ಅಪ್ರೋಚ್ ಮಾಡಿದ್ವಿ ನಾವು. ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಏನಿದೆಯೋ ಬಡ್ಡಿ ಏನಿದೆಯೋ ಅದು 9 lakhs ಇದೆ, ಅದನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಪ್ರಿನ್ಸಿಪಲ್.
You are the plaintiff.
ನಾವು
Suit is decreed. 10 ಲಕ್ಷ ಏನಕ್ಕೆ ದುಡ್ಡು ಟ್ರಾನ್ಸಾಕ್ಷನ್?
ರಿಲೇಟಿವ್ಸ್.
Yes, madam.
Okay, sir. Referring the matter to mediation center.
Want referring that mediation center? Who has filed this memo?
ಸೇರಿ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಬಟ್ ಅವ್ರ ಕಡೆಯವ್ರು ಏನೋ ಬರೋದಿಲ್ಲ.
ಅರ್ಲಿಯರ್ ಮೀಡಿಯೇಷನ್ ಹೋಗಿತ್ತು. ಮೀಡಿಯೇಷನ್
ಎಲ್ಲಿ?
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ ಅಥವಾ
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ
ಆಗ್ಲಿಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ಆಗಿರ್ಲಿಲ್ಲ.
Why it is failed? Report ಬಂದಿದೆ.
10,26,000 ಅಮೌಂಟ್ ಅವರು ಮನಿ ರಿಕವರಿ ಕೇಳ್ತಾ ಇರೋದು. 6 lakhs ಅಂತೇಳಿ ಬಂತು. ಆಮೇಲೆ ನಮ್ದು ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಅಲ್ಲಿ ಒಂದು ಫ್ಲಾಟ್ ಇದೆ. ಆ ಫ್ಲಾಟ್ ಅನ್ನು ಅವರಿಗೆ ಬಿಟ್ರೆ ನಾವು ಎಂಟೈರ್ ಅಮೌಂಟ್ ಅನ್ನು ಬಿಡ್ಬೇಕು ಅಂತೇಳಿ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಅದರಲ್ಲಿ ಫೇಲ್ಯೂರ್ ಆಯ್ತು.
ಏನು why that flats is also comes this a family member?
Husband and second appellant is the wife of the plaintiff. ಆಮೇಲೆ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದು ಡೈವೋರ್ಸ್ ಆಗಿದೆ ಅದ್ರಲ್ಲಿ. ಬಟ್ ಮನಿ ರಿಕವರಿ ಸೂಟ್ ಉಳ್ಕೊಂಡಿದೆ.
ನಿಮ್ಮ ವೈಫೇ ನಿಮ್ಮಿಂದ ದುಡ್ಡು ತಗೊಂಡಿದ್ದಾರಾ?
ವೈಫ್ ತಗೊಂಡಿದ್ದಾರೆ, ತಂದೆಗೆ ತಕ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತೇಳಿ ಅವರ ಕ್ಲೇಮ್.
Claim that has been proved. Prove ಆಗಿದೆ. 10,26,000. ನೀವು ಎಷ್ಟು ಕೊಡಕ್ ರೆಡಿ ಇದ್ರಿ?
ಅವ್ರು ಕೊಡ್ಲಿಕ್ಕಲ್ಲ, ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ಇರೋದಾದ್ರೆ
ಫೈನಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ. No, that degree it is you are the plaintiff who has. Yes. Now you have agreed for how much?
ಫ್ಲಾಟ್ ಅಲ್ಲಿ ಆಫಿಷಿಯಲ್ ಅನ್ನು ಬರಬೇಕು ಅಂತ ವೈಫ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ. ಈ ಫ್ಯಾಕ್ಟ್ ಏನಂತಂದ್ರೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಪೇಡ್ ಬೈ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದು MFA ಅಪೀಲ್ ರಿಟರ್ನ್ ಆಗಿತ್ತು. ಯಾಕಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಬರೋದಿಲ್ಲ ಅಂತ ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿತ್ತು. ಅಪ್ಲಿಕೇಶನ್ ಕ್ಲೈಂಟ್ ರಿಟರ್ನ್ ಆಗಿತ್ತು. ಅದ್ಮೇಲೆ MFA ಪೆಂಡಿಂಗ್ ಇದೆ.
One time. Please. At the request of counsel for the respondent. Please this matter next week.
Number 61, Madhukar Deshpande, K. Yashoda for appellant, R.S. Ravi.
Yes, Mr. Much faster. Next week. Or I don't think afternoon some other 2 matters are there. Next week. I want wait. Yes. Is this matter? Next week.
Monday.
26. Yes, leave this matter on 26th.
22, Sanjana Tariga, K. for appellant, Devi Narasimha.
This is so for cancellation of the sale deed, the appellate report was the building. Paper book is almost ready. Within 2 days, I will file the paper and also requested my learned friend that I will be requesting for time. By 22nd, within 2 days, I will file the paper.
What is that matter?
Suit for cancellation of the sale deed. And for injunction, suit came to be dismissed.
Yes. Who came to be dismissed?
Yes.
Why? You are not ready?
No, now I am not ready. I am requesting the court because paper book also may be required.
Yes, sir. The request of the parties. Use this matter of 2 weeks.
My lord, 22nd.
Second,
27.
28. 28. Use this matter on 28. Yes, use this matter next week.
Badrinath, for appellate, Manjunath,
Badrinath. Here, use this matter next week.
Nataraj for appellate, MD, all of that.
Respond also is filing written argument.
Yes, Mr. What is this?
Please. So defense appeal. Was filed. Seeking for injunction.
Yes.
For the plaintiff, there were different members of neighbors. Allegation was made.
Suit for
injunction.
where injunction?
Where injunction.
Yes.
Of Schedule B property.
Yes.
Measuring not to the extent of 4 feet into 28 feet. Ingade 4 feet to Ingade 28 feet. But different plaintiff and defense notes of neighbors. Right, that notes this is not a slum area, initial note.
Yes.
Since not the BDM notes taken into consideration that all these persons were in possession of the property in Shantinagar. Notes to the respect of their possession notes, the BDA has granted them. Subsequently, notes lease was granted. Then subsequently notes, accordingly notes, sale deed was executed. But there is no dispute notes with the fact that sale deed was also executed by the BDA with plaintiff is concerned. With respect to Shirley property. And with respect to defendant also concerned notes, sale deed has been executed. But defendant courts, in order to put up construction, had demolished his portion of the property and had commenced notes the construction. In that course notes, when I put up underwater tank, steps put on further progress part of it. Notes the plaintiff went and obtained the injunction. Road extent notes, I stopped my construction. Then notes application was heard upon. Then the court injunction was made absolute in the course of a trial. Then notes I approached the Salva court notes in the MFA. Then the court suggested notes living apart. Because the construction would stop. Living apart the disputed portion, notes the court suggested to put up a further construction. Then accordingly notes leaving that portion, notes I put up a construction notes and construction is completed. Now it's the case of plaintiff that towards the southern side of the plaintiff's property, she had left it to an extent of 4 feet to 28 feet for the purpose of enjoying the below the air and the light. To the extent of that 4 feet to 28 feet, I in the course of construction demolished the portion and adjoining her wall.
Yes,
those
you have constructed.
That's the case. Friends, then notes I also cross-examined her. In the course of cross-examination, I put forth by saying that whatever the house that was allotted by the BDA, it stands still ಅಂದ್ರೆ ಹೌದು ಹಾಗೆ ಇದೆ ಅದು ಅಡ್ಜಾಯ್ನಿಂಗ್ ಅದನ್ನು ಗೋಡೆಗೆ ಅಟ್ಯಾಚ್ ಮಾಡಿ ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಹೌದು ಅದು ಹಾಗೆ ಇದೆ ಅಂತ ಬಿಟ್ಟು now notes the court felt that a commission should be appointed. Accordingly notes the CW commission was called upon to lead notes as a court evidence. Notes he then notes the assistant executive engineer for BDA. Notes he submitted a report by saying that I have encouraged the property to the extent of 428 feet adjoined, which was not according to him. I have it is. According to him, I have put up the steps portion over the wall of a plaintiff house on them. That's what he has submitted. Notes I also cross-examined him. that leads into notes of circumstances about accepting his report. But virtually, the court said, I accepted notes entirely the report of the court commissioner and gave notes the injunction.
What is wrong in that court commissioner's report?
It is the cross examination. CW1. Write that notes, just straight notes, evidence of PW1.
Page
note 26. Commences notes at page number 27.
Yes.
Participal.
Yes.
ನನಗೆ ಮರಿಲಕ್ಷ್ಮಿ ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದೋ ಹೆಸರು ಇರುವುದಿಲ್ಲ. ದಾವಾ ಮನೆ ಇರುವುದು ಸ್ಲಮ್ ಏರಿಯಾ ಅನ್ನುವುದು ನಿಜ. ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಬಿಡಿಎನವರು ನನ್ನ ಹೆಸರಿಗೆ ಪತ್ರ ಬರೆದು ಕೊಟ್ಟ ನಂತರ ಮತ್ತು ಸ್ವಾಧೀನ ಕೊಟ್ಟ ನಂತರ ನಾನು ಅಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆದರೆ ನಾನು ಅಲ್ಲಿ ಮೊದಲಿಂದಲೂ ಇರುತ್ತೇನೆ. ನನ್ನ ಮನೆಗೆ ಪಶ್ಚಿಮ ಬದಿಗೆ ಒಂದು ಕಿಟಕಿ ಇರುತ್ತದೆ. ನನ್ನ ಮನೆಗೆ ಪಶ್ಚಿಮ ಬದಿಗೆ ಒಂದು ಕಿಟಕಿ ಇರುತ್ತದೆ. ನನ್ನ ಗಂಡನ ಹೆಸರು ಅಬ್ರಾಹಂ. ನಾನು ಹಿಂದೆ ಪಾಸ್ಪೋರ್ಟ್ ಮಾಡಿಸಿದೆ. ನನ್ನ ಹೆಸರು ಮೇರಿ ಅಂತ ಇದ್ದು ಅಬ್ರಾಹಿಂ ನನ್ನ ಗಂಡನ ಹೆಸರು. ನಾನು ಕ್ರಿಶ್ಚಿಯನ್ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದವಳು. 1991ರಲ್ಲಿ ನನಗೆ ಬಿಡಿಎದವರು ಹಂಚಿಕೆ ಮಾಡಿದ್ದರೂ ಸಹ ಅದಕ್ಕಿಂತ ಪೂರ್ವದಿಂದ ನಾನು ಅಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. ಮನೆ ಕಟ್ಟಲು ನಾನು ಪರವಾನಗಿ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೋ ಹೇಗೋ ಅಂದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ, ನಾನು ಕಟ್ಟಿದ ಮನೆಯನ್ನೇ ಮಾಲೀಕರಿಂದ ಕ್ರಯ ಮಾಡಿಸಿಕೊಂಡಿದ್ದೇನೆ. ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟವರು ಯಾರು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಅಂದಾಜು 40 ವರ್ಷಗಳ ಹಿಂದೆ ಲಿನಿನ್ ಮೇಡಮ್ ನಿಂದ ಅದನ್ನು ಕೊಂಡುಕೊಂಡಿದ್ದೇನೆ. ಈಗ ನನ್ನ ಬಳಿ ಕ್ರಯಪತ್ರ ಇರುವುದಿಲ್ಲ. ನಾನು ವಾಸವಿದ್ದ ಮನೆ ಈಗ ಹಾಗೇ ಇದೆ. ನನಗೆ ನನ್ನ ಮುಂದೆ ಮತ್ತು ಹಿಂದೆ ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಜಾಗ ಇದೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ದಾವಾ ಆಸ್ತಿಯ ಚಕ್ಬಂದಿ ನನಗೆ ಹೇಳಲು ಗೊತ್ತಾಗುವುದಿಲ್ಲ. ಲಿಪಿ ಒಬ್ಬರಿಗೆ ಒಂದು ಕಿಟಕಿ ಬರುತ್ತದೆ. ನಮ್ಮ ಮನೆಗೆ ಒಂದೇ ಕಿಟಕಿ ಇರುತ್ತದೆ. ಬಲಬದಿಗೆ ಅಥವಾ ಎಡಬದಿಗೆ ಕಿಟಕಿ ಇರುವುದಿಲ್ಲ ಅನ್ನುವುದು ನಿಜ. ಬಚ್ಚಲು ಕೋಣೆ ಪ್ರತಿವಾದಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು ಅನ್ನುವುದು ಸುಳ್ಳು. ನಾನು ಪುನಃ ಹೇಳುತ್ತೇನೆ, ಬಚ್ಚಲು ಕೋಣೆ ಈಗಲೂ ಸಹ ಉಪಯೋಗ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಲಿಪಿ 9 ಮತ್ತು 12 ಇವುಗಳನ್ನು ಪ್ರತಿವಾದಿ ಕಟ್ಟಡ ಕಟ್ಟಲು ಪ್ರಾರಂಭಿಸಿದಾಗ ತೆಗೆಯಲಾಗಿದೆ ಅನ್ನುವುದು ನಿಜ. ನನ್ನ ಮನೆಯ ಗೋಡೆ ಹಾಗೆ ಇರುತ್ತದೆ ನೋಡಿ. ನನ್ನ ಮನೆಯ ಗೋಡೆ ಹಾಗೆ ಇರುತ್ತದೆ. ನನ್ನ ಮನೆಯ ಗೋಡೆಗೆ ಹೊಂದಿ ಆತ ನನ್ನ ಗೋಡೆ ನಿರ್ಮಿಸಿದ್ದಾನೆ. ನಮ್ಮ ಮನೆಯ ಬಲಬದಿಯ ಗೋಡೆಗೆ ಹೊಂದಿ ಕಟ್ಟಡ ಕಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು ನಿಜ. ನಮ್ಮ ಮನೆಯ ಹಿಂಬದಿಗೆ ಆಸ್ಪತ್ರೆ ಇದ್ದು ಆಸ್ಪತ್ರೆ ಗೋಡೆಗೆ ಹೊಂದಿ ನನ್ನ ಮನೆ ಕಟ್ಟಲಾಗಿದೆ ಅನ್ನೋದು ನಿಜ. ನನ್ನ ಮನೆಯ ಎಲ್ಲಾ ಗೋಡೆಗಳು ಮೊದಲು ಇದ್ದು ಹಾಗೇ ಇರುತ್ತದೆ ಅನ್ನೋದು ನಿಜ. ನಾನು ಬಿಡಿಎನವರು ಹಂಚಿಕೆ ಮಾಡಿದ ನಂತರವೇ ಮಾತ್ರ ಅಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇವೆ ಅನ್ನೋದು ಸುಳ್ಳು. ಬಿಡಿಎಯನ್ನು ಹಂಚಿಕೆ ಮಾಡಿದ ಆಸ್ತಿ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿ 15 ಅಡಿ ಇದ್ದು ಎಡಬದಿಗೆ 29 ಅಡಿ ಇದ್ದು ಬಲಬದಿಗೆ 27 ಅಡಿ ಇರುತ್ತದೆ. 1991ರಲ್ಲಿ ಹಂಚಿಕೆಯಾದ ಪೂರ್ವದಿಂದಲೇ ಪ್ರತಿವಾದಿ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿಕೊಂಡು ವಾಸವಾಗಿದ್ದ ಅನ್ನೋದು ಸುಳ್ಳು. ಬಿಡಿಎನವರು 1991ಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿಯೇ ಪ್ರತಿವಾದಿಗೆ ಆಸ್ತಿ ಹಂಚಿಕೆ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಸುಳ್ಳು. ನನ್ನ ಸೈಟ್ ನಂಬರ್ 9A ಇರುತ್ತದೆ ಮತ್ತು ನನಗೆ ಸಂಬಂಧವಿಲ್ಲ ಅನ್ನೋದು ಸುಳ್ಳು. ಪ್ರತಿವಾದಿ ತನಗೆ ಹಂಚಿಕೆಯಾದ ನಿವೇಶನದಲ್ಲಿಯೇ ಮನೆ ಕಟ್ಟಿಸುತ್ತಿದ್ದೆ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪ್ರತಿವಾದಿಯ ಮೇಲೆ ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡಿದ್ದೀನಿ ಅನ್ನೋದು ನಿಜ. ನಾನು ಮತ್ತು ಪ್ರತಿವಾದಿ ಆಗಾಗ್ಗೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದೆವು ಅನ್ನೋದು ಸುಳ್ಳು. ಶೆಡ್ಯೂಲ್ ಬಿ ಆಸ್ತಿಯನ್ನು ಪ್ರತಿವಾದಿ ಅತಿಕ್ರಮಣ ಮಾಡಿ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ ಅಂದರೆ ಸುಳ್ಳು. ಪ್ರತಿವಾದಿ ಬಿಡಿಎನಿಂದ ಹಂಚಿಕೆಯಾದ ಆಸ್ತಿಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ ಅನ್ನೋದು ಸುಳ್ಳು. ಪ್ರತಿವಾದಿ ಶೆಡ್ಯೂಲ್ ಬಿ ಆಸ್ತಿಯನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿ ಯಾವುದೇ ಕಟ್ಟಡ ಕಟ್ಟದೇ ಇದ್ದರೂ ಸಹ ನಾನು ಈ ಸುಳ್ಳು ದಾವ ಹಾಕಿದ್ದೀನಿ ಎನ್ನುವುದು ಶೆಡ್ಯೂಲ್ ಬಿ ಆಸ್ತಿ. ನಾನು ಪಡೆಯಲು ಮತ್ತು ಪ್ರತಿವಾದಿಗೆ ತೊಂದರೆ ಕೊಡಲು ಈ ರೀತಿಯ ಸುಳ್ಳು ದಾವ ಮಾಡಿದ್ದೇನೆ. Court commission is waiting. Number 43. It is her case that towards the southern side, she had left this Shakti property for the enjoyment of not which she had enlightened them. That's what the reading is. Now look at the court commission.
Northern side of the plaintiff property and northern
side of the defendant. 43. Veera Singh Naik. It's the executive here. By the order of this court, I have been appointed as a court commissioner of this social property. I have submitted my master along with the report. same report is marked as exhibit C1. Shantinagara Islam area. And the sketch as shown in exhibit D14 in respect of site number 9, that is my Penny's property, and also sketch shown by me in exhibit C1 or differs. Cannot verify the original sale deed in respect of site number 9 while executing the commission work. I also measured the property of defendant bearing number 9A. In the exhibit C1, I have not mentioned the measurement of the site number 9A. The common wall is situated in between site number 9 and 9A. Staircase is constructed on a very common wall, and that is the enclosed area. The staircase is constructed in order to reach 3 floors of the house of the defendant. The wall of site number 9A and 9 are situated adjacent to each other. What is in existence in site number 9? And the witness volunteers on the very wall, staircase is put up. It is false to suggest that there is no encroachment, and I have submitted false report. It is false to suggest that I have not issued any notice to defendant before executing property. False to suggest that I have submitted false report. Really, or he does not know what is exactly the site measurement of a rating. But still not see gives a report. And even according to him, there exists a common wall between the plaintiff and the defendant. And over that common wall, I have put up a staircase and that's what it is. But on the contrary, the plaintiff shows that the defendant's property and the plaintiff's property is entirely different. He has put up a construction because the cross-examination PW1 shows that our house exists as of today, the construction as it is, without any demolition.
See, our case is that whatever that wall it has there, beyond that wall there is a setback. That is their case. That setback you have encroached and you have put up a staircase attached to their wall. Therefore, the staircase has been encroached. That is
the commission report says otherwise. Commission report says that there exists a common wall between the plaintiff and defendant. Over that common wall, I have put up a staircase.
No, that is what now it appears to be a common wall because you have put up in a construction till that wall. Therefore, it's become a common wall.
Just
yes.
It's been marked. That is also joining the plaintiff wall because it's a slum area. There will be no blood.
Yeah, which photographs were exhibit B?
I also produced the photographs. Plaintiff also produced.
ಏನು ಗೊತ್ತಾಗ್ತಿಲ್ಲಲ್ಲ ಯಾವ್ದು ವಾಲ್ ಅಂತ different picture. There is no
none different evidence is one. ನಾವು ನೋಡಿದ್ರೆ ಆ ಸ್ಟೇರ್ ಕೇಸ್ ಇದ್ರದ್ದು ಅದು ಸ್ಟಾಪ್ ಆಗ್ಬಿಟ್ಟು ನಂತರ ನಾವು 3 floor ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ವಿ.
There, this is what this next to the staircase there is a wall.
That is plaintiff's property. That is
plaintiff property. The staircase which you have put up now, they are saying that it has been left out for a setback. That you have used it for a staircase. That is their case. That is your entire building is a new construction.
ಅದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಎಷ್ಟಿದೆಯೋ ಅಷ್ಟಕ್ಕೆ ನಾವು ಬಿಲ್ಡಿಂಗ್ ಹಳೆಯ ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಷ್ ಮಾಡಿ
ಈಗ ಇದರಲ್ಲಿ ನೀವು ಇದು ಕಟ್ತಾ ಇದ್ದೀರಾ ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ಟಕ್ಕೆ ಬಂದಾಗ ದೇರ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇರ್ ಕೇಸ್ ಇಸ್ ದಟ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಆಫ್ ದೇಮ್
ಎಕ್ಸಾಕ್ಟ್
ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಇಟ್ ಇಸ್ ಯುವರ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಯುವರ್
ಪುಟ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಅಂತಿಲ್ಲ ಬಿಲ್ಡಿಂಗ್ ಎಕ್ಸಿಸ್ಟ್ ಅಟ್ಯಾಚ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಇತ್ತು ನಮ್ಮ ಹಳೆ ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಷ್ ಮಾಡಿ
ವೇರ್ ಇಸ್ ದಟ್ ಸೆಟ್ ಬ್ಯಾಕ್ ದೆನ್
ಸೆಟ್ ಬ್ಯಾಕ್ ಇಲ್ಲ ಸರ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಆಲ್ ಸ್ಲಮ್ ಏರಿಯಾ ಅಟ್ಯಾಚ್ ಒಂದೊಂದು ಪ್ರಾಪರ್ಟಿನೂ ಅಟ್ಯಾಚ್ ಆಗಿ ಒಂದೊಂದು ಇದು ಮಾಡಿ
ವಾಟ್ ಇಸ್ ದ ಮೆಜರ್ಮೆಂಟ್ ಆಫ್ ದಟ್ ಪ್ಲೇಂಟಿವ್ ಪ್ರಾಪರ್ಟಿ
it is
as it measured from there to that this staircase if that is measured
commissioner appoint ಮಾಡಿ ಹಾಗೆ that's what is the commissioner
property measure ಮಾಡಿಬಿಟ್ರೆ ಗೊತ್ತಾಗೋದು
ಬಟ್ ಮಾಡಿಲ್ಲ commissioner just said ಕಾಮನ್ ವಾಲ್ ಮೇಲೆ ಕಾಮನ್ ವಾಲ್ ಇದೆ
ಈಗ ಹೋಗಿ ನೋಡಿದ್ರೆ what commissioner said is correct if you see this is a common
ಅಲ್ಲ ಕಾಮನ್ ವಾಲ್ ಇದ್ರೆ ಅವ್ರು ವಾಲ್ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾಕಂದ್ರೆ that's what the commission said
ಅಲ್ಲಿ ಅವರು ಲೀಡಿಂಗ್ ನಾನು ಅದಕ್ಕೆ ಯಾರು ಕೂಡ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಡ್ತಾರೆ ಸೆಟ್ ಬ್ಯಾಕ್ ಸೇರಿಸಿ ಕಾಂಪೌಂಡ್ ಆಗ್ತಾರೆ See, if you give the setback,
Please.
all that construction is that setback bittare, but compound will be the end of their river land. It is not after the compound there is any setback. But here his case is that after the compound there is a setback.
That's what it was very surprising.
No, therefore, one the remedy is that should have been measured. Measure ಮಾಡಿದ್ರೆ ಅವ್ರದ್ದು ಮೆಜರ್ಮೆಂಟ್ ವಾಲ್ಗೆ ಸ್ಟಾಪ್ ಆಗುತ್ತೋ ಅಥವಾ ಬಿಯಾಂಡ್ ದಟ್ ವಾಲ್ their property will come, then that is the setback.
ಮಾಡಬಹುದಾಯ್ತು, ಬಟ್ ಕಮಿಷನ್ ಇಸ್ ನಾಟ್ ಅನ್ಸ್. ಅದಕ್ಕೆ ನಾನು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ put my question. I have not measured I have not verified the original sale deed in respect to site number 9.
First issue is they have to prove that there is a setback left by the plaintiff beyond that compound wall.
Right.
ಅದು ಪ್ರೂವ್ ಆದ್ರೆ ಅವಾಗ ನೀವು ಅಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀರಾ ಅಂತ ಬರುತ್ತೆ. ಬಟ್ ಅದನ್ನ ಮೆಜರ್ ಮಾಡಿದಾಗ ಮಾತ್ರ ಗೊತ್ತಾಗುತ್ತೆ. ದೇ ಆರ್ ಗಿವಿಂಗ್ ಎನ್ ಎವಿಡೆನ್ಸ್. ಎವಿಡೆನ್ಸ್ ಯಾಕೆಂತಂದ್ರೆ ಈ ಸೆಟ್ ಬ್ಯಾಕ್ ಎಲ್ಲ ಕೊಟ್ಟಿರೋದು ಈ ಕಲ ಸ್ಲಮ್ ಅಲ್ಲಿ ಏನ್ ಸ್ಕೆಚ್ ಇರಲ್ಲ ಏನಿರಲ್ಲ.
ಸ್ಕೆಚ್ ಇರಲ್ಲ, ಆಮೇಲೆ ಸೆಟ್ ಬ್ಯಾಕ್ಸ್ ಇರುತ್ತೆ. ಎಕ್ಸಾಕ್ಟ್ಲಿ ಒಂದೊಂದು ಬಿಲ್ಡಿಂಗ್ ಅಟ್ಯಾಚ್ಡ್ ಆಗಿ ಇನ್ನೊಂದು ಬಿಲ್ಡಿಂಗ್ ಇದೆ.
ನಾನು assuming that it is not a setback, but their measurement. They have been allotted some extent. What is that extent? ಅವ್ರಿಗೆ ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಅಲಾಟ್ ಆಗಿರೋದು? What is that extent? Tell me.
East west 29 plus 27 by 2 and north to south 15 feet.
ಆಯ್ತ್ರಿ, ಅವ್ರ ಮನೆ ಎಲ್ಲ ಐತ್ರಿ, ನಿಮ್ದು ವಾಲಿಂದ ಆಚೆಗೆ there is no house at all. ಮನೆ ಏನಿದೆ ಅವ್ರದ್ದು?
In between ಪಕ್ಕದ
ನಿಮ್ದು
ಅದೇ
ಇಲ್ಲೆಲ್ಲಿದೆ? ಇಷ್ಟೇ ನಮ್ಮ ಮನೆ. ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್?
ಅದನ್ನ 15 feet east to west 29 plus 27 by 2 north to south 15 feet. ಅಂದ್ರೆ 15 ಅಡಿ ಮುಂದೆ, ಇದಕ್ಕೆ ಹೋಗ್ತಾ 27 ಅಡಿ.
ಎಷ್ಟು 15 ಅಡಿ ಇದೆಯಾ ಅಲ್ಲಿ ಮುಂದೆ?
ಇದೆ.
Where is that entrance?
ಅಲ್ಲಿ ಡೋರ್ ನಾವು ಇವಾಗ ಅದು ಬಿಲ್ಡಿಂಗ್ ಲೆಫ್ಟ್ ಸೈಡ್
ಅಲ್ಲ, ಅವರು ಈ ನಿಮ್ ಸ್ಟೇರ್ ಕೇಸ್ ಪಕ್ಕದಲ್ಲಿ ಕಾಂಪೌಂಡ್ ಇದೆಯಲ್ಲ, ಅದು ಅವ್ರು ಹಾಕಿದ್ದ?
ಕಾಂಪೌಂಡ್ ಇಲ್ಲ,
ಕಾಮನ್ ವಾಲ್, ಹಳೆ ಕಾಮನ್ ವಾಲ್ ಮೇಲೆ ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಮನೆ ಪಕ್ಕದಲ್ಲಿ ಒಂದಷ್ಟು ಜಾಗ ಬಿಟ್ಟಿದ್ರಿ ನೀವು?
ಜಾಗ ಬಿಟ್ಟು ಕಾಮನ್ ವಾಲ್ ಇತ್ತು, ಕಾಮನ್ ವಾಲ್ ಮೇಲೆ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ದಾರೆ, ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ರಿಪೋರ್ಟ್ಸ್.
ಕಾಮನ್ ವಾಲ್ ಯಾರು ಹಾಕಿದ್ದು?
ಕಾಂಪೌಂಡ್ ವಾಲ್ ಹಳೇದಿತ್ತು ಸ್ವಲ್ಪ.
That is not your case is you have constructed a house. ನಿಮ್ಮ ಕಾಂಪೌಂಡ್ ಇರ್ಲಿಲ್ಲ, ನಿಮ್ ಮನೆ ವಾಲೇ ಲಾಸ್ಟ್, ನಿಮಗೆ ವಾಲ್ ಇಂದ ನಿಮ್ದು ಸ್ವಲ್ಪ ಜಾಗ ನೀವು ಹೇಳೋದು ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟಿದೀವಿ ಅಂತ. ದಟ್ ಇಸ್ ದೇರ್ ಕೇಸ್. ಈಗ ಅದಕ್ಕೊಂದು ವಾಲ್ ಹಾಕಿ ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ತಾ ಇದೀರಿ
ಅಂತ. ದಟ್ಸ್ ವಾಟ್ ಸೇ. ಸೆಟ್ ಬ್ಯಾಕ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರು ಸೆಲಿಡ್ ಎಲ್ಲ ಬರ್ಬೇಕಾಗಿತ್ತು, ಅದು ಇಲ್ಲ.
ಯಾಕೆ ಅವ್ರೇನು ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಹೌಸ್ ಪರ್ಚೇಸ್ ಮಾಡಿ?
ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಹೌಸ್
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
ಏನಿಲ್ಲ. ಒಂದೊಂದು ಪ್ರಾಪರ್ಟಿ ಸ್ಲಮ್ ಆಗಿರೋದ್ರಿಂದ ಒಂದೊಂದು ಪ್ರಾಪರ್ಟಿ ಅಟ್ಯಾಚ್ಡ್ ಆಗಿ, ಈಗ ಅವ್ರ ಗೋಡೆ ಪ್ಲಸ್ ನಮ್ ಗೋಡೆ ಅಟ್ಯಾಚ್ಡ್ ಆಗಿದೆ. ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಮ್ಮ ಪೋರ್ಷನ್ ಏನಿರುತ್ತೆ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ನಮ್ಮ ಹಳೆ ಪೋರ್ಷನ್ ಬಿಲ್ಡಿಂಗ್ ಹೇಗಿರುತ್ತೆ ಅದ್ರ ಮೇಲೆ.
ಹಳೆ ಪೋರ್ಷನ್ಸ್ ಬಿಲ್ಡಿಂಗ್ ಪಿಕ್ಚರ್ ಇದೆಯಾ? ಫೋಟೋಸ್
ಇಲ್ಲ, ನಮ್ದೇನಿಲ್ಲ.
ಅದಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಎರಡು ನಿಮ್ದು. ಇಫ್ ಇಟ್ ಈಸ್ ಅಟ್ಯಾಚ್ ಟು ದೇರ್ ವಾಲ್,
ಅದನ್ನ ಕ್ವಶನ್
ನಿಮ್ದು ಅವ್ರದ್ದು ಮನೆ ಮಧ್ಯದಲ್ಲಿ ಏನಾರ ಗ್ಯಾಪ್ ಇದ್ರೆ ನಾವು ಯು ಆರ್ ಡಿಮಾಲಿಶಿಂಗ್ ಅಂಡ್ ಟೇಕಿಂಗ್ ಎನ್ ಅಡ್ವಾಂಟೇಜಸ್ ಆಫ್ ದಿ ಗ್ಯಾಪ್ ಟು ಬಿ ಕವರ್ಡ್.
ಅದಕ್ಕೆ ಮುಪ್ಪತ್ತಿಯಲ್ಲಿ ಒಂದೇ ಕಿಟಕಿ ಇತ್ತು, ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಇದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ. ಇವಾಗ ಅದನ್ನ ಎಂಜಾಯ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನ
ವಾಲ್ ಹಾಕಿದ್ ನೋಡಿದ್ರೆ ಅವ್ರಿಗೆ ಎಲ್ಲಿ ದೇರ್ ಇಸ್ ನೋ ವಿಂಡೋ, ನಥಿಂಗ್, ದೇ ಕಾಂಟ್.
ಇಲ್ಲ. ಹಾಗಾದ್ರೆ ವೇರ್ ದ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ನೋಟ್ಸ್ ಎಂಜಾಯಿಂಗ್ ದ ಫ್ರೆಶ್ ಏರ್ ಅಂಡ್ ಲೈಟ್ ಫ್ರಮ್ ದ ಸದರ್ನ್ ಸೈಡ್.
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ನೀವು ವಾಲಯ ಮತ್ತೆ ಈ ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ಟಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರದ್ದು ಗೋಡೆಗೆ ದೇರ್ ವಾಸ್ ಎನಿ ಓಪನಿಂಗ್ ಆರ್ ವಿಂಡೋ?
ಇಲ್ಲ, ಏನಿಲ್ಲ. ಅವ್ರೆ ಕಾನ್ಸೆಪ್ಟ್ ಪಿಡಬ್ಲ್ಯೂ ಒಂದು
ಆಯ್ತು, ಅವ್ರು ವಿಂಡೋ ಬಿಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾವು ದಟ್ ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಯು ಹ್ಯಾವ್ demolished entire house and reconstructed.
Of my house, and I obtaining permission from the building commission ತಗೊಂಡು
ಇದಕ್ಕೆ ಪ್ಲಾನ್ ಇರಲ್ವಾ ನಿಮ್ದು?
ಇದೆ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ.
Where is that plan?
ಇದೆ
only after measurement it can be final.
ಇಲ್ಲ, ನಾವು ಅದನ್ನ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ನೋಡಿದ್ರು ಕೂಡ ಇಟ್ ಶೋಸ್ ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಅದನ್ನ ಅವ್ರು ಏನು ಬಾತ್ರೂಮ್ಗೆ ಅಂತ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಕೂಡ ನಮಗೆ ಅದನ್ನ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಅದನ್ನ ಫೀಸ್ ಎಲ್ಲ ಕಟ್ಸ್ಕೊಂಡು ದಟ್ ಇಸ್ ಮಾರ್ಕ್ ಆಸ್ ಎಕ್ಸಿಬಿಟ್.
ಈಗ ಎಕ್ಸ್ಟೆಂಟ್ ಮೆಸರ್ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಡಿ, ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ದೇರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಮೆಸರ್ಡ್. ಇಲ್ಲೊಂದು ಪಿಂಕ್ ಕಲರ್ ವಾಲ್ ಕಾಣಿಸುತ್ತಲ್ಲ, ಅಲ್ಲಿಂದ ಇವ್ರದ್ದು ಮೆಸರ್ಮೆಂಟ್ ಆಗ್ಬೇಕು. ಇವ್ರದ್ದು ಮೆಸರ್ಮೆಂಟ್ ಇವ್ರದ್ದು ಎಷ್ಟು, ಅದು 13 ಮುಂದೆ 15 ಅಡಿ. If it is 15 feet come to this common wall, then they have no case. If it is comes to the 12 feet, then you are encroaching, this staircase belongs to them. That is the only solution.
The court commission notes before reading evidence.
Court commissioner measurement directions ಮಾಡಬೇಕಿತ್ತು, to measure that properties and submit a report. ಗೊತ್ತಾಗಿರೋದು ಯಾರ್ಯಾರ್ದು ಪ್ರಾಪರ್ಟಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಎಷ್ಟೆಷ್ಟಿದೆ ಅನ್ನೋದು ಗೊತ್ತಾಗುತ್ತೆ. Somebody has a shortage, then you are having a more passage, then you are encroached. That is simple.
ಅದಕ್ಕೆ ಅವರಿಗೆ ಅವ್ರ ಸೈಡ್ ಇಡು ನಮ್ಮ ಸೈಡ್ ಇಡು ಎರಡು ತಗೊಂಡ್ಬಿಟ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ then the solution would have been meted out. But without any this thing notes, he blindly goes and says that there is an encroachment. Even ಅದನ್ನ ರಿಪೋರ್ಟ್ ನೋಡ್ಬೇಕು.
Yeah, the sketch is exhibit in respect of the site is also sketch shown by the differ. What is that exhibit D14 sketch?
Sketch it is. That is what the media section.
Not verified the original sale date. Let him verify and examine. You produce that original sale date in consonance with the sale date. He has to measure and submit a report.
Exactly. Still, our the sale case measurement is here.
I will send it back and direct the court to appoint the commissioner and find out that measurement and submit a report. After parties to produce that sale deed.
But even the court has also observed, since notes I already put up a construction, if there is any chances of not settlement between the parties, they can go ahead and
ನೀವೇನಾದ್ರೂ ಅವ್ರಿಗೆ ಏನಾರ ಸ್ವಲ್ಪ ಕೊಟ್ಟು ಏನಾರ ಮಾಡಿ
ಅದನ್ನ ಆಫರ್ ಮಾಡಿದ್ವಿ. ಯಾಕಂದ್ರೆ ನಾವು ಅಫ್ಕೋರ್ಸ್ ಸ್ಟೇರ್ಕೇಸ್ ಬಿಟ್ಬಿಟ್ಟು ನಾವು ಅದನ್ನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಸ್ ಕಂಪ್ಲೀಟೆಡ್. ಬಟ್ ದೇರ್ ಎಕ್ಸಿಸ್ಟ್ ನೋಟ್ಸ್ ಆನ್ ದ ಬಾಟಮ್ ವಾಟರ್ ಟ್ಯಾಂಕ್. ಹಾಗಾಗಿ ಅವ್ರಿಗೆ ಏನು ಬೇಕಂದ್ರೆ 4 feet into 28 feet.
ಆಯ್ತು, ನಿಮ್ದೇ ಜಾಗ ಅಂತಾನೆ ತಿಳ್ಕೊಂಡು ಯು ಕ್ಲೈಮ್ ಸಮಥಿಂಗ್ ಅಂಡ್ ಯು ವಿಲ್ ಗಿವ್ ಇಟ್ ಅಂಡ್
offer was made.
ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್?
ಇಲ್ಲ ಅದನ್ನ she was not personally there was some arrogance notes between the plaintiff and the defendant. ಹಾಗಾಗಿ that could not be meted out.
No, that you advise your clients, Mr. No purpose will serve. She can take that because
counsel is not willing.
ಈಗೇನಾದ್ರೆ ಸರ್ವೆ ಮಾಡಿದಾಗ ಆ ಕಾಮನ್ ವಾಲ್ ಇಂದ ನಿಮ್ದು 15 feet ಐತೆ ಅಂತಂದ್ರೆ ನಿಮ್ಗೆ ಏನೂ ಬರಲ್ಲ. ನಾಟ್ ಪೇ ಎನಿಥಿಂಗ್. ನೌ ದಟ್ ಕೀಪ್ ಇಟ್ ದಟ್ ಆಸ್ ಅಂಡರ್ ಅ ಸಸ್ಪೆನ್ಷನ್. ಮೇಬಿ ಹಿ ಹ್ಯಾಸ್ ಎನ್ಕ್ರೋಚ್ಡ್. ವಾಟ್ ಎವರ್ ದಟ್ ಬೆನಿಫಿಟ್ ಹಿ ವಿಲ್ ಗಿವ್, ಯು ಟೇಕ್ ಇಟ್.
ಕಾಮನ್ ವಾಲ್ ಮೇಲೆ ಸ್ಟೇರ್ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ
ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಈಗ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ನಿಮ್ದು 15 feet ಕಾಮನ್ ವಾಲ್ ಇಂದ ಒಳಗಡೆನೆ ಇದ್ರೆ ಯು ಕಾಂಟ್ ಕ್ಲೈಮ್ ದಟ್ ಬಿಕಾಸ್ ಯುವರ್ ರೈಟ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ದ 15 meter. ಅವರು ಏನ್ ಮಾಡಿದಾನೆ, ನೋಬಡಿ ಹ್ಯಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಸೇಲ್ ಡೀಡ್. ಅವ್ನು ಅಲ್ಲಿರೋ ಪಿಕ್ಚರ್ ನೇ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ನೋಡ್ದ ಹೇಳ್ದ ಅಷ್ಟೇ. ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಮೆಜರ್ಡ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ. ಅದಕ್ಕಿಂತ ಮತ್ ಹೋಗಿ ಮತ್ ಮಾಡಿ ಅದಕ್ಕಿಂತ ಯು ಸಿ ದಟ್.
ಇಲ್ಲ, ಅವರು ಸ್ಕೆಚ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಸಲ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರಿಂಗ್ ನೋಟ್ಸ್ ಹ್ಯಾಸ್ ಮೆಜರ್ಡ್ ಮೈ ಸ್ಕೆಚ್, ಮೈ ಪ್ಲಾನ್. ಅದಲ್ಲೂ ಕೂಡ ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ತಾವು ನೋಡಿದ್ರೆ very same person notes has given the
now that only problem is measurement ಅಷ್ಟೇ.
measurement ಅಷ್ಟೇ.
ಇದನ್ನೆಲ್ಲ ಸ್ಕೆಚ್ ಮಾಡಕ್ಕಿಂತ ಅವ್ನು ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಮೆಜರ್ ಮಾಡಿದ್ರೆ ಆಗೋದು.
ಫ್ರಂಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಎಷ್ಟು ಪೋರ್ಷನ್ ಬರುತ್ತೆ
15 feet ಫಸ್ಟ್ ಅವ್ರದ್ದು ಅಳತೆ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು 15 feet ಕಡಿಮೆ ಇದೆ ಅಂತ ಅಂದ್ರೆ then you have encroached it. If it is 15 feet, then there is no encroachment. It is not his plaintiff property. You might be encroach somebody's property, it is different, but it is not a plaintiff property. ಅದ್ರ ಬದಲು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ರಿ ಸುಮ್ಮನೆ. ವೇರ್ ಇಸ್ ದಟ್, ಹೂ ಇಸ್ ಕೌನ್ಸಿಲ್? ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಿದೆ? 60. You advise him to
is not valid.
or I will refer to that mediation. Is it possible? ಯಾಕಾಗಲ್ಲ?
ಅದು ಅವ್ರವ್ರಿಗೆ ಗೊತ್ತಿದೆ.
Why they are relatives?
ಇಲ್ಲ ಬೇರೆ
Total item. ಈ ಡೋರ್ ಇದೆಯಲ್ಲ, ಇದು ನಿಮ್ ಪ್ರಾಪರ್ಟಿನಾ? ಇಷ್ಟೇ ಅವ್ರದ್ದು?
ಸ್ಟೇರ್ಕೇಸ್ ಇರೋದು ನಮ್ದು.
ಅಲ್ಲ, ಇದ್ಯಾವುದೋ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆಯಲ್ಲ, ದಿಸ್ ಇಸ್ ದಟ್ plaintiff front portion. Site number 9 ಯಾರ್ದು?
Site number 9 plaintiff.
Plaintiff.
Plaintiff. Site number 9A the defendant.
9A.
9A.
ಇದು ಏನಿದು? Site number 8 is somebody's ಅಲ್ಲ? They have measured. Here the 11 feet. Yeah. 38 feet. See that some they have the report is says that it has been measured.
The exhibit C1 and the commission report.
C1 ಅಲ್ಲಿ
C1.
what they have given a measurement. Encroached portion has been find out.
Encroached portion ಕೊಡ್ತಾರೆ. But without looking into
ಅಲ್ಲ ಈ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದಾಗ ಹೌದು ಸೈಟ್ ಈ ವಾಲಿಗೆ ಬಿಫೋರ್ ದಟ್ ಕಾಮನ್ ವಾಲ್ ಇಟ್ ಕಮ್ಸ್ ಟು ಶಾರ್ಟೇಜ್ ಆಫ್ ಇದು 11 ಅಡಿ 4 ಇಂಚ್ ಬರುತ್ತೆ 3 ಅಡಿ 8 ಇಂಚ್ ಇಸ್ ದ ಸ್ಟೇರ್ ಕೇಸ್ combine both then it will comes to that is 15 feet that has been done. Therefore it has been said that you have encroached.
Cross-examination ಅಲ್ಲಿ but without looking into
ಇಲ್ಲ but it is there is no dispute that it is in 15 feet 15 feet measure ಮಾಡಿದ್ದಾನೆ 15 ಇದು ಅಲ್ಲಿ ಇಲ್ಲ ಅಲ್ಲಿ ಅವ್ರ ಮನೆ ಇರೋದು 11 and half including staircase it comes to that 15 feet. Then he said you have encroached that 3 feet.
Then notice this is taken without issuing notice to defendant. Then he admits it.
You have not disputed that.
I disputed.
I have filed an objection to that commissioner report.
ಅದಕ್ಕೆ cross examination ಮಾಡಿ.
Commissioner report ಗೆ objection ಹಾಕಿಲ್ಲ ನೀವು.
But cross examination ಮಾಡಿ.
Cross examination ಮಾಡೋದು different. You have to file an objection to the commissioner report. Are not accepting because this is wrong. You better settle. Otherwise, ಆಯ್ತು ಏನೋ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇರೋದನ್ನೇ ನೋಡ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿಕೊಟ್ಟು ಶಿ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಅದು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ತಗೊಂಡು ಶಿ ಕ್ಯಾನ್ ಲಿವ್ ಬೆಟರ್ ಲೈಫ್ ಸಿ ದಟ್ ದೇರ್ ಆರ್ ಪೂರ್ ಪರ್ಸನ್ಸ್ she can take that value of that property anyhow that she can't extend their house ಅವಳಿಗೆ ಈ ದುಡ್ಡು ಕೊಟ್ರೆ at least it should be useful for advising. These are all small slum idaವೆ.
How some slum?
ಎಷ್ಟು ಆಫರ್ ಮಾಡಿದ್ರಿ ನೀವು? You see that what is the market value and all. Let us see next when he is coming.
After 22nd.
23rd. 23rd. It is not around 23rd. Yes, Mr. Sinu. Serial number 67. Not ready? Yes, sir. The request of counsel for the appellant. Read this matter next week.
Number 68, Saravana is for appellant, considered matter, Alesha Anandi.
60?
68.
The respondent. Where is that Sarwan? Next week. And appear for the appellant. Use this matter next week.
Number 69 and 70 adjourned. ಏಜ್ ಒಂದು ಬರ್ಬಿಡಿ ಸರ್ ಅಷ್ಟೇ. ಏಜ್ ಒಂದು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಬರ್ಬಿಡಿ ಅಲ್ಲೇ ಏಜ್ ಒಂದು ಬರ್ಬಿಡಿ. ಸಾಹೇಬ್ರು ಏನ್ ತಿಳ್ಕೊಂಡಿದಾರ, ನೀವೇ ಅಪೋನೆಂಟ್ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ ಸಾಹೇಬ್ರು. ಆರ್ಡರ್ ಎಲ್ಲ ಪಾಸ್ ಆಗೋಗಿದೆ. ಈಗ ಆರ್ಡರ್ ಬೇಕಾ ಮಾಡ್ಕೊಂಡು ತಿರ್ಗಾ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ. ಈಗ ನೆನ್ನೆ ಯಾಕೆ ಹೇಳ್ತೀರ ನೀವು? ಏನು ಬರಿಬಿಡಿ, ಏಜ್ ಒಂದು ಓವರ್ ರೈಟ್ ಮಾಡ್ತೀವಿ. ಫೋಟೋ ಬಂದ್ಬಿಟ್ಟಿದೆ. ನೀವೇನು ಹೇಳಿದ್ವಲ್ಲ ಸಾಹೇಬ್, ನಾನು ಹೇಳಿ ಅವ್ರ ಅಪೋನೆಂಟ್ ಅಲ್ವಂತೆ. ಅನ್ಕೊಳ್ತಾರೆ 2 ನಿಮಿಷಕ್ಕೆ. ಇಲ್ಲ ಊಟ ಮಾಡ್ಕೊಂಡು ಬಂದು ಮಾಡ್ಕೊಡಿ. ಸರಿ.
Yeah.
Court officer. Court officer ಅವರೇ.
ಸರ್ ಹೇಳಿ ಸರ್.
ಈಗ ಈ ಲಾಸ್ಟ್ ಅವರ್ ಮ್ಯಾಟ್ರೇ ತಗೊಳ್ಳೋದಾ?
ಹೌದು ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ವೆಯ್ಟ್ ಮಾಡಿ, ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಚೇಂಜ್ ಆಗುತ್ತೆ, ವೆಯ್ಟ್ ಮಾಡಿ. ನಮ್ದು ರಿಸರ್ವ್ ಆಗಿರೋ
ಮೆಮೊ ಹಾಕಿನೂ ಆಗ್ತಾ ಇಲ್ವಾ?
Number one.
Yes. First matter. Huh? First matter. ಅಲ್ಲಪ್ಪ ಹೊಸ ಮ್ಯಾಟ್ರ ಅಥವಾ ಹಳೆ ಮ್ಯಾಟ್ರ? 28ನೇ ಮ್ಯಾಟ್ರ್ ಈಗೇನು ಅರ್ಜೆಂಟ್ ಇದೆ? ಆಯ್ತು, ನೀವು ಸ್ಟೇ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಈಗೇನ್ ಕೊಡಕ್ ಬರ್ತದಪ್ಪ? ನಾಳೆ ಆದ್ರೆ day after tomorrow, yes.
Part one matter, serial number one, Harish M for appellant, Sunil Kumar HN.
Paso.
Serial number two, Channa Basappa HN.
Paso.
Serial number four, C.H. Kunti Petimat.
Paso.
Serial number five, C.H. Dwarakanath for appellant.
Yes, Dwarakanath.
Serial number 10, Naveen J.N. for appellant.
Yes, Paso.
Serial number 12, Sumati S. for appellant. Serial number 14, Kumara L. for appellant.
Yes, Paso.
Serial number 19, Deepak B. Serial number 19.
Yes, Paso.
Serial number 30, Ratana VR for appellant, Krishnamurthy P. Archagar.
Please, my lord. I am for the respondent.
Yes, Mr. Krishnamurthy, what you want?
Please, before I forget, one submission I would like to make. For appellant, Lakshmana has died about 7 to 8 months back. I don't know why it has not been informed to the honorable court.
Yes.
And surprisingly, this IA number 1023 or additional documents is
filed by him only.
ಅದು ಯಾವಾಗ ತೀರಿದ್ದಾರೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ಕ್ಲೈಂಟ್ ಅವ್ರಿಗೆ ಪಾಪ ಅವರೆಲ್ಲ ಈಗ ತ್ರೇತಾಯುಗದ ಹನುಮಂತ ಆಗಿದ್ರು, ಒಳ್ಳೊಳ್ಳೆ ಕುಸ್ತಿ ಪಟುಗಳು. ಈಗ ದ್ವಾಪರ ಯುಗದ ಹನುಮಂತ ಆಗಿದ್ದಾರೆ, ವಯಸ್ಸಾಗಿದೆ. ನಾನು ಫೋನ್ ಮಾಡಿದಾಗ ಅಂದ್ರು ಫಸ್ಟ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. IA ನಂಬರ್ 1/23 ಫೈಲ್ ಮಾಡಿದ್ದು ಅವರದ್ದೇ ಅಫಿಡವಿಟ್ ಇದೆ, ಲಕ್ಷ್ಮಣ. ಅದು ಯಾವಾಗ ತೀರಿದ್ದಾರೆ ಅಂತೇಳಿ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ಫ್ರೆಂಡ್
ನಿಮ್ ಪ್ರಕಾರ ಅವ್ರು ಯಾವಾಗ ತೀರಿದಾರಂತೆ?
ನಮ್ಮವ್ರು ಹೇಳೋದು 7-8 ತಿಂಗಳ ಹಿಂದೆ ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತೇಳಿ.
7-8 ತಿಂಗಳು ಹಿಂದೆ ಅಂತ ಅಂದ್ರೆ ಇದು ಆಲ್ರೆಡಿ 3 months ಬ್ಯಾಕ್.
ಹೌದು, ಐ ಡೋಂಟ್ ನೋ. ಅದು ಅವರು ಪಕ್ಕಾ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೋರ್ಟಿಗೆ ಕೊಡಬೇಕು, ಯಾವಾಗ ತೀರೋಗಿದ್ದಾರೆ, ಯಾಕೆ ಕೋರ್ಟಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಲಿಲ್ಲ.
ಎಸ್ ಪ್ರಸನ್ನ, ವಾಟ್ ಇಸ್?
I am not aware about the alleged fact that Lakshmana has died. But the affidavit is shown at Mysore.
It's shown at Mysore. He is from Mysore.
He is from Mysore.
Then maybe he was there on that day. Might have been dead. ಯಾಕೆಂತ
ಐ ಡೋಂಟ್ ನೋ. ಅದು ನಮ್ಮ ಫ್ರೆಂಡೇ ಹೇಳ್ಬೇಕು. ನಮ್ಮ ಫ್ರೆಂಡೇ ಹೇಳ್ಬೇಕು.
ಬೆಂಗಳೂರು ಆದ್ರೆ yes, doubt. I know how that advocates are doing.
We used to send the affidavit lot to get
No. Normal thing is,
yes,
whenever filed in Vakala, they will take that blank paper.
Nowadays, nobody will take such a risk.
Yes, now that it is sent it to the Mysore means,
yes,
maybe because lower court advocate will not have that signature and kept it ready. Maybe he was alive as on that day, but later he is dead. Now that
I am not aware.
He said that he is dead. Appeal may be abated in respect of first appellant.
So far as first appellant is concerned, appeal gets dismissed.
Yes.
And now so far as
if it is true.
If it is true, then an opportunity will be there not to file application for bringing legal aid.
ಅಲ್ಲ, ಲೀಗಲ್ ಏರ್ ಪ್ರಶ್ನೆ ಎಲ್ಲ ಬರ್ತದೆ. ಇದು ಸ್ಕೀಮ್
ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಸೂಟ್ ಅಲ್ಲಿ.
ಹೌದು,
ಅಪಲೆಂಟ್ ಅಂತ ಹೇಳೋದು ಅವರು. ಅಪಲೆಂಟ್ ಅಂತ ಹೇಳೋದು.
ಅಪಲೆಂಟೇ ಮತ್ತೆ ನಿಮ್ದು ಇವ್ರು ತಾನೇ ನೀವು.
Representative suit ಅವರು ಹಾಕಿರೋದು.
ನೀವ್ಯಾರು?
ಡಿಪೆಂಡೆಂಟ್.
I am claiming that notes I have been looking after the guarding notes and it is my father notes whose father was looking after the guarding.
LRC ಏನ್ ರೈಟ್ಸ್ ಐತೆ?
ಹೌದು.
ಒಬ್ರು
if the fact is right notes I may have.
ಎಲ್ಲಾರು ಬರಲ್ಲ. ಈಗ ಅದರ್ ಪರ್ಸನ್ಸ್ ಆರ್ ಆಲ್ರೆಡಿ ದೇರ್.
Yes.
ಅವರು LRC it is like in a public.
Opposed to.
ಪೋಸ್ಟ್ ಈಗ ಗರಡಿಯಲ್ಲಿ ಹೇಗೆ ಅಂದ್ರೆ ಗುರುಗಳು ಅಂತ ಇರ್ತಾರೆ. ಗುರುಗಳು ಅವ್ರ ಮಗ ಆತರ ಹೋಗೋದಿದ್ರೆ
ಆತರ ಇರಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
ಆತರ ಏನಿರಲ್ಲ. But he was in one of that regular this thing.
Yes.
If he's dead means it's gone. In
Now,
next.
lords, the attempt of the respondent is clear that two plaintiffs have died. Kindly see, two plaintiffs have died during the pendency of the suit. Then three plaintiffs remain. They have become the trustee. Now, lords, in collusion with Tahsildar, they wanted to retain the trust.
No, now there are other two appellants are there.
ಹೌದು. Now let me make my submissions on the merit.
Yes.
ಅದು ಈ ಕೇಸನ್ನು ನೋಡಿದಾಗ ಯಾರ್ದೋ ದುಡ್ಡು ಯಲ್ಲಮ್ಮನ ಜಾತ್ರೆ ನೆನಪಾಗ್ತದೆ. 1944 ನಮ್ಮ ಫ್ರೆಂಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿದ್ರು ಮಾಡ್ಲಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಒಂದು ಸ್ವಲ್ಪ
No. Now that what is your last occasion? It was been urgent only seeing that whether you have any objection for sending back with giving an opportunity, and that committee which has been constituted as per this court order, as per the degree, it will be continued. That committee is subject to the result of the suit. If he proves, then that committee will go. Otherwise, then if you say what is your
my submission is this Garadi was started in 1944. 100 ವರ್ಷಕ್ಕಿಂತ ಹಳೆಯದು.
Yes.
One Veerbhadraya ಅನ್ನೋರು he started and he established, and since then it is in existence for the welfare of ಈ ಕುಸ್ತಿ ಪಟುಗಳು ಅಂತಾರೆ, wrestlers. ಅವರ ಸಲುವಾಗಿ ಮಾಡಿದ್ದು. The learned judge, according to me, in the absence of defendant evidence, he has considered all the aspects, taken care to see that the interest of this Gardi is protected, and has passed a very considered judgment. Now, this defendant who filed the written statement, who cross-examined the plaintiff, despite about 25 adjournments, ಅದನ್ನೇ ನಾನು ತಮ್ಮ ಒಂದು ತೋರಿಸ್ಬಿಡ್ತೇನೆ. Kindly see the order sheet.
Yes.
ಆಮೇಲೆ ಒಂದು 2-3 ಸಬ್ಮಿಷನ್ ಹೇಳ್ತೇನೆ. If you feel that it is necessary to give one more opportunity, I will leave it to the honorable court. That will be subject to it. However, it is my duty to bring to the notice.
Yes.
Kindly see the order sheet. ಅದರಲ್ಲಿ ಬುಡದಿಂದ ಬೇಡ, 1-3-19 ದಯವಿಟ್ಟು ತಾವು ನೋಡಿ. 1-3-19.
Yes.
3-4-5 ಪೇಜ್ ಆಗ್ಬಹುದು.
Yes.
1-3, your lordship got it, my lord?
Yes.
Yes. Counsel for plaintiff present, defendant and counsel absent.
Yes.
PW1 present and fully examined. Counsel for plaintiff closes his side. Since the defendants have not filed any WS, their evidence is taken as nil. And then next page, 25-4-19.
That is not there. 24/5/19, 2019.
25-4-19.
No, it is only. Yes.
ಇದೆ ಎಡಗಡೆ.
Yes.
25-4-19. For cause and rejoinder, if any, 1/6/2019. And then next 1-6-19. Defendants and their counsel absent. Your lordship got it, Lord?
Yes.
Yes. ಅದು 4ನೇ ಬಾರಿಗಾಗದು. ನಾ ಇಲ್ಲಿ ಪೆನ್ಸಿಲ್ ದಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಟ್ಟಿದ್ದೆ. And then next page 29-6-19. Defendants and their counsel absent.
Yes.
Next page. Defendants and counsel absent for cross-examination on 29/8/2019.
Yes.
18-10-19. Defendants and both counsel absent. Next ಅದೇ ಪೇಜ್ ಅಲ್ಲಿ ಕೆಳಗಡೆ counsel for defendant praise time granted for defendant's evidence by 2/1/2010.
Yes.
20. I'm sorry. Next page. Counsel for defendant praise for time granted. Next allೇ ಕೆಳಗಡೆ Counsel for defendants 1 to 3, Srimati S.K. Advocate, filed memo of retirement. For appearance of defendants and the evidence finally by 7/2/2020. Next, defendants called out absent. No representation made on behalf of defendants. Sufficient time already granted. No grounds assigned to grant time. Hence, evidence of defendants taken as nil.
Yes.
And then counsel for defendant praise time granted finally. Next, defendants are the counsel absent. Next date, other party plaintiff number 4 present. Other parties and counsels absent. Next, ಆಮೇಲೆ SOP ಬಂತು ಈ ಕೋವಿಡ್ ಇಂದಾಗಿ ಒಂದು 2 ಪೇಜ್ ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಪೇಜು 11/9/20. Lordship got it, not?
Yes, yes, yes.
Yes. Amended plaintiff furnished heard the arguments of learned counsel plaintiff, issue notice to defendants, calling upon them to meet their at counsel and request their counsel to attend the court by next date. Then 14/9 and 23/9, notice to D to serve, called out, absent. Gone on for defendants' arguments by 6/10/2020. Adadmele. Next page, no representation for defendants. Again, adjourned. Defendant 1 to 3 absent. Their counsel absent, despite service of notice on defendant number 2. And then no representation for defendant number 1 to 3. Call on for arguments as last chance by 23/11/2020. And then no representation for defendants till 5:15 p.m. This case is posted today for arguments of defendants as last chance. Sufficient time is granted to defendants to advance arguments. It seems defendants are not interested in contesting the suit. Therefore, arguments of the defense is taken as heard. At this stage, one day limit pass ಮಾಡ್ತೇನೆ. In fact, it started with 164 of 2015. 15 miscellaneous case ಹಾಕಿ contest ಮಾಡಿ permission ಕೊಟ್ಟು ಆಮೇಲೆ 2018 ಅಂತ ಹೇಳಾಗಿದ್ದು ಇದು ತಾವೇ. And then peruse the order sheet. It reveals that though defendants 1 to 3 have appeared before the court through their counsel, have not advanced their argument. The court notice are also issued to defendants 1 to 3. One more opportunity is given to defendants 1 to 3 to advance their arguments. As it is a civil suit, opportunity has to be given to the defendants in the interest of promoting justice. Therefore, judgment is not passed today. Gone on for defendants' arguments, if any, as finally by 15/12/20. And then no representation for defendants. It seems defendants are not interested to advance in arguments. Hence, arguments of the defendant is taken as not advanced. Subsequently, judgment is pronounced. Now, despite all these adjournments, he did not adduce any evidence before the trial court. The learned judge, in fact, last time I was reading paragraph 20.
Yes.
Of the judgment. ಈ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಇದು ಪೇಪರ್ ಎಲ್ಲ ಸರಿ ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್. ಐ ವುಡ್ ರಿಕ್ವೆಸ್ಟ್ ಕೋರ್ಟ್ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಇರೋದನ್ನ ದಯವಿಟ್ಟು ನೋಡಿ. 5 issues and framed.
Yes.
Whether the plaintiff proves that the defendants indulged in illegal activities, including dismantling the suit property, that is Gardi, and converting the same into shop premises, and misusing the funds of Gardi for their own use. Whether the plaintiff proves that the defendants failed to render and make proper accounts in respect of suit property, that is Gardi. Whether the plaintiffs are entitled to seek for framing a scheme for proper management of Gardi by appointing trustees. Whether the defendants are liable to be restrained from converting the suit Gardi premises into commercial premises. This is according to their own documents. Samudaya Bhavan Samiti anta madkondo they constructed a building demolishing a portion of Gardi, and they say under the society's registration act, the registration has been granted, and mainly appellant number 3, that Surya Narayana, he has taken over charge, and he has been collecting rents from the shop premises, not even a paisa lekka yavadakku idu, despite the direction given in the decree, specific direction, iduvaregu no accounts have been furnished to the honorable court, trial court. And now, so far as facts are concerned, I don't think it is necessary, not necessary to read, because ನಾನು reasons portion ಓದಿದ್ದೇನೆ. ಆಮೇಲೆ ಇನ್ನೂ ಒಂದು ಪಾಯಿಂಟ್, ಈ ಎಕ್ಸಿಬಿಟ್ P14 ಅಂತೇಳಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಆ ಡಿವಿ ಎಂತದ್ದು ಡಿ ಹೇಳ್ತಾರಲ್ಲ, ಡಿಸ್ಕೋ ಡಿಸ್ಕೋ ಅದನ್ನ ಮೈ ಫ್ರೆಂಡ್ ಸೆಡ್ ವಿಥೌಟ್
ಇದ್ರ ಸಿಡಿ ಹಾಕಿದೀರಾ ನೀವು?
ಸಿಡಿ ಅದು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ನನ್ನ ಫ್ರೆಂಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು, ವಿಥೌಟ್ ಪ್ರಾಪರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂಡರ್ ದ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ದಟ್ ಈಸ್ ರಿಲೈಡ್ ಅಪಾನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ರಿಕಲೆಕ್ಟ್. ಆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು. Surprisingly, my friend has not noted that P14 is not marked at all. It is not relied upon at all. Yes. P10, P1 to P11 ವರೆಗೆ ಮಾತ್ರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು, ಮಾರ್ಕ್ ಆಗಿದ್ದು ಅಷ್ಟನ್ನು ಮಾತ್ರ learned judges referred. Yes. Kindly see in paragraph 16.
Yes.
ನನಗೂ ಆಶ್ಚರ್ಯ ಆಯ್ತು, P14 ಅಂತ ಹೇಳಿದ್ರೆ ರೆಫರೆನ್ಸೇ ಇಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡ್ಲಿಲ್ಲ.
ಹಾಕಿದ್ದಾರೆ, ಬಟ್ ಅದನ್ನ ಮೋಸ್ಟ್ಲಿ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿರ್ಬೇಕು, ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ ಅಂತ.
ಮಾಡಿಲ್ಲ ಅಲ್ಲ, ದಟ್ ಈಸ್ ಕ್ಲಿಯರ್ ಫ್ರಮ್ ದ ಜಜ್ಮೆಂಟ್ ತುದಿಯಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ, ಜಜ್ಮೆಂಟ್ ತುದಿಯಲ್ಲಿ
P11 ಅಷ್ಟೇ.
ಲಾಸ್ಟಿಗೆ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಎಷ್ಟೋ ಸಲ ಎಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್
ಬಿಟ್ಟೋಗುತ್ತೆ, ಬಟ್ ಇಫ್ ಇಟ್ ಇಸ್ ಮಾರ್ಕ್ಡ್ ಇಟ್ ಶುಡ್ ಬಿ ಇನ್ ದಟ್ ಎವಿಡೆನ್ಸ್.
ಹೌದು,
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಮಾರ್ಕ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು? ವಾಟ್ ಆರ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ಮಾರ್ಕ್ಡ್ ಅಂತ ಇರುತ್ತದೆ.
ಎಕ್ಸಿಬಿಟ್ P9 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
11 ವರೆಗೂ ಇದೆ.
ಇಲ್ಲ, P9 ಮಾಡಿದ್ದಾರೆ.
P9 ಏನು?
CD ಅಂತ ಇದೆ, CD ಫೋಟೋ, 5 ಫೋಟೋಗ್ರಾಫ್ ವಿತ್ CD ಫೋಟೋ.
P14 ಇವರು P14 ಅಂತೇಳಿ CD ಹಾಜರು ಮಾಡಿದ್ದಾರೆ.
P14 is the CD. Exhibit P11 photographs
ಅಂತೇಳಿ ಜಜ್ಮೆಂಟ್ ಅನ್ನು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮಾತ್ರ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಫೋಟೋಗ್ರಾಫ್ಸ್
ಹೌದು.
ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಲಾಸ್ಟಿಗೆ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 5 ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ examination chief, I have submitted my affidavit in lieu of examination chief. The contents of the affidavit are true and now I see the documents produced by me and they are marked as follows. Antondu table kodtare. Adರಲ್ಲಿ certified copy of 5 photographs with CD photo exhibit P9 ಅಂತ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಅದು ಮಾರ್ಕ್ ಮಾಡಬೇಕಾದ್ರೆ ಬರೀ ಫೋಟೋ ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. ಇದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ. Maybe an objection. Exhibit P14 ಅಂತ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ, but this has not been taken.
No.
Only P13 ವರೆಗೂ ಫೋಟೋಸ್ ಇದೆ.
P1 to P11 ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡಿದ್ದು.
P10 and P11
ಅಷ್ಟೇ.
P12 and 13 ಫೋಟೋಗ್ರಾಫ್ಸ್ ತಗೊಂಡಿಲ್ಲ, ಪ್ಲಸ್ ಸಿಡಿನೂ
ತಗೊಂಡಿಲ್ಲ. ನಾನು ಚೆಕ್ ಮಾಡಿದೆ ಅದನ್ನು. And para 16.
Yes.
Para 16. In support of his evidence, he has produced exhibit P1 to P11.
Yes.
The defendant's counsel cross-examined this PW1. It is elicited that it is defendant number 1. This is important. Our cross-examination, who is in possession of the receipts for having collected donation from the public towards the suit Gardi. This is stated by PW1 in the cross-examination that this defendant number 1, who is in possession of Gardi, having collected the donation from the public, he further volunteered that he does not possess any records to that because it is defendant number 1. So also he does not possess any records to show that defendant number 1 sold 50 iron balls and wooden glass. He was in complete management. He does not remember as to when exactly he made such a complaint, etc. He admits that in order to construct a commercial complex, permission from the corporation is required to be obtained. According to him, he has produced the documents before the court to show that such a commercial complex was constructed. It is their case also. He denied suggestion. No commercial complex was constructed over the space pertaining to the suit Gardi. He denied all others also to show that the suit scheduled property standing in the name of Gardi. Exhibit 1 is the certified copy of property issued by the Mysore City Corporation is produced. It shows that the said suit property still stands in the name of Gardi. Likewise, we find exhibit P2, the encumbrance certificate, which shows that it is standing in the name of Gardi only. some complaints have been filed by various interested public before the Commissioner of Mysore City Corporation on 3/11/2015, complaining about the act of the defendants of taking a decision to construct the commercial suit schedule property. These complaints show that in the year 1944, the said Gardi was established and there is an attempt by persons like Narayana, that is appellant number 3, and Ganesh. Instead of constructing Gardi, they are putting the commercial complex in the suit property. So these complaints have been marked in evidence from P3 to P7. Similar complaints have been submitted by all these persons named in the complaints. While marking these documents, no little finger has been raised by the defendants. Exhibit P8 is the certified copy of the invitation being produced by the plaintiffs to show that there was a foundation ceremony being arranged on 28/9/2015 between 9 to 10 a.m. And one V. Vasu, being the MLA of Chamaraj constituency, was to lay the foundation. The chief guest was one Srimati Shivanna, being the member of Mysore City Corporation. That means one thing is clear from these documents, that there was an attempt to put up construction in the suit schedule property, and to that effect, the residents of Nazarabad Mohalla and Bestageri Hattu Janagala Gardi are the persons who have arranged the said function. Exhibit P99 is the photograph to show the construction of building in the suit schedule property, and the under construction pictures are being produced by the plaintiffs. While marking these documents, no objection is raised. So also Exhibit P11. Exhibit P10 is a paper publication in Prajanudi where a public notice has been issued with regard to miscellaneous number 160, kindly noted, 164 of 2015. By filing this miscellaneous petition, permission was granted. And on perusal of these documents, the said suit schedule property standing in the name of Hattu Janagala Garadi, and the plaintiffs and other residents being the wrestlers used to perform the wrestling and used to do exercise in the said Gardi, as stated by the plaintiffs, is not denied by the defendants, either in the written statement and in the cross-examination. Now, by filing this suit, it is alleged by the plaintiffs that there is a mismanagement. The plaintiffs want to settle a scheme in respect of the said Gardi for proper management of the Gardi by appointed trustees. So also have sought injunction restraining the defendants from converting the Gardi premises into commercial premises, putting up shop premises in scheduled property, and call upon the first defendant to furnish the accounts to the court with respect to the public collection and rent received so far from the shop premises. To rebut the evidence placed on record by the plaintiffs, except the barred cross-examination, nothing is elicited from the mouth of this PW1. Now the plaintiffs want to create a trust consisting of trustees, and to administer the said trust, they want to form a scheme for proper management of the Gardi. Therefore, we have to see the origin of the concept of trust by reading the provisions of concept of trust as defined under the provisions of section 92 CPC. So far as the original concept of trust is concerned, religious and charitable trusts are found to exist in some shape or the other in almost all the civilized countries. Instincts of pity and benevolence, which are implanted in human nature, finds expression in religious and charitable trust. In Roman law, properties dedicated to gods formed a species of public aid. They were not the objects of ownership or transfer, and no action could lie in respect of them in a court of law. The only juristic person recognized in early Roman law was the state, but it was a public and not a private trust. The idea of a corporate body as a new subject to rights and duties distinct from all its members was fully recognized in Rome during the imperial period. In English law, there is something technical in the concept of trust, which had its origin in dual system of law and dual system of ownership, which came into existence in England under the peculiar historical and political conditions. Modern writers on the law of trust do not, however, by stress on the trustee having a legal estate or on his being the owner of the trust property. It is enough to constitute a person a trustee if he has control over the trust property or can exercise any powers in respect of the same, and there is a duty cast upon him to hold the property or exercise his powers for the benefit of other person or for the accomplishment of some particular purpose. As in Halsbury's laws of England, a trust has been defined as a confidence reinforced in a person with respect to property of which he has possession or over which he can exercise a power to the extent, to the intent that he may hold the property or exercise the power for the benefit of some other person or object. Under section 92 of CPC, the word trust has been used in a general and not in a restrictive sense. It connotes an obligation or duty attaching to a person in charge of properties dedicated to religious or charitable purposes, which could be enforced either in law or in equity. It is akin to that of a trustee in English law without any legal estate in the property which English trustee has got. The trust need not be expressed. It may be constructive as well. Therefore, this section refers to both express and constructive trust. A question comes to whom the trust property belongs, that is either to the trustee or the beneficiary. As between the trustees and the beneficiary, the law recognizes the truth of the matter. As between these two, the property belongs to the latter and not to the former. But as between the trustee and the third persons, the fiction prevails. The trustee is the owner of the trust property, the right of the beneficiary being in a proper case to call upon the trustee to convey to him. A trustee is not complete until the trust property is vested in trustees for the benefit of sestue trust. A trustee, no doubt, is a legal owner of the property. The beneficial ownership is the same vesting in the beneficiary. Merely because the property is vested in the trustee or the legal owner, trustee is not entitled to sell the same. He is not the full owner of the property in the sense of the term because there is a beneficial interest and the ownership therein carved out in the property. The Indian law does not recognize legal and equitable estates. By that law, therefore, there can be but one owner, and where the property is vested in a trustee, he is the owner. What a person does by creating a trust in respect of his own properties, appointing himself as the sole trustee of the trust, is to make a vesting declaration and not to make a gift of the property. Now the plaintiffs want to have a scheme for the proper management of the trust. A suit is filed under section 92 of CPC. It is a suit of special nature, which presupposes the existence of a religious or charitable character. Such a suit can proceed only on the allegation that there is a breach of trust. Such a trust or that such direction of the court is necessary for the administration thereof, and it must pray for one or the other reliefs that are specifically mentioned in this section. Thus, it is only when these conditions are fulfilled that the suit has got to be brought in conformity with the provisions of section 92 CPC. Already miscellaneous petition was filed before this court in miscellaneous 164 of 15, and the court has passed an order on 26/3/2018 granting leave to file the suit in a representative capacity, etc. Therefore, a suit for declaration of such property appertains to a religious trust may lie under the general law, but outside the scope of section 92 CPC. In a case of present nature, when a suit is filed under section 92 of CPC, as it is a suit of special nature, which presupposes the existence of public trust of a religious character, the Honorable Supreme Court of India, with regard to the trust, has laid down the law with regard to the legal possession in a judgment reported in a, that is a leading judgment, AI 1990 Supreme Court 444, in a case between Venugopal Naidu and others versus Venkarayalu Naidu, charities and others as under. The legal possession which emerges is that a suit under section 92 of the Code of Civil Procedure is a suit of a special nature for the protection of public rights in the public trust and charities. The suit is ನಾನು ಒಂದು ಸ್ವಲ್ಪ ನೀರನ್ನು ಕುಡಿಸ್ಕೊಳ್ತೇನೆ with your permission.
Yes.
Please. ಬೆಂಗಳೂರಲ್ಲಿ ಬೇಗನೆ ಸೆಕೆ ಚಾಲು ಆಗ್ಬಿಟ್ಟಿದೆ.
Yes.
The legal position which emerges is, I am obliged to the Honorable Court. The legal position which emerges is that a suit under section 92 of the Code of Procedure is a suit of a special nature for the protection of public rights in the public trust and charities. The suit is fundamentally on behalf of the entire body of persons who are interested in the trust. It is for the vindication of public rights. The beneficiaries of the trust, which may consist of a public at large, may choose two or more persons amongst themselves for the purpose of filing a suit under Section 92 of the Code. And the suit title, subtitle, suit title would only their names as plaintiffs. Can we say that the persons whose names are on the suit title are the only parties to the suit? The answer would be in the negative. The named plaintiffs being the representatives of the public at large, which is interested in the trust. All such interested persons would be considered in the eye of law to be parties to the suit. A suit under Section 92 of Code is thus a representative suit, and as such binds not only the parties named in the suit title, but all those who are interested in the trust. It is for that reason that explanation 6 to Section 11 of Code constructively bars by res judicata the entire body of interested persons from re-agitating the matters directly or substantially in issue in an earlier suit under Section 92 of Code. If the objects of 92 CPC is applied to the present facts of the case, as spoken to by PW1, there is a mismanagement of the administration of the said Gardi, which is not denied by the defendants. So, in the considered view of this court, as defendants have not led any evidence in the case, the adverse inference can be drawn against the defendants and accordingly is drawn. Therefore, in the considered view of this court, if all these factual features coupled with possession of law with regard to the scheme as defined under Section 92 of CPC is taken into consideration, it can very well be stated that defendants had indulged in the illegal activities in dismantling the scheduled property, that is Gardi, and are trying to convert the same into shop premises and thereby might have misused the funds for the Gardi for their own use. Therefore, it is a suit being filed by the plaintiffs for invoking the provisions of Section 92 of CPC, as the defendants have failed to render the proper accounts in respect of the scheduled property. Rightly, the plaintiffs have filed a suit. Question comes with regard to whether plaintiffs are entitled to seek for framing of a scheme for proper management of the Gardi, etc., by appointing trustees in view of mandate of Section 92 of CPC and also the law laid down by the Honorable Supreme Court. In the aforesaid judgment, it can be stated that the plaintiffs are entitled to seek for framing of a scheme for proper management of Gardi by appointed trustees. Therefore, so and so. Issue known as these issues are in nature with the findings on issue 1 and 3. In this case, PW1 has spoken by the defendant and also converting the suit Gardi into commercial premises. Therefore, it is meant for public purpose and all the wrestlers do exercise in the said Gardi since 1944 onwards. Therefore, that status of said Gardi has to be kept as it is. And the plaintiffs in this case have made up acceptable grounds to grant the relief of injunction against the defendants as prayed as ingredient Section 30 Civil Act have been complied with by the plaintiffs. Therefore, the plaintiffs are able to prove that the defendants are to be restrained from converting the Gardi premises into commercial premises, as the plaintiffs in this case have sought reliefs. In this case, in view of the findings on issue 1 to 3, plaintiffs are entitled for the relief. So, claim, therefore, so and so. And kindly see the operative portion, order that assumes importance because the subsequent conduct of the defendants, that shows that they are acting in violation of the direction issued by the Honorable Trial Judge. There shall be a scheme for proper management, etc. The Tahsildar Mysore Taluk is appointed administrator with a direction to appoint 5 trustees to have a proper management of the suit Gardi as prayed by the plaintiffs. This committee has been constituted. I have produced the document. The Tahsildar Mysore Taluk is further directed to appoint the trustees within 6 months from the date of decree by calling appropriate application from the public at large, by giving advertisement in daily Kannada newspaper and furnish having wide publication, select the trustees by conducting interview who are aspiring to become trustees. This has been done and the trust has been constituted. The trust deed has been duly registered also. 2 document ತಮ್ಮನ್ನು ನಾನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ ಮೊನ್ನೆ ಮೆಮೊದೊಟ್ಟಿಗೆ. Further, this is important. The defendants are restrained from converting the suit into commercial premises by putting up shop premises in the schedule. And then the first defendant is hereby directed to furnish accounts to this court within 3 months from the date of decree with respect to the public collection rent received so far from the shop premises and also submit periodical accounts. Idanna they have not done so far.
But first defendant is no more now.
How do now the present appellants, other two appellants.
No, but
Other two
direction is only against the first defendant.
Now, the other two appellants, they represent, otherwise, if they say that first appellant is the only person who was responsible, and then these two appellants cannot maintain the appeal at all because they
No,
say.
by seeing that direction, he alone has to give a furnishing that account. Court should have said respondent 1 and 2 has to furnish.
Liability should have been joined in several.
Now,
Ali, maybe he is the one person who has misusing. Therefore, direction has been given to only first defendant.
How? ಈಗ appellants ಈಗ ನನ್ನ submission appellant number 2 ಅವರು he is not interested. My instructions are that ಅದನ್ನ I am hesitating to say he has not signed the wakalat along with the wakalat first appeal.
Yes, Mr. Prasanna.
Anyway, I
Sufficient opportunity has been given. You have not given any.
Yes.
The entire judgment, but it is only a presumption. And an adverse inference has been drawn by the court.
Yes.
Why? Because in spite of providing sufficient authority, the evidence tendered by the plaintiff has not been rebutted.
Yes.
But the cross-examination part is sufficient to show that the plaintiff has not established the averments made in the plaintiff.
Where is that?
Cross-examination, the earlier notes I have read, notes, kindly see notes page number 16 of the paper book. Because it is a short cross-examination, it is sufficient.
Yes.
T1 is in possession of the receipts for having collected donations from the public towards this suit Garadi. The witness volunteers that I do not possess any records to that effect. If that is the case, what prevented the plaintiff requesting the honorable court?
ಆಯ್ತು ಬಿಡಿ ಈಗ ನಿಮ್ದು ಕಲೆಕ್ಷನ್ ಹೋಯ್ತು ಅವನೇ ಹೋದ್ರಲ್ಲ ಈ ಕಲೆಕ್ಷನ್ ಇಲ್ಲ ದುಡ್ಡು ಇಲ್ಲ. What about that you are constructing that? Yes.
Next, then I do not possess any records to show that the D1 sold 50 iron balls and wooden gadas. I had filed a complaint against D1 before Nazarabad police. I do not remember as to when exactly I filed such complaint. The witness volunteers that police had not initiated any action against the defendant number 1. No further action taken by the plaintiff to see that what is the fate of his complaint. If at all he was interested to maintain the property of the Garadi, he should have pursued it further. He did not take such an action. Then it is true to suggest that in order to construct a commercial complex, permission from the corporation is required to be obtained. I have produced the documents before the court to show that such a commercial complex was constructed. It is not true to suggest that no such commercial complex was constructed over the space pertaining to suit Garadi. There was a suggestion. Of course, it was denied. If that is the case, he should have brought to the record to show that by dismantling the Garadi space, they have put up.
That is what that he has produced that photographs and all.
Photographs have not been properly marked as per section 65. Kindly see, my learned friend notes has stated that CD has not been taken into consideration. But the certified copy issued to the parties, Lord, it is marked as notes exhibit P14. There are other 5 photographs also. Because notes the plaintiff had
Exhibit P14 is there. It is not that this thing CD.
Yes, it is a CD.
Yeah, really there.
This is the notes, so entire certified copy. ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಒಂದು ಫೋಟೋ ಇದೆ ಅಲ್ಲಿ 2 ಮಾತ್ರ ಅವರ ಕನ್ಸಿಡರೇಷನ್ 11 ಅಂತ
ಎಕ್ಸಿಬಿಟ್ P14 ಅಂತ ಮಾಡಿದ್ರು ಬಟ್ ಇನ್ ದ ಎವಿಡೆನ್ಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಮಾರ್ಕ್.
ಆಯ್ತು, ಎಕ್ಸಿಬಿಟ್ P11 ಅಲ್ಲಿ 2 ಫೋಟೋಗ್ರಾಫ್ ಕೊಡ್ತಾರೆ, ನೆಗೆಟಿವ್ಸ್ ಕೊಡುವುದಿಲ್ಲ. then it cannot be liquidated unless negative or pen drive or CD coupled with the certificate under section 65. ಎಕ್ಸಿಬಿಟ್ 11 2 ಫೋಟೋಗ್ರಾಫ್ ಮಾರ್ಕ್ ಆಗಿದೆ. ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಾದ್ರೂ ಕೂಡ there must it is an electronic document. But it is a printed generated from the computer. Therefore, photographs in the previous occasion before amendment, we used to produce the negatives. Now negatives will not come. Therefore, we used to produce CD or pen drive with the certificate of the section 65. No such procedure has been adopted. Therefore, exhibit P11 cannot be taken into consideration. So as to say
Mr. Krishnamurthy,
please.
Have you produced that negative along with that photographs?
My instructions are.
That is a mandate.
How the negatives have been produced and one aspect your lords may kindly consider. ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅದಾದ್ಮೇಲೆ ಒಂದ್ ನಿಮಿಷ ಐ ಆಮ್ ಆನ್ಸರಿಂಗ್ ದ ಕ್ವಶನ್ ಬೈ ದ ಆನರಬಲ್ ಕೋರ್ಟ್. My instructions are that negatives have been produced, and even otherwise, unless the negatives are produced normally.
Negative is not produced. No, what you have. No, what is that? By reading what it shows, you have a CD. From the CD, this photograph has been taken. Therefore, you have produced the CD. Instead of negative, now it has been produced CD.
No.
CD contains.
Because the negative, there is no objection by the defendant at the time of marking the document. It is made clear by the learned judge.
No, if it is not objected, then this is negative is not necessary.
No, according to me, it is not, because one andre commercial.
That I am relying on that. You show me that law. What is the law on that point?
Commercial construction of commercial building on the site. That is admitted by them. Kindly see the document. Avare produce madi. It is an admitted fact.
No, that court has come to the conclusion that this construction is on that Gardi property on the basis of the photographs.
And so far as that is concerned, forget the photographs. Avare document. Avare monne hajar madiddaralla Societies Registration Act ಗಳಿಗೆ kindly look into the document. Avare.
No, this document is before the trial court.
ಅಲ್ಲ ಇಲ್ಲಿ ಹಾಜರು ಮಾಡಿದಾರು.
ಇಲ್ಲಿ ಸರಿ trial court to give a finding what is the material I am asking. Now he is testing the judgment of the trial court.
The question whether there is commercial complex constructed has been considered by the trial court. That is admitted by the defendants themselves. By their own document.
Where is?
I kindly see the document. Our monne hajar ಮಾಡಿದ್ದು on 12.
No, Mr. Krishnamurthy, that is not available before the trial court. On what basis trial court has come to the conclusion that
problem ಇದೆ ಅಂತ ಕಾಣಿಸ್ತಾ ಇದ್ರು.
Yes, that you are from your side that has disconnected.
My submission is in the judgment passed by the trial court, it is clear that the defendants have photographs and there are constructions and according to them the ceremony was also performed.
Although yellow photographs, all photographs only. Photographs has to be produced along with that negative, is it not?
In the invitation which is produced, which is also marked, it is clear that inauguration was conducted.
Haudu, inauguration haudu, building haudu, elli kattidare building anta. Court comes to the conclusion that they are denying that we have constructed the building on that Gardi's property. To come to the conclusion it is a Gardi's property on the documents which you have produced, photographs and all.
In this document produced before this honorable court, it is under section 107 of CPC. This honorable court can look into the documents produced before this honorable court. Kindly see the document which is produced before this honorable court. Because along with this application they have produced. Is also not in accordance with Order 41 Rule 27. ಅದನ್ನು ನಾನು ಓದ್ತೇನೆ. Kindly see the document. ಅದರಲ್ಲಿ the first document. Before that, can I request this honorable court to look into this application? Affidavit ಅನ್ನು ಒಂದು ನಿಮಿಷ, because it is not in accordance with Order 41 Rule 27 ಅಂತ ತೋರಿಕೆ ಅದನ್ನು ಒಂದನ್ನು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ through the document. This honorable court can look into the document 107 ಕೆಳಗೆ 41 Rule 27 ಕೆಳಗೆ the affidavit in support of the application. Para number 3. May I read that one?
Yes.
I submit that the plaintiffs have miserably failed to establish the fact. It is the defendants who have mismanaged the public property Gardi in question and illegally constructed shops in the Gardi premises and entitled to constitute a trust so and so, so and so. On the other hand, this is important. A trust has been already formed and duly registered before the district register of societies Mysuru in the name and style of ನಜರಾಬಾದ್ ಬೆಸ್ತಗೇರಿ 10 ಜನಗಳ ಗರಡಿ ಸಮುದಾಯ ಭವನ ಸೇವಾ ಸಮಿತಿ. ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಅವರು. ಇಟ್ ಈಸ್ ಆಸ್ 10 ಜನಗಳ ಗರಡಿ ಸಮುದಾಯ ಭವನ ಸೇವಾ ಸಮಿತಿ and ಸಮುದಾಯ ಭವನ has been constructed under the active participation of jurisdiction MLA by investing the funds allotted for development, which fact has been suppressed by the plaintiffs who have been successful in their attempt to become the trustee members. The documents relating to the aforesaid facts could not be produced during the course of trial of the suit by the defendants, as myself and other defendants were not proper guidance in, and I am reading as it is, guidance in the case. They do not say that it is constructed elsewhere. It is here only. And kindly see, ಈಗ ಅದರಲ್ಲಿ the first document, certificate of registration ಅಂತ ಹೇಳಿದ್ರು. Last time I pointed to this honorable court, ಇದು certificate registration ಅಲ್ಲ, first document at page 5, kindly see, page 5. Page 5 of that application. Page 5. This certificate of registration ಅಂತ ಹಾಜರು ಮಾಡಿದ್ರು. I pointed out that this is not certificate of registration. This is only a letter.
Yes.
Page 5 ಅಲ್ಲಿ, page 4 ದಲ್ಲಿ list of documents ಅಂತ ಹೇಳಿದ್ರು. Page 5. Lordship got it not?
Yes.
ಅದರಲ್ಲಿ that was only a letter. ಈಗ along with the memo dated 12/2/2014, that may kindly be seen. 12/2/24 ಹಾಜರು ಮಾಡಿದ್ದಾರೆ. Along with the memo. ಅದರಲ್ಲಿ first document says, yes, first document at page 2, kindly see that. Only address ನೋಡಿ. I hereby certify that ನಜರಾಬಾದ್ ಬೆಸ್ತರಗೇರಿ 10 ಜನಗಳ ಗರಡಿ ಸಮುದಾಯ ಭವನ ಸಮಿತಿ number 407, that is the suit property. 407 Theobald Road, Nazarabad, Mysore 570010. That is the suit property. Kindly check the schedule in the judgment of the trial court. Same property. And they do not deny that.
Yes.
And kindly see the next page. ಆ ಉದ್ದೇಶ ಅವರದ್ದು ನೋಡಿ. This is meant for the wrestlers. ಕುಸ್ತಿ ಪಟುಗಳಿಗೆ ಒಂದು ಉದ್ದೇಶನು, it is not in relation to the wrestlers. ಗರಡಿ ಸಮುದಾಯ.
Now what is the position now that construction is over?
ಅಲ್ಲಿ ಒಂದು ಯಾವುದು ಹನುಮನ ದೇವಾಲಯ ಇದ್ದದ್ದೇನೋ ಕೆಡವಿ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರಂತೆ. 2-3 ಅಂಗಡಿಯಿಂದ ಬಾಡಿಗೆಯನ್ನು ವಸೂಲು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಯಾರು? Mainly my instructions are that it is appellant number 3 Surnaarayan.
Alre, now that you have constituted the trust committee, you are there.
ಹೌದು, ಈಗ ನಾವು ಮಾಡಿದ್ದೇವೆ. ಹೋದ್ರೆ ಅಲ್ಲಿ ಇವರು they are not allowing us and they are not rendering the accounts. They are trying to supervise the things because the committee has been constituted and trust deed has been registered. ಆದ್ರೆ ಇವರೆಲ್ಲ ವಯಸ್ಸಾದವರು ಮೊದಲಿನ ತಾಕತ್ತಿಲ್ಲದೆ ಇರೋದ್ರಿಂದ he is younger compared to these persons.
No, that will not come in the see when you are in a the court has given a direction to constitute to protect that property. You are not able to protect, then leave it to others.
We will definitely do it. We are doing it. We are doing it. Only
You are
thing is
saying
that
that still that person is collecting. How can he collect that when that trust has been formed?
he cannot, and that is why he has been directed to furnish the accounts. ಅದಕ್ಕೆ appropriate action will be taken in the matter now.
No, ಅಕೌಂಟ್ಸ್ ಕೊಡೋದು ಹಿಂದೆ ಅವ್ರು ಕಲೆಕ್ಟ್ ಮಾಡಿರೋದು ಇದಕ್ಕೆ. But after constitution of that your committee, you should not allow anybody.
ಅದಕ್ಕೂ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಈ ಹಿಂದೆ ಮತ್ತು ಮುಂದೆ ಎರಡೂ ಇದೆ. ಕೈಂಡ್ಲಿ ಸಿ ದ ಡಿಗ್ರಿ ಎರಡಕ್ಕೂ ಇದೆ.
ಮುಂದೆ ಅಂದ್ಮೇಲೆ ನಿಮ್ದು ಕಮಿಟಿ ಆದ್ಮೇಲೆ ಇನ್ನು ಅವ್ರಿಗೆ ಯಾರಿಗೂ ಬರಲ್ಲ ಪವರ್. Then you have the power to control everything.
Definitely. That is what we are doing it. That is what we are doing. Now the only question is, ಈ ಕೈಂಡ್ಲಿ ಸಿ ದ ಪರ್ಪಸಸ್ ಅವ್ರು ಈ ಸಮುದಾಯ ಸಮಿತಿ ಅಂತೇಳಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರಲ್ಲ, and that certificate of registration issued by the society's registrar will not prevent the competent court under section 92 of CPC from deciding the lists between the parties so far as section 92 is concerned. Yes, and 92, the learned judge has discussed all the aspects, including the aspect that the defendant has not.
That you have constructed and
I have produced other documents. We don't want to show the documents which I have produced further. Kindly see the subsequent documents, not document which is the application file for registration of society. So,
Allah Ali affidavit ali you said we have made an effort and constructed that building anta ಹೇಳ್ತಿರಲ್ಲ.
ಬಿಲ್ಡಿಂಗ್ ಅಂತ ಗರಡಿಯನ್ನು ಫೋಟೋಗ್ರಾಫ್ ಹಾಜರ್ ಮಾಡಿದ್ದೀವಿ. ಗರಡಿ ಇದೆ ಅಲ್ಲಿ, ದೊಡ್ಡ ಲಾರ್ಜರ್ ಎಕ್ಸ್ಟೆಂಟ್, ಇದು ಮೈದಾನ ತರ ಇದೆ. ಅಲ್ಲಿ ಗರಡಿ ಸ್ಪೇಸ್ ಬೇರೆ ಇದೆ, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ 2 ಶಾಪ್ಸ್ ಆಲ್ರೆಡಿ ಇದೆ. ಅದಲ್ಲದೆ ನಾವು ಬೇರೆ ಕಟ್ಟತಕ್ಕ MLA ಕೋಟದಲ್ಲಿ ಫಂಡ್ ರಿಲೀಸ್ ಆಗಿದೆ, ಅದನ್ನ ಯುಟಿಲೈಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. ಸಪೋಸ್ those constructions are illegal, what action they have taken subsequent to construction? Have they demolished? Have they filed from the corporation? They have not taken any such. They want the income.
No. They don't. They are not saying that illegal. They are saying that you are constructing that.
That is incorrect.
See, property which is.
We have not dismantled the garden. We have allowed to function the garden. In addition to that, under the supervision of the local MLA, some constructions might be there, but it will not prevent the functioning of garden. That is why I have produced the photograph.
No, that construction is for the benefit of the garden or that your trustees.
To maintain the accounts, to generate the income. There must be some. But these people have not generated, not contributed anything. They are only interested to become the trustees, become the members of the society. And they have not contributed. We have formed a separate society. Then the problem starts. Kindly see.
No, your formation is also for the other purpose. Maybe.
No. That is may not be correct. Not kindly see.
Why he has not furnished that account when even after that degree? If it is a public property, he could have furnished that. Yes, we have constructed. These are all the investment. This is the profit. Now that Gardi has having this profit, he has not given, but now he has passed away.
But it is not the only act. It is a voluntary act of the persons who are all participating in the Gardi. ನೋಡಿ, ವ್ಯಾಯಾಮ ಶಾಲೆಯಲ್ಲಿ ಯಾರೆಲ್ಲ ಮಾಡ್ತಾರೆ ಎಲ್ಲರೂ ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತಾರೆ. ಈಗ ನಾವು ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ ಆಯ್ತು, ನೀವು ಇದ್ರಲ್ಲ ಅಲ್ಲಿ ನೀವು ಇಷ್ಟು ಕಲೆಕ್ಷನ್ ಆಗಿದೆ, ಇಷ್ಟು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು should you not give an account?
We will provide.
You are not given before the Tahsildar even after so many years.
That was not of course there is a decree which is challenged before the Supreme Court during the pendency of the appeal is admitted. Therefore, we have not taken any steps to provide the account. Of course, what prevented the other side? Suppose the person who is the judgment debtor has committed default, has not obeyed the decree. What is the next course of? There is execution proceedings. Why they have not initiated? Of course not. They are not bound to initiate. It is my duty to furnish the accounts.
Yes,
but suppose I fail to comply.
No, that shows that you are not in that public interest.
That is not the correct. Kindly see the nomenclature of the Gardi plots.
No, that is true. ಎಲ್ಲ ಹೆಸರುಗಳನ್ನೆಲ್ಲ ಹಾಕೊಂತಾರೆ.
ಸೇವಾ ಸಮಿತಿ.
ಹೆಸರು ಮೇಲ್ಗಡೆ ನಾವು we cannot now you see that they will put that ದೇವ್ರ ನೇಮ್ಗಳು ಎಲ್ಲಾ ಹೆಸರು ಹಾಕೊಂಡ್ಬಿಟ್ಟು ಬೇರೆ
ದುರ್ಗಾದೇವಿ ಗುಡಿ ಇದೆ, ಹನುಮಾನ್ ಗುಡಿ ಇದೆ. ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಸೇವಾ ಸಮಿತಿ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ ಅಷ್ಟೇ ವಿನ ಬೇರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಓನ್ಲಿ ದಟ್ ದಿಸ್ ಡಿಪೆಂಡೆಂಟ್ಸ್ ವಾಂಟೆಡ್ ಟು ಮೇಕ್ ಮನಿ ಔಟ್ ಆಫ್.
See, you should have show your bona fide giving that accounts. That should have been shown that yes, you are doing for the interest of the trust. Their allegation is that for the interest of your personal interest you are doing, and
the entire plots matter is taken plots of the custodian of the custody of the Garadi has been taken by Tashildar, and a committee has been constituted according to the respondents. But now, lords, of course, lords, the matter is remanded. Lord, up to date accounts, lords, there may be a terms to the appellant to furnish the accounts. And any terms, lords, may kindly be imposed, lords, to see that the proper opportunity be provided to the appellants. Because
yes, Mr. The condition he will be given a permission,
please,
given opportunity was subject to that. If he has given entire state accounts to that committee, then only trial court may be directed to permit him to give an opportunity. At least, in that way it can be execution. Another way, you have not filed an execution. By this way we can execute that order.
Please, one day, I absolutely agree.
Yes.
For the suggestion being made by the honorable court. One day, judgment ಯಾವುದು ಅಂತ ಕೇಳಿದ್ರಿ 2007 ILR 1127.
What is that?
Only for the purpose ಒಂದು ಪ್ಯಾರ ಒಂದು ದಯವಿಟ್ಟು ನೋಡಿ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಕೇಳಿದ್ರಿ. Following that there is judgment by your lordship also along with Justice Veerappa.
Yes.
1127 ILR 2007 Karnataka. I agree, but the only thing is your lordship wanted to know about that judgment. Only for the purpose of providing opportunity, matter should not be remanded and said.
That is true. No, now that this court has given additional document is concerned,
please,
under order 41 rule 28, we can send it for only a giving a parties to be examined and report can be submitted to the court.
ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದೆ ಮಾಡಬೇಕು.
Illi the thing is that even though 100 times opportunity has been given, he has not adduced anything. Therefore, if it is only for the purpose of additional documents, then this court can get it then a report from the trial court. But here he has not taken any opportunity. Therefore, I thought that one opportunity may be given. But anyhow, now he cannot delay the matter because now everything is in your control. That will be continued. But you will given an opportunity only subject to that part of that degree has to be complied by giving in a.
ಒಂದೇ ಒಂದು ಸೇರಿಸ್ಬಿಡ್ತಾನೆ. ನನ್ನ ರಿಕ್ವೆಸ್ಟ್ that can be done. Of course, ನನ್ನ ಕನ್ಸೆಷನ್ ದಯವಿಟ್ಟು ತಗೊಳ್ಬೇಡಿ. Let it.
ಇಲ್ಲ. Will take your argument.
Please, exemplary cost may be imposed on the defendant for the purpose of leading his evidence in the only. It should be confined to that. ಎರಡನೇದು, this trust committee etc. formulated or constituted, that should continue till the disposal. And he should furnish all the accounts to.
Yes. No, that part of the degree in respect of that giving an account,
please,
it will also be directed to comply. Then only you will give the person.
And a time limit may be fixed.
Now that instead of first defendant, we'll say that other defendant number 2 and 3.
Highly obliged.
May I make one?
Is an after condition.
Advocate has retired. A memo is filed of retirement, which has been accepted. Then again, the court has recorded that advocates are present. That may be incorrect.
Have you calculated how many times time has been given?
ಹೌದು ಮಾಡಿದ್ದೇನೆ.
Don't track further, Mr. I will conclude. Yes.
ಒಂದೇ ನಿಮಿಷ, ನಾನು ತುದಿಯವರೆಗೂ ಮಾಡಿದ್ದೇನೆ ಇಲ್ಲಿ.
Yes.
ಕೋವಿಡ್ ಇತ್ತು
23 ಸಲ ಆಗಿದೆ.
ಅದು ಬಿಟ್ಟಿದ್ದಾರೆ.
23 ಸಲ ಆಗಿದೆ. ಅದು ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲೇ 23 ಸಲ. ಕೋವಿಡ್ ಎಲ್ಲ ಬಿಟ್ಟಿದ್ದೆ ನಾನು. ಕೋವಿಡ್ ಎಲ್ಲ ಬಿಟ್ಟಿದ್ದೆ. excluding
ಅದಕ್ಕಿಂತ
COVID.
ಮುಂಚೆ ಅಡ್ವೊಕೇಟ್ ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ ಒಬ್ರು
ಅಲ್ಲ, ಅದರ ನಂತರ ನಾನು ಓದಿದ್ದೆ.
ಬಟ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಇಲ್ಲ. ಆರ್ಟಿಗಳಿಗೆ ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ಬೇಕು ಅಂತಿದೆ, ನೋಟಿಸ್ ಸರ್ವ್ ಆಗ್ಬೇಕು.
ಎಲ್ಲಿದೆ ಅದು?
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಡಿಪೆಂಡೆಂಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೋ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಅಕ್ಸೆಪ್ಟೆಡ್, ಬಟ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಸರ್ವ್ಡ್ ದ ನೋಟಿಸ್.
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ, ಅದನ್ನು ಓದಿದ್ದೇನೆ ನಾನು, ಅದನ್ನು ಓದಿದ್ದೇನೆ.
ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ?
No, that advocate who has been permitted to retire has been complied that rules.
ಹೌದೌದು, ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿತ್ತು.
For the petitioner pays fine on the.
ಅದನ್ನು ಓದ್ತೇನೆ ಮತ್ತೊಮ್ಮೆ ಬೇಕಿದ್ರೆ. ನೋಟಿಸ್ ಅದಾದ್ಮೇಲೆ 2 ಸಲ ಇಶ್ಯೂ ಆಗಿದೆ.
Where is that, Mr. Show me.
Please.
21/1/2020.
21/1/2020. Plaintiff and the counsel
Plaintiff
present.
and counsel present. D1 to D3 absent. Counsel for D1 to D3 Srimati SK advocate filed memo of retirement for appearance of defendant and their evidence finally by. Next, both counsel present.
ಬಂದಿದ್ದಾರೆ.
Both counsel present. No representation. The counsel present.
Defendant called out, no representation made on behalf of the defendant, sufficient time already granted, no ground assigned to grant the time, hence the evidence. Lawyer ಬಂದಿದ್ದಾರೆ, ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
Lawyer ಬಂದಿದ್ದಾರೆ.
ಮತ್ತೆ
Then
counsel for the defendant press time ನೋಡಿ ನಿಮ್ಗೆ ಆಮೇಲೆ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಆಮೇಲೆ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಅವರೇ. After filing a retirement.
Court has not permitted him to retire.
Yes.
Then he has continued.
Yes.
He should have issued notice to the parties and he should have retired.
ನಮಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬರ್ಡನ್ ಇಸ್ ಆನ್ ದಿ ಪ್ಲೇಂಟಿಫ್. ಆದ್ರಿಂದ ಅವರು ಪ್ರೂವ್ ಮಾಡಬೇಕು. ಪ್ರೂವ್ ಮಾಡಿದ ನಂತರ
ಅವರು they have given sufficient documents to prove that there is any materials.
Then SOP.
If you want, even I will give a finding that there is any sufficient material.
ನನಗೆ ಅದು ಅದಕ್ಕೆ ನಾನು ಫಸ್ಟಿಗೆ ಮೊನ್ನೆ ಕಮೆಂಟ್ಸ್ ಮಾಡೋತ್ತಿಗೆ ನಂದು ರಿಕ್ವೆಸ್ಟ್ ಅದನ್ನೇ ಇದೆ.
ಆಯ್ತು, only given opportunity. Otherwise, you see that finding is given that all that records of the Mysore City Corporation shows that it stands in the name of that. Only thing is that whether Gardi is still existent.
Yes.
Or you have demolished and constructing that.
Yes.
That we have to be established.
Yeah.
I tell you go before the trial court and say, because trial court finding is you are demolished that Gardi and tell.
ಡಿಸ್ಮ್ಯಾಂಟಲ್ ಮಾಡಿದೀವಿ.
Dismantle ಮಾಡಿದ್ದೀರಾ?
ಡಿಸ್ಮ್ಯಾಂಟಲ್ ಮಾಡಿದೀವಿ ಅಂತ. ಬಟ್ ತಹಶೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ತಹಶೀಲ್ದಾರ್ ಇವಾಗ ಏನಿದೆ? Therefore, let there be a open remand.
Yes.
However, the committee trust constituted by the Tashildar may be continued. Disposal.
But you have to give that ಇದು.
ಈಗ ನಾನೀಗ ಏನಾಗಿದೆ? Component number 1 died. ಇವಾಗ all the committee has taken over the entire assets. ಈಗ books of accounts ನಮ್ಮಲ್ಲಿ
books of accounts ಇವ್ರ ಹತ್ರನೇ ಇರ್ತದೆ. Defendant number. Defendant number 1 is dead only 6 months back.
ಹೌದು. Now the entire position is with the plaintiff. With the plaintiff.
Unless you give that accounts, we will not send it back. You will not. You ask your clients whether they're ready to give it. Otherwise, I will dismiss it here.
Books accounts ಆಗಿದೆ. ನಮಗೆ access ಬೇಕಲ್ಲ.
No, ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ ನೀವು. ಅದನ್ನ ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ ಇದನ್ನ? ಅದು it is not in that original records.
ಮಾಜರ್ ಇಲ್ಲ. ಟೇಕನ್ ಓವರ್ ಮಾಡಬೇಕಾದ್ರೆ ಇನ್ವೆಂಟರಿ ಬೇಕು, ಮಾಜರ್ ಬೇಕು, ಯಾವುದು ಮಾಡಿಲ್ಲ.
Ask your clients whether they're ready to give it or otherwise I will confirm this finding.
We have to contact her.
Password. Yes. ಅಥವಾ ಅವರಿಗೆ ಇಲ್ಲ, ಈಗ ಅವರು ಯಾರೋ ಇద్దರು ತೀರ್ಕೊಂಡೋದ್ರು, ನಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂದ್ರು, ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಯು ಆಸ್ಕ್ ದೆಮ್. ಯೆಸ್. ಪಾಸ್ವರ್ಡ್.
Number 35, Ravindra Prasad Prasad applied the Sampat A.
Yes, Mr.
Credence value, Lordship, I have brought that.
What is that value?
Totally ಎಲ್ಲ small properties list wise ಹಾಕಿದೀವಿ.
ಎಷ್ಟಾಯ್ತು ಟೋಟಲ್?
Each share 4 lakh 28,000 rupees ಬರುತ್ತೆ.
Where not partition 17 share each, and the value of the each share is 428 per jurisdiction.
428,000 ಅದೆಲ್ಲ ಚಿಕ್ಕ ಪ್ರಾಪರ್ಟಿ ಅದು. ಅದರಲ್ಲಿ ಸ್ವಾಮಿ ಇದು ಒಂದು ಬಂದ್ಬಿಟ್ಟು 8 into 22 feet ಐಟಮ್ ನಂಬರ್ 1 ಶೆಡ್ಯೂಲ್ ಎ ಪ್ರಾಪರ್ಟಿ. ಸೆಕೆಂಡ್ ಬಂದ್ಬಿಟ್ಟು 18 into 25 ಅದು 450 ಸ್ಕ್ವೇರ್ ಫೀಟ್. ಇನ್ನೊಂದು 13.6 feet into 8.5 feet. ಇನ್ನೊಂದು 15 into 8.6. ಇದೆಲ್ಲ ಬರೋದು ಪೊಲೀಸ್ ಅಲ್ಲಿ ಏನು ಅದ್ರದ್ದು ರಿಲೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಗೆ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಇನ್ ಪೇಜ್ ನಂಬರ್ 108 ಪೇಜ್ ನಂಬರ್ 8 ಇವರು.
ಇದೇನಿದ್ರು ಬೆಂಗಳೂರದೇ ಅಲ್ವಾ?
ಬೆಂಗಳೂರದೇ ಅದು.
ಎಷ್ಟು ಬಂತಲ್ಲಿ ಟೋಟಲ್?
ಟೋಟಲ್ ಇವ್ರ ಲಕ್ಷ ಕ್ಯಾಲ್ಕುಲೇಷನ್ 5,400 ಬರುತ್ತೆ ಪರ್ ಸ್ಕ್ವೇರ್ ಫೀಟ್.
ಅಲ್ಲ ಇದೆಷ್ಟು ಬರುತ್ತೆ ಒಟ್ಟು
ಟೋಟಲ್ ಏರಿಯಾನ?
ಅಲ್ಲ ಒಟ್ಟು ಅಪಲೆಂಟ್ಸ್ ಎಷ್ಟು ಬರುತ್ತೆ?
ಅಪಿರೆನ್ಸ್ ಈಚ್ ಪರ್ಸನ್ 428.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
11 ಜನ. 10 ಜನ.
4 lakhs.
ಒಬ್ಬರದು ಈಚ್ ಶೇರ್ 4 lakhs ಬರುತ್ತೆ. ಸೊ ಇಟ್ ವಿಲ್ ಕಮ್ ಬಿಫೋರ್ ದಿಸ್ ನಾರ್ಮಲ್ ಕೋರ್ಟ್ ಸಿಂಗಲ್.
ಅಲ್ಲ 4 lakhs ಅಂತಂದ್ರೆ ಎಲ್ಲರದು ಶೇರ್ ಮಾಡ್ಬೇಕಾ ಇಂಡಿವಿಜುವಲ್
ಬರೋದು? ಆತರ ಶೇರ್ ಪಾರ್ಟಿಷನ್ ಶೆಲ್ ಬಿ ಎವ್ರಿಬಡಿ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇದೆ. ಪ್ಲೇಯರ್ ಅವರು ಇಂಡಿವಿಜುವಲ್ ಪ್ಲೇಯರ್ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಸಪರೇಟ್ ಪೊಸಿಷನ್.
ಎಲ್ಲರದು ಸೇರಿಸಿ ಮಾಡ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ ನೀವು ಅಡ್ವೊಕೇಟ್ಗಳು ಹೆಂಗ್ ಬೇಕಂತ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಯಾರೋ ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ ಬಂದ್ಬಿಟ್ಟು ಕಡಿಮೆ ಬಂತಲ್ಲ, ಈಗ 4 lakhs ಬಂತು, ನಿಮ್ದು ಇದು ಬೆಂಗಳೂರು. If it is not Bangalore, if it is a district court, it has to go to that district court. ಅವಾಗ ಇಲ್ಲ 4 ಜನದ್ದು ಸೇರಿಸ್ಬಿಟ್ಟು 10 ಲಕ್ಷದ ಮೇಲೆ ಆಗುತ್ತೆ, ಇಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ. You show me that any
plaint ಅಲ್ಲಿ ನಾವು where will be the separate possession of the each person will be saved, not joint thing. ಆ ಒಂದು ಪರ್ಪಸ್ ಗೆ ಮಾತ್ರ each individually separate possession ಅಂತ.
ಕೋರ್ಟ್ ಫೀ ಕೊಡಿ, ಕೋರ್ಟ್ ಫೀ ಅನ್ಸುತ್ತಲ್ಲ. ಯಾವುದು
35(2) section.
Separate person.
Subsection 3, 35. Well, in a suit falling under subsection 1 or subsection 2, a defendant's claim partition in separate of his share of the fee shall be payable on his return statement, computed on the half market value of his share or at the rate.
ಅದ ಇದಾಯ್ತು ಅವನ ಶೇರಿಗೆ. Suit for partition in separate position, joint family properties and properties owned jointly are in common. Suit for partition separate position of the suit, joint family properties owned jointly are in common. If the force title to this property is denied or who has been excluded from such property, appointed in the position of the joint family, who is joint person, he shall be paid at the following rates. ಇದು ಕೋರ್ಟ್ ಫೀಗೆ
ಯಾವುದು ಹೇಳಲ್ಲ, ಬಟ್ ಇಲ್ಲಿ ಸ್ವಾಮಿ 35 ಅಲ್ಲಿ fee shall be computed on the market value of the plaintiff's share ಅಂತ ಹೇಳುತ್ತೆ. ಇಂಡಿವಿಜುವಲ್ ಹೇಳ್ತಾರೆ. plaintiffs ಅಂತ
ಅದು
ಸಿಂಗುಲರ್.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆಕ್ಟ್ ಕೊಡಿ.
ಹೈಕೋರ್ಟ್
ಆಕ್ಟ್ ಕೊಡಿ.
61(5)(1) ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಏನು ಹೇಳಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ.
5 ಲಕ್ಷ 10 ಲಕ್ಷ ಅಂತ ಹೇಳಿ
15 ಲಕ್ಷ 20 ಇದು 15 lakhs, more than 15 lakhs and less than 15 lakhs. Appeal against a decree of or order passed in a suit or other proceeding, the value of subject matter shall be heard by a bench not less than 2 judges of the High Court.
Value of the subject matter is an
individual share. Value of the subject matter is the individual share. Section 5(1) of High Court.
ಅದೇ ಇಂಡಿವಿಜುವಲ್ ಅಲ್ಲ, ವ್ಯಾಲ್ಯೂ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಪ್ಲೇ
ಹೇಳ್ತಾರೆ. It has to be deemed to be that individual ಅಂತ
ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಅದು ಈಗ ಹುಡುಕೋದಕ್ಕೆ ನೋಡ ನಮ್ಮ ಇವ್ರು ಅವರ ಇರ್ಬೋದು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ they might have a case.
ಇದರಲ್ಲಿ 5 ಜನ 10 ಜನ ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಅವಾಗ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಶೇರ್ ಆಟೋಮೆಟಿಕ್ ಸಿಂಗಲ್ ವೈಸ್ ಬರ್ತದೆ.
This then what are the that is the only office objection.
The only office objection.
Why it is posted today then?
Your lordship, there is a LR defendant number, respondent number 3
and memo
number 9.
ಮೆಮೊ ಹಾಕಿದ್ರಾ?
ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ಲ LRC
ಅಲ್ಲ ಈಗ ಎಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ರಾ ಈಗ? What is that you have filed for?
ಇದು ಇವಾಗ ಮೆಮೊ ಹಾಕಿದ್ವಿ.
Where is that?
ಮೆಮೊ for suit for guidance.
Total ಎಲ್ಲಿ ಇದೆ? ಇಲ್ಲಿದೆ. The net counsel for the appellant has filed a memo enclosing notification for guidelines value and stated that each share of the plaintiff, share of each plaintiff appellant is 4,28,053. The same is taken on record. Yes. Of its objection in respect of that aspect is concerned is overruled. Then what is this? Then it has to posted for admission.
Admission of the application because they are likely to find it.
Where is your other side?
ಅದರ್ ಸೈಡ್ ಅವರು ಕೇವೇಟರ್ ಬಂದಿಲ್ಲ, ನಾನು ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಹಾಕಿ ಕೇವೇಟರ್ ನೋಟಿಸ್ ಕಳಿಸಿದ್ರು.
ಅವ್ರೇನೋ ರಿಟೈರ್ಮೆಂಟ್
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್.
Senate Council for aviator correspondent number 1 has filed a memo 21/2/2023 closing NOC enclosing the acknowledgement having written the entire paper and NOC wakalat to the parties and sought for retirement from the case. Memo is dated 21/2/2023 is taken on record. Senate Council for respondent number 1, Kivator is permitted to retire from the case. Yes, what is this?
Your lordship, I have filed a memo with regard to service of notice to the caveator.
No, now Kivator is gone. Now that
ಅವ್ರಿಗೆ caveator council ಗೆ ನಾನು ಕೊಡೋಕೆ ಹೋದ್ರೆ ಅವ್ರು NOC ತಗೊಂಡ್ರು. Since there is a compliance required to be complied with this.
you have sent it to that party.
Yes. ಅದ್ರದ್ದು postal receipts ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
ಅದೇನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಅಲ್ಲ? Yes. Then what is this matter?
Your lordship, suit for partition. Suit for partition, your lordship, admittedly a joint family property of 1 Sri.
You are the plaintiff or a defendant?
I am the plaintiff. Plaintiff suit has been dismissed.
Yes.
ಅವರು ಎರಡೇ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ನಮ್ದು. ಒಂದು ಅಂತ ಹೇಳಿದ್ರೆ ಇವರು ಇಂಡಿವಿಜುವಲ್ ಸಪರೇಟ್ ಇದ್ರು ಮದ್ವೆ, ಟೋಟಲಿ ದೇ ಹ್ಯಾವ್ ಗಾನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಫ್ಯಾಮಿಲಿ ಅಂಡ್ ಮ್ಯಾರಿಡ್, ದೇರ್ಫೋರ್ ಹಿ ಹ್ಯಾಸ್ ಅರ್ನ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. It is in the year 1980 the suit properties will be partitioned among the family. It is larger extent. Plaintiff father through it has been partitioned with the plaintiff father's brothers. Thereafter, your lordship, it has been, your lordship, as a karta, that is the defendant number 1, respondent number 1's husband who was looking after.
Now what is that threat you are having?
Your lordship, I am in the occupation of the property.
Now there is a delay for filing appeal also.
2 days appeal, 2 days delay, your lordship.
Now what is the threat?
Threat, your lordship, your lordship, one is I am in the possession of the property. They are filing the execution, your lordship, and also they are trying to interfere, your lordship.
What is that execution? Suit is dismissed.
Dismissed are eviction ಗೆ ನಮ್ಮ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಎವಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ illegally.
How can they do it?
Your lordship, ಅದು process ಮಾಡ್ತಾ ಇದ್ದಾರೆ. That's the reason, your lordship, I am in a possession. The address what is shown is the plaintiff is also shown.
No, suit for dismissal of the suit for partition is not that they can evict you from that suit scheduled property. They have to file
but they are doing illegally, your
lordship. A complaint, you file a suit for
your lordship, I need a protection because in pursuance of the judgment and decree, your lordship, they are taking the benefit. On the strength of dismissal order, your lordship, they are processing against
how can
your lordship illegal.
No, that see dismissal of the suit for partition, can they say that your property has been acquired?
Your lordship, portion of the
Any can
property,
be-
I am also in occupation, portion of the property, they were also, they're making attempts, your lordship.
That is an illegal. You approach the trial court to get an injunction.
Lordship, when there is a dismissal, when they do not have, I do not, the trial court has said that I do not have a right over the property.
Yes.
Now, the trial court, very same trial court will not grant any kind of
Issue notice.
status quo, let there be maintenance of status quo.
Parties are directed to maintain status quo till next date of it.
Much okay.
Correct. ಇದು ಗೊತ್ತಾ ಅದು ಶೇರ್ಸ್ ಜನ ಅಪಲೆಂಟ್ ಇರ್ತಾರೆ ಈಚ್ ಶೇರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಟುಗೆದರ್ ಯು ಹ್ಯಾವ್ ಟು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಫಾರ್ ಜುಡಿಸಿಕ್ಷನ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಶಾರ್ಟ್ ಶೇರ್ ಕೇಳಿರ್ತಾರೆ ಈಚ್ ಅಂತ ಇದ್ರೆ ಇಂಟು ಮಾಡ್ಕೋತೀವಿ ಸರ್ 5 ಜನ ಇದ್ರೆ 5 ಜನ ಇಬ್ರಿದ್ರೆ ಇಬ್ರಿಗೆ
ಮಾಡ್ಬಿಟ್ಟು ನೀವು ಜುಡಿಸಿಕ್ಷನ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಸಿಂಗಲ್
ಇಂಟು ಮಾಡ್ಬೇಕು
5 ಜನ ಇದ್ದಾರೆ ಅಂತ ಇರ್ತಾರೆ 5 ಜನಕ್ಕೆ ಸೇರಿಸ್ಬಿಟ್ಟು ಇಫ್ ಇಟ್ ಇಸ್ 15 lakhs it has to go before the division bank. How can 8 lakhs ಇದೆ. If it is together, it become more than 15 lakhs. 11 share will come to 8 lakhs. There are 8 lakhs for each appellant. There are 5 appellants. Different shares ಇದೆ. ಅದನ್ನು 5 ಜನದು ಸೇರಿಸ್ಬಿಟ್ಟು 15 ಲಕ್ಷ ಮಾಡ್ತಿದ್ದಾನೆ. Each one. Each 8 lakhs it is single judge. Otherwise, ನೀವು 5 ಜನದು ಸೇರಿಸಿದ್ರೆ 15 ಲಕ್ಷ ಮೇಲಾಗುತ್ತೆ. ಡಿವಿಷನ್ ಬೆಂಚಿಗೆ ಹೋದಾಗ 3 ಜನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಬಿಟ್ರೆ ಮತ್ತೆ ವಾಪಸ್ ಸಿಂಗಲ್ ಜಡ್ಜಿ ಕಳಿಸ್ತಾರೆ. Then it is single one.
Number 44, Vinita PC for appellant.
The execution case
Hmm.
on March 11th, March 11th. That
You take hand summons, emergent notice and hand summons also. Yes. Then after service, you move the matter, then.
Please.
Or issue notice. In addition, appellant is permitted to take out hand summons to the respondent.
Please.
Yes, Prasanna, you have asked your client, what he said?
Narayana is maintaining the account. Yes, some accounts not so.
He will furnish them. Why, I will ask that, that person is dead.
Yes, he has died last 4 months ago. Exact date not so, yes.
No, any of that after swearing in that affidavit.
Yes.
No, I am not even taking that document. You will be permitted to
Please.
file it before the trial court.
Please.
Then you can file by other persons.
Please.
Then they will also have an opportunity to object it and they consider.
Please.
Your main ground for remand is that no opportunity for given to you. Whatever
Insufficient.
documents you have to produce, you produce there.
Please.
The documents will not take on records now here, Mr. Krishnamurthy.
ಅಲ್ಲ ಅದು ಏನಾಗುತ್ತೆ ನಾಳೆ ದಿವಸ ಅವರು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲದೆ
No, I will permit the parties to file additional documents and additional evidence. But is resolved. Any party can produce. But these 2 conditions will be added.
Yes.
And exemplary cause I am requesting.
Yes. See, this appeal is filed by dependent. Challenging. Okay, order sheet ಅಲ್ಲಿ during the pendency, learned counsel for the appellant has submits that first appellant is dead. The submission is taken on record. Learned counsel for the appellant is permitted to delete that respondent number 1. Appellant number 1. Appellant number 1. You delete it. It will be filed by that defendant challenging Judgment and degree dated 23 December 2020, passed by Principal District and Session Judge Mysore in OS number 2 of 2018, whereby application filed by the plaintiff under section 92 of the Act, CPC, section 92 of CPC is allowed. Suit is decreed. For the sake of convenience, parties are referred to their ranking as per the trial court. Brief facts of the case are that in the year 1944, what is the name of the Gardi?
10 ಜನಗಳ ಗರಡಿ.
10 members, 10 ಜನರ Gardi. That trust has been established in the year 1944 in the name of 10 ಜನರ Gardi.
ಅದು ಟು ಬಿ ಪ್ರಿಸೈಸ್ ಬೆಸ್ತಗೇರಿ 10 ಜನಗಳ ಗರಡಿ ಟ್ರಸ್ಟ್. ಬೆಸ್ತಗೇರಿ 10 ಜನಗಳ ಗರಡಿ ಟ್ರಸ್ಟ್.
ಬೆಸ್ತಗೇರಿ 10 ಜನಗಳ
ಗರಡಿ ಟ್ರಸ್ಟ್. ಪ್ಲೀಸ್.
No, it is constituted under the Trust Act only. Otherwise, you can't file in the case. Yes. Since
register agide, there must be a document. There is no such document. Registered document.
Trust. The plaintiff. The plaintiff who are the beneficiaries under the trust have filed a miscellaneous petition. Miscellaneous petition number 164 of 2015. Section 92 of the CPC, seeking a leave of the court to file a suit for settling the scheme, reconstitution of the trust, around that there is a mismanagement of the trust property. After obtaining the leave, they filed the present suit in OS number 2 of 2018. After service of summons, defendant appear through their counsel, filed in a detailed written statement, contended that suit in the present form is not maintainable in the eye of law. They have not implemented necessary parties also sought for dismissal of the suit on the basis of pleadings of the parties. Trial court has framed the following issues. To prove the case, plaintiff number 3, Timmappa, has been examined as PW1, got marked to exhibit P1 to P11. He has been cross-examined by the defendant. In spite of giving an opportunity, the defendant neither examined any witnesses nor produced any document. On the basis of oral and documentary evidence, trial court has answered issue number 1 to 5 as affirmative. And agreed the suit being agreed by the same. The defendant has filed this appeal. So and so learned counsel appearing for the plaintiff, the defendant has contended that the defendant has not mismanaged the trust properties or trust fund, and they have not dismantled the Gardi or the benefit of the trust. The commercial complex has been constructed without dismantling the Gardi. The trial court has not given any proper opportunity to the defendant to defend their case. He further contended that since there was no proper communication between the defendant and their counsel, in spite of trial court has granted an several opportunity, they are unable to use that evidence and produce necessary documents. They have also filed an application before this court and produced additional documents. If this court give one more opportunity, they will establish their case. Hence, he sought for allowing that appeal. Krishnamurthy, learned counsel appearing for plaintiff respondent, has contended that there is a specific allegation against that defendant that they are trying to dismantle that existing Gardi and want to construct that commercial complex. They have also produced corporation records to show that commercial complex has been constructed on the property belongs to that Gardi. Further contended that the defendant has mismanaged the properties of the Gardi and also mismanaged that
they have not furnished any accounts at all. Accounts.
They have mismanaged that income of the Gardi, and they have not furnished that accounts. Therefore, in the interest of Gardi, herein after called Gardi, in interest of Gardi, the plaintiff has filed the suit for settlement of scheme and reconstitution of mismanagement, reconstitution of the management trust. And also sought for direction to furnish the account to the court. Further contended that trial court has granted more than 23 times opportunity to the defendant. Neither they have produced any document nor examined any witnesses. There is no other alternative. The court to consider that the evidence of the parties and pass an order. After considering that the evidence of PW1 and documents produced by the plaintiff, the trial court has rightly decreed the. After that, suit has been decreed. Pursuant to the directions, pursuant to that decree, Tahsildar has constituted a committee
one submission. After
Yes.
the decree, in the appeal, this honorable court permitted further proceedings to go on.
Yes,
By
yes.
the- Please, 21-22.
Yes.
Subject to outcome of the appeal and then.
Yes, yes.
Permitted.
I will. Pursuant to that, Tahsildar has appointed a trustee. Now new trustees are managing the Gardies. He further contended that even this court by order dated
21-2022.
21-2022.
Submission. Why is making such submission?
Agrees. To be checked with Tahsildar. That constitution of committee as per the degree is subject to the result of the appeal.
I have produced 2 documents along with my memo, my lord. On
No, nobody is disputing one. I am
Please.
giving my finding. Yes.
please.
Yes. 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 Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Heroes, judgment and degree and original records. The plaintiff has filed miscellaneous petition. The point for consideration in this appeal, whether judgment and degree passed by the trial court is perverse, arbitrary, or for interference of this court. Plaintiff has filed, the plaintiffs are the persons interested and the beneficiary of the Gardi. They have filed miscellaneous petition, miscellaneous number 164 of 2015 before Principal District and Session Judge Mysore under section 92 of CPC, seeking a leave of the court for filing the suit, being a scheme suit. Miscellaneous petition has been allowed by order dated 26/3/2018, and they have filed an OS 2 of 2018 for appointment of trustees or for reconstitution of the trust management by appointing new trustees, and also direction to the respondent to furnish that account to the court on the ground that the respondent has mismanaged the fund and properties of the Gardi. On appearance, defendant has filed a written statement in spite of granting in a sufficient opportunity, I have gone through that original records and the order sheet. More than 23 times opportunity has been given. The defendant has not adduced that evidence and have not produced any document except filing in a written statement and cross-examine the PW1. Now, first time before this court, they have filed an application with some additional documents. And learned counsel for the appellant submitted that there was no proper communication from their advocate to the appellant. Therefore, they have not properly prosecuted their case.
From filing ವಕಾಲತ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ನಾನು
ನೋಡಿದೆ, ಲೆಕ್ಕ ಮಾಡಿದೆ.
ಎಸ್ ಸರ್ ಇದೆ ನಿಮ್ ಪ್ರಕಾರ.
Both counsel present ಯಾವಾಗ 12/12/19 ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಪ್ಲೇಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಫಾರ್ ಡಿಫೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿಂದ ಗಮನಿಸ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ ನಂತರದಿಂದ ನಾವು ಸಮ್ಹೌ ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ರೆ ನಾವು ವಿ ಕ್ಯಾನ್ ಪಾಯಿಂಟ್ ಔಟ್
ಎಷ್ಟು ಸರಿ ಅಲ್ಲಿ
12/12 took time 1 then 21/1 2 ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಡೇಟ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಡಿಫೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ನಿಲ್ ಅಂತ ಮಾಡ್ತಾರೆ 7/2/2020 ಅದು 12/12/19 we took time for reading evidence. Then 2/1/2010 defendant trace time. Then 21/1/2010 retirement memo filed. Then 7/2/2020 defendant called out absent ಅಂತ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿಂದ ನಾವು absent ಇದ್ದೀವಿ. ಅಲ್ಲಿ
ಎಷ್ಟು ಸರಿ ಅಲ್ಲಿಂದ
4 times ಅಲ್ಲಿ ಮತ್ತೆ ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ ನಾವಿರಲಿಲ್ಲ 10/6/2020 ಇಂದ 23/9/2020 ತನಕ.
has given a sufficient opportunity 23 times. ಅವ್ರದ್ದು ಇದ್ರಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಇವ್ರಲ್ಲಿ sufficient opportunity. The net counsel for defendants submits that since there was no proper communication from their advocate, the parties have not properly prosecuted their appeal. The trial court, on the basis of the evidence of PW1 and documents produced by the plaintiff, has decreed the suit pursuant to that decree. The Tahsildar has appointed trustees and new appointed a trustee. Now new management is taken over.
existing plaintiffs and two others.
Rather early. Other than new management is now managing that verdict.
And the trust deed is registered.
And appointed trustees. New management is managing. Appointed trustees and trust deed is also registered.
It's on 12/9/2023.
12/9/2023. Now that new management is managing the trust. Since even though the opportunity has been given to that defendant, he has not produced any documents and examined his witnesses to give one more opportunity. I am of the opinion that the matter requires to be remitted back to the trial court for fresh consideration. Accordingly, the appeal is allowed. The order dated so and so to decide. The matter is remitted back to the trial court. Get direction to reconsider that matter. Of
No,
course,
from the stage of open from the stage of defendant's evidence anteli. Otherwise, he would file unnecessarily protract the proceedings. 15ನೇ ಇಸ್ವಿ matter.
no, but permitted. Yes,
from
from the stage.
of
Remanded the
defendant's
matter with a direction to continue that matter from the stage.
Opportunity.
ನೀವು ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಆಗಿದ್ರೆ ಎಲ್ಲ ಪಾಯಿಂಟ್ ಅನ್ನು ಕವರ್ ಮಾಡಲಿಲ್ಲ ಅವರು.
From the stage.
No. This is too much, my lord. This is
Yes,
wrong.
from the stage. Yes, from the stage of evidence of defendant.
Please.
ಏನಾಗುತ್ತೆ
And
ಅಲ್ಲಿ
the parties is also permitted to produce additional documents. That trial court is directed to consider that parties are permitted to file an application for production of additional documents. Trial court is directed to consider the same in accordance with law. And it's also made clear that the committee already constituted as per that judgment and degree dated so and so will be continued, is subject to the result of the suit. They are continued and they continued and managing that verdict. That committee, constitution of the committee is subject to the result of the suit. It is also made clear that the defendant number 2 and 3 are directed to furnish that account to the court within how many days? 3 months.
3 months.
Within 3 months from the date from today.
Point number 1 died.
2 and 3
You have to collect the records from his.
ಅದೇ ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮಗೆ ಅಲ್ಲಿ?
3 months ಬೇಕಾಗುತ್ತೆ.
Yes, 3 months from today or from the date of register of the copies. 3 months from the date of register of the
Opportunity ನನಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಅವರ ಎವಿಡೆನ್ಸ್ ಅನ್ನು ಫೋಟೋಗ್ರಾಫರ್ ನಾವು ವಿ ಹ್ಯಾವ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್.
That cannot be relayed because
ಇನ್ನೊಂದು
all technical
ಈ ಡಾಕ್ಯುಮೆಂಟ್ಗಳನ್ನು ಅವ್ರಿಗೆ ಹಾಜರು
ನೀವು ಅವ್ರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಕೌಂಟರ್ ಮಾಡೋದಕ್ಕೆ ನಿಮಗೊಂದು ಅಪರ್ಚುನಿಟಿ ಅಷ್ಟೇ. ನೀವು yes.
ಅದರ್ವೈಸ್ ನಾಳೆ ದಿವಸ ನಮಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಪರ್ಚುನಿಟಿ ಇಲ್ಲ.
Permission of the defendant to adduce that evidence subject to they are submitting the accounts. They are not complied that directions. Trial court can pass an degree in accordance with the evidence of the defendant has taken nil. Yes.
I request that exemplary cost may be awarded. ನಮ್ಮವರಿಗೆ ಬಡವರು ತುಂಬಾ ತೊಂದರೆ ಪಟ್ಟಿದ್ದಾರೆ. ಕಾಸ್ಟ್ ಕೊಡಬೇಕು. exemplary cost.
Cost will be paid to that Gardi.
ಹೌದು ಕೊಡ್ಲಿ ಸಾಕು
ದಯವಿಟ್ಟು
ಸಾಕು ನಮ್ಗೆ ಅಷ್ಟೇ ಬೇಕು. ಅಷ್ಟೇ
ಕ್ರಾಸ್
ಬೇಕು.
ಎಕ್ಸಾಮಿನೇಷನ್ ಕಾಸ್ಟ್
ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಲ್ಲ?
ಮಾಡಿದ್ದಾರೆ. I strongly oppose this.
That can,
I
that
strongly oppose this.
cross examination.
Yes.
On the other hand, they want cost.
As and also
That's kindly provide one opportunity to cross examine the PW1.
see opportunity you have lost is not examine your witnesses.
ನಾನು ಅದನ್ನು
You have cross examined that witness.
ಪೇಜ್ ಅಲ್ಲಿ
That is your lawyers left to the lawyer.
ಅದಕ್ಕೆ ಅವ್ರು ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ.
Yes.
ಇನ್ನು ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ.
Yes. And also
ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ ಬೇರೆ
cost of rupees 15,000.
ದಯವಿಟ್ಟು ಅದೊಂದು ಬೇಡ ಯಾಕಂದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು ಬಿಡಿ
ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಏನು ಆಗ್ಲಿಲ್ಲ. 15,000
ಆಯ್ತು ಬಿಡಿ ಆಯ್ತು.
ಆಪರ್ಚುನಿಟಿ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
May I request certain time limit ಒಳಗೆ ನಿಕಾಲಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆಯದು ಅಂತ ಕಾಣಿಸ್ತದೆ. Time frame.
That parties are directed to be present before the trial court on 20th March without any further notice. Trial court is directed to dispose of this suit 6 months from date of appearance of the parties.
Much obliged.
ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ 3 ತಿಂಗಳು ಅವ್ರಿಗೆ ಇರ್ಬೇಕು, ಆಮೇಲೆ 3 ತಿಂಗಳಲ್ಲಿ ಸರ್ವಿಸ್.
Much obliged.
All pending applications are disposed of.
Please.
Number 1. Yes, Harish Kumar. The matter was posted before the register for non-compliance of office objection. Four times office objection were not complied. It's the matter was posted before the court on 31/7/2023. The day week time was granted to comply that office objection. Again, the matter was posted on 5/10/2023. 2 weeks time was granted for compliance of office objection. Again, on 13/2/2024, matter was posted before the court for 7th time for compliance of the office objection. When the matter is called in both sessions, none appear for the appellant. Office objection is not compliant. Directed the registry to post this matter on 14/2/2024 at the top of the list under the caption for dismissal. Even today, when the matter is called twice, none appear for the appellant. It appears that appellant is not interested in prosecuting the case. It's dismissed for non-prosecution.
Number 2, Channabasappa SM for appellant.
The matter was posted before that register for non-compliance of the office objection 3 times. None appear for the appellant. Office objection were not compliant. If the matter was posted before the court on 31/7/2023, that day 3 weeks time was granted to comply that office objection. Again, the matter was posted on 5/2/2024. None appear for the appellant. Finally, weeks time was granted to comply that office objection. Again, the matter was posted on 13/2/2024. Matter was called. None appear for the appellant. The office objection is not compliant. It's directed to post this matter today at the top of the list under the caption for dismissal. But today, when the matter is called, appear for the appellant. Yes, it appears not interested in prosecuting, dismissed for the fund.
4, give executive for appellant.
Matter is called twice. None appear for the appellant. To give one more opportunity with this matter. Dismissal. Instead of granting an 3 times to comply office objection. Office objection is not complied. No representation on behalf of the appellant. Even today, matter is posted. Hence, office is directed to post this matter on 14/2/2024 under the caption for dismissal. Even today, when the matter is called twice, none appear for the appellant. But today, matter is posted for dismissal. Dismissal. In spite of matter was called twice, none appear for the appellant. Appears that not interested in prosecuting and dismissal.
Number 5, CS Varakana.
None appears. 2 weeks to comply office objection.
Number 10, Naveen JN.
Yes, finally 2 weeks.
Number 12, yes.
Finally, none appears. None appears. None appears. Finally 2 weeks.
Number 14, Kumar L.
Yes, none appears. Finally 2 weeks.
Number 19, Deepak V.
None appears. Finally 2 weeks.